Good morning, good morning, good morning, Law Nerd. It is Thursday, August 29th. We are gathered here together today to go to court in Idaho for the prosecution of Idaho versus Bryan Kohberger. He has been accused of murdering four young adults that were going to the University of Idaho in their off-campus home. The defense today is arguing that because of the extensive and persistent media attention in this case and the press conferences given by law enforcement and the prosecution, that the county where this happened is not I've got an echo. Is the county where this happened is not the proper venue for this case. So there is an argument here that venue is the issue. We saw a bit of this in the motions where the prosecution was trying to stop the surveys, and the prosecution's like, whoa. The defense is talking like to jurors. You can't have them do that. And the defense was like, we have to interview people in the county to see if their feelings about this case have been impacted such that they cannot keep an open mind and they cannot hold on to the presumption of innocence. And even if they go into court and are like, yeah, I can be fair. Can they really though? If they have so much information about the case, if they already think that this defendant is guilty, should they be the jury? Can they be a fair jury? And does it violate the defendant's rights to have a jury that is not impartial from the jump before jury selection even starts? This might be a bit of a premature motion. A lot of times these motions aren't brought until you start picking a jury. But because this is a 3 to 4 month trial, delaying it till then could put the case over another 6 months plus to get another courtroom that can accommodate a trial that long. The defense really seems to want to push this to Ada County. And that is where Boise sits in Idaho, out of Latah County, which is a much smaller county, much smaller per population, and much closer to this prosecution. And the individuals there were on pins and needles while a manhunt was going on for almost a month before Kohberger was arrested. That impacts people and how they feel about a case because they're going to remember viscerally that thing that happened. That's like a traumatic community experience that they're all going to remember. Like, where were you when this thing happened? So we are looking at their motion for change of venue today. I think that Judge, and for those of you new in this case, yes, the judge's name is John C. Judge. I think Judge is going to punt. I think he's going to take this under submission. I don't think we will get a resolution today. I'm optimistic we will get through all the defense witnesses today. We've already seen some of these witnesses because the witnesses had to come in to argue with the court to allow them to continue their work. This process got cut off in the middle, because the prosecution was like, excuse me, some of these questions seem really prejudicial. So Your Honor, stop it. The prosecution here is arguing, yes, there is pervasive media attention, but everywhere in Idaho knows about this case. So why move it? And arguing that it is very inconvenient to move this from Latah County to Boise, where Ada County is. It would be tremendously expensive for Latah County to move everyone to another county hundreds of miles away to do this trial. We're going to see those arguments today in cross-examination of the witnesses and in arguments from the prosecution and defense. Will this finish today? I don't know if this will finish today. Do I think the judge will rule today? No, I do not. Do I think at some point the judge will be like, I have to ask questions, I'm so curious? Absolutely he will. Absolutely he will. If we know anything about John Judge, he's like, tell me more about that. And it's like, Your Honor, can we move forward, please? He's like, tell me more. I want to know everything. And he is a very active participant in the process, sometimes seemingly for the sake of process. But we will see what happens today. This prosecution is set to go to trial in the summer of 2025. So it's really set to start when school is out. And that is what we are doing today. So we are going to be tuning in. We have solved the problems of getting the, not of our echo at the beginning, but we have solved the problems of getting cut off when this hearing ends. So thank you to the Law Nerd team at Team Baker. Thank you, Megalina, for handling that so that if we pause and talk about this, if we zoom, because there will probably be a lunch break, that when court ends, we're not going to sit here going, oh, where to go? We learned once the hard way, never again. So we're going to go to court. I'm going to roll the intro. Law nerds, it's great to be in court with you. More pretrial motions, ladies and gentlemen of the chat. Theys, gays, ladies, gents, those who identify as pumpkin spice girlies, all of you. It's good to see you. We are going to just take a look at what's fair here. Even if you don't agree with what the defense is asking, just try to be like, I don't know if I agree. I don't know if this should be moved. It's inconvenient for the victim's family. It's inconvenient for the witnesses. It's inconvenient for everyone. But are the defense attorneys making good points? And this is a death penalty case. A fair trial for the defendant is critical. There will be so many appeals if this defendant is convicted. So if this defendant is convicted, appeals for decades. We're still seeing it in like the Scott Peterson case, 20 years plus, and there are still appeals. That does not let the victims' families, friends, and community rest. So having a prosecution that is more difficult to appeal based on early decisions gives all of the participants, the victims, those impacted by this case, hopefully a little bit more room to rest when it comes to appeals. There is need for that. So even if it's like, this is frustrating, I don't know if I want this to move, I want this defendant and all defendants to have a fair trial. So if there are appeals, those appeals are on real issues that are real problems, and not because the judge was like, I don't think this is a problem. It can be a problem. Pretrial publicity can absolutely be a problem. That's just real. So let's go to court, shall we? We are going to, we're going to roll the intro and we're going to go to court. Law nerds, let's ride. I'm going to gavel again because I love it. Things we probably won't get to hear today. Oh, wait, no, we might today. We might. I'm putting that on my bingo card for today. We might get a mention of the FBI. We'll see.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, let's roll. Court is getting started. We are on a little bit of a delay so that we can do my favorite thing, which is zoom through the shit that we don't need. It's very important to me to be able to zoom through the things that are not helpful to us. Judge is not on the bench yet, but I appreciate that in the Zoom call, it says right there at the bottom, Judge John Judge. It's great. So I'm waiting for them to call to order, but we're going to wait for the judge to come on the bench before we call to order or get on the bench. Get on the bench, Your Honor. Get in the car, Elizabeth. Get on the bench, John.
2922-2805.
There we go. We are now called to order.
Is in the courtroom.
Time to get the notebook.
He is represented by Ms. Taylor, Mr. Lawson.
I've got backup snacks. I've got water. We're going to be here all day.
The state is represented by Mr. Thompson.
I guarantee you, Prosecutor Santa's going to be pissed off by things today. He's going to get big mad.
Ms. Beatty and Mr. Nye.
You guys are like, why is Santa going to get big mad?
Motion to change
some of this has to do with things he said.
To Ada County, filed by the defense. Preliminary. Anything, Mr. Thompson?
In Your Honor, not from the state.
He's like, let's roll.
Ms. Taylor?
Let's roll.
Your Honor, just that there is a stipulation that the court received the exhibits that were filed along with our declaration and our memorandum in support. That's correct, Your Honor.
All right. So we're talking about
Carol,
all those slides. there were like 100 slides.
There were 100 slides, Your Honor. We're talking about those,
This
but
will
in
be the
particular,
feed at
the
trial.
references to all of the media coverage, the articles that were contained, the table with the links to all of the articles that depict all of the media coverage.
Remember, Idaho
So
kicked out
are you going to show
pool
those
cameras and went to
publicly,
Zoom
or
only.
those are for me because I'm the one who has to make the decision?
Those are for you. Yeah,
Oh, okay.
We'll have PowerPoint presentations today, but we will not be going through the hundreds of articles that have been provided for the court's consideration.
You know,
Well,
on
I'm
Zoom, Ann Taylor
thankful
looks
for that,
so much like Shannon Bedore. It
because I
is
did look
wild.
through all that, and I thought, oh, this would be not a good thing
Attorney
to
Taylor, how do you feel about John's
push out
engagement to
to the
Alexis?
public, because we're trying to
I
protect
need
that,
to know.
right?
Your Honor, we are, and I think it would take an extraordinary amount of court time to try to read through all of the articles or review all of the bits of news coverage that have happened in this case.
There's
We do
not a
intend to
chance.
offer a little bit of a preview throughout our testimony, but certainly not the hundreds of articles and news stories that have existed.
Well, that was my other concern. So, all right. Well, call your first witness.
Kimberly, I'm
Your
going to
Honor,
hold
Ms.
on to your
Massey,
question
we'll
until we
start.
have a
Okay.
moment. It's a good question asking about why
Mathis,
we're choosing to change
thank
and
you.
where we're
Good morning,
choosing to
Your Honor.
change.
Good morning.
Your Honor, as we get started here today, what I'd like to do is provide you with a roadmap of where we're going with our witnesses. The standard here is whether there's a reasonable likelihood.
For everyone, lawyer adjacent, just running a meeting at work, whatever. I love it when you set an agenda. Hey, remember, this is what we're doing here today. This is what the standard is. This is what we need you to pay attention to these witnesses for. Love it, love it, love it. Like, we're called to order. And she's like, I got you, Your Honor. This is what we're doing. This is what we expect it to show. A roadmap is so helpful. We've got a veritable road so far, though the judge is well aware of this case, and I appreciate it. It is a great thing that not a lot of lawyers do with the judges.
That pretrial publicity has affected the impartiality of prospective jurors.
That's the standard.
To establish the quantity of pretrial publicity, we will call James Todd Murphy with TrueScope.
James Brown?
To establish effect on partiality, we will call Dr. El-Alayli to discuss the social science behind juror decision-making. Then we will call Dr. Bryan Edelman about the survey and what it means.
He was great.
And finally, we will call Dr. Dahir about the validity of the survey methodology.
Dr. Dahir is going on the list of the greatest names. I did a poll on Tuesday. Dr. Dahir is getting added to the list. Dr. Dahir is getting added immediately to the list of great names.
We are not calling today Scott Sunby, but as you listen to testimony today, please keep his sworn affidavit in mind. With his 39 years of studying capital juries and teaching at the National Judicial College, he is considered by the United States Supreme Court an expert in this area.
The Supreme
He
Court
has
likes him, so
published
should you.
this book. It's called A Life and Death Decision, A Jury Weighs the Death Penalty.
A lawyer
And this
after
book
my own heart.
is a culmination
We got
of
the exhibit, Your Honor.
interviews of over 1,200 capital jurors and how capital juries make
I
decisions.
actually might get that book.
Research shows that when a small community creates pressure to impose death, an Eighth Amendment violation may occur. Through these witnesses today, we want to avoid beginning a trial with, as Mr. Sunby states, quote, a thumb on death's side of the scale, end quote. And with that, I call James Todd Murphy.
It's a good quote.
Thank you.
We don't want the jury to come in with a thumb on the side of the death penalty because they already think he's guilty. They've already bought into pretrial publicity. They've already made up their minds, and they can't be impartial. That is not what anyone wants.
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do. All right. Thank you, sir. Please have a seat there. And once you're seated, please state your name and spell your last.
The reason the defense is going is because it's their motion. These are their witnesses.
I go by Todd, my middle name. Last name is M-U-R-P-H-Y. All right. Sir, James Jackson.
Mr. Murphy, how are you employed?
I'm the president of TrueScope.
Gainfully.
That's spelled TRUESCOPE. It's one word.
And can you explain what TrueScope is?
Sure. TrueScope is a media monitoring and analysis service. We wrap our arms around all the media types.
We'd like you to wrap your arms really tightly around Sinclair. Can you explain to them what copyright is, sir? If you're monitoring the media, we have some requests. Can we put in requests?
Out there, you can do it on a global level or a geographically isolated level. Normalize all that data from television, radio, newspapers, magazines, social media, online sources. Index that with metadata so we know date, time,
AK,
placement.
congratulations.
We assign sentiment metrics
Thank
to
you
it.
for updating us.
And from that, we can extract data sets for what our clients need, specific to topics or phrases.
Media plus science.
Can you explain how you track this media intelligence that you just described?
Sure. So we have feeds that are coming in. For example, we acquire a feed from X, formerly Twitter. We have an online feed that accesses all available online sources. We have a broadcast feed of TV, radio, and podcasts. All those feeds come into us as they're broadcasted, as they're posted, as they air or are printed. We don't do any modification of the text or the context. We just take it as it was provided
Do
by
you scrape
the
YouTube
content
videos
owner.
for all of their
Index store, and then
transcripts
when
and
queries
index
against
them? I've got questions.
Where did you travel from to be with us here today?
Our North America headquarters are in Omaha, Nebraska, where I live.
Would you tell the court about your background in media intelligence?
Sure. Might sound cliche, but I was born into the business. My father acquired a press clipping service called Universal Press Clipping Bureau in 1959.
Interesting legacy.
Eventually met my
career.
mother. Without further detail, eventually I became in existence. That's a technical phrase, I'm not sure. So working alongside my father growing up was just part of the DNA. I studied psychology and communications in college, and when I graduated, the internet was beginning to become a thing. And so I saw a future of data mining and expanding what was a press clipping service into the future.
So, mining the internet.
So my full-time employment with Universal at the time started in 1991 and came to today.
Beyond your 30 years of experience that you've described in your educational background, do you have other qualifications in this area?
How many large data language learning models are you using in your business?
In the mid-90s,
currently?
I developed a framework for comparative media analysis where we could take those data sets and compare. My first project was letting hospitals compare themselves to others to see how one brand of a hospital might compare to another within a community or market. I also invented the first multi-channel media monitoring software that would let us monitor multiple TV channels on one computer and write the closed captioning text to a database simultaneously.
So yes.
Innovations not quite as exciting as those continued throughout the years. I also made other acquisitions, which I then folded into Universal, buying up other monitoring services in Alaska or Wisconsin or wherever. Eventually, merged my company with TrueScope.
Do you need me to stop? Do you need me to
TrueScope, a
go?
technology company out of Australia.
I feel that.
TrueScope owns Universal Information Services at this point, and we're adding AI and other natural language processing to what we do. The tech.
What about organizations? Are you part of any organizations in this field?
I am. There's a global organization of all media intelligence services called FIBEP. That's spelled F-I-B as in boy, E-P as in Paul. Every continent except the uninhabited ones have many, often multiple media intelligence or media monitoring services. They belong, or most belong to this organization.
That was my phone, not yours,
My
by
peers
the way.
in this organization.
My team has texted me.
To lead this organization at a global level last year. I'm currently the president of FIBEP.
And have you ever testified related to your expertise before?
I have been asked to do that. Yes.
How many
Before
times?
you start talking about the data in this case,
surprised she didn't
how
ask.
closely have you followed this case on a factual level?
I kind of have a personal standard operating procedure that when a client engages us on a topic that I feel for our company may become contentious or may have downstream effects where I might be called to objectively testify, I purposely removed myself from evaluating the content of the data set related to the subjects they're asking us to monitor. So while I have made myself familiar with the search strategy, the keywords, the phrases, which would include the defendant's name and the family names of the students that are victims, I have done very little. I paid very little attention to the media exposure on this. In fact, I just learned that the judge of this case has a last name that sounds like he was born for this role. That was last night. I didn't know who the judge was. For coincidence. My apologies.
Sir, don't try to charm the judge. In fact, it was just last night that I learned that Judge's name was in fact Judge. The judge is so chuffed by it too. He's just like, tell me more about me.
Apologies for not knowing who you were until last night. Thank you.
Are you familiar with Ms. Saucier who testified last year in this case?
Yes, Jean Saucier is my right-hand person.
Judge,
She's a
he's
senior
thrilled.
vice president of client success. She has a media measurement background that started years before she came to be under my employment. I would venture to say she's as much of an expert in this area as I am. And if she was actually here, I'd probably say she's more of an expert, but since she's not, I'll tell you that for myself.
So for context purposes, when she testified about data in TrueScope, is it the same set of data that you've just testified to?
Exact same data. We work at the same company. We have access to
Who testified at the last
exact
hearing?
tools. She works with clients directly as yourself.
Her PowerPoint was not fun to look at.
How is TrueScope using media intelligence in this case?
I'll say it maybe functionally. We have been asked by you, our client, to track specific topics related to this case, names associated, and I might say the more unique a phrase is, the more accurate our media monitoring can be.
The defense set the data set that you were looking at?
John Smith and Susan Jones. Then we have to do much more Boolean logic, apply more Boolean logic to make sure that we're focused on extracting it's very specific. So for you, we've built a search query using Boolean logic and AI to focus on the stories that are of interest in this case. The second half of what we're doing, so that's the media monitoring. We first capture the data. That creates a data set. Then that data set is analyzed by our analysis team, which is led by Cheryl Lewis, Dheril, Lewis, Lewis. And she has an assistant data analyst who they're trained in a way that we call cross-coder proficiency. So whether Cheryl analyzes a story or Perry, her assistant analyzes it, they analyze it in the same manner. That also creates a check and balance that if something in the media monitoring function picks up a story that matches the name Judge, but for some reason isn't the Judge associated with this case, the analyst then at a human level can say, that's the wrong Judge, and it would be removed from the data set at the analysis level.
What objectives is TrueScope trying to achieve in this case?
We've been primarily asked to look at the...
And asked by the defense, because the defense hired them.
What, without even being hyperbolic, would say an extreme amount of media coverage, its impact on a population or a community.
Stephanie said, am I the only one who thinks he looks like Seth Kinney?
Volume of that media exposure on various communities across the U.S., but focused on
volume of media, potential impact of media.
How long has TrueScope been gathering data for Mr. Kohberger's case?
I believe we were engaged on February 15th, 2023.
Well, they probably went back.
We have
in
some
time.
ability to pull some data forward from that time, but that's when technically the engagement came.
And you've talked about the media types
exists
and the data
the
that's
internet's
gathered.
forever.
Is area or location of media coverage able to be determined?
Yes, in most cases, maybe I'll separate that into two areas of media. You have traditional media, which would be television, radio, newspapers, magazines, even online news sources. Those are all tied to a specific city and state. You have the Moscow Daily News, and the metadata that we have attached to that source would say, okay, that publication name is in the city of Moscow, in the state of Idaho, and has a circulation figure of, I'll say, hypothetically 3,000 readers. I don't know the exact circulation of that specific paper. For television, each television news affiliate, local news comes from what's called a local news affiliate. It may be the ABC affiliate, but it may have call letters such as KXLY, I think is one of the Spokane channels.
Yes, we know.
And they may be an NBC or an ABC affiliate, but they're the local affiliates who's in charge of airing local news. And
we're still in a traditional
media
media,
data,
folks.
Nielsen services. You may have
We
heard
haven't gotten to
Nielsen
new media. We'll see what he
boxes
calls
and
it.
market ranks and things like that.
Sir, the judge
They know
knows
that that
media
station
is.
is in this city, in this state, and each affiliate is part of a DMA, a designated market area. Stop me if I'm going too far down the rabbit hole. But
Yes,
a designated market area,
You've read
although
that
the news
correctly.
may come out of Spokane, Washington, the designated market area.
Is this needed for this motion? No. Is Judge interested? Yes. Is it going to continue because Judge is interested? Yes. Judge strikes me as a tremendously curious human, and he's like, ooh, tell me more. So, no, we don't need the deep dive for this motion. Judge just wants to know.
Is a radius around that can take in additional cities, counties, and at the
So
functional
this is like the
level,
structure of
consumers of
how
news, viewers,
media
in this sense.
conglomerates are broken
Is
down.
frequency of media coverage able to be determined?
Yeah, we since on television, newspapers, online, demographics
He didn't go
can
back to
change
new
over
media, I
time and
suppose.
change by day. So a good example of frequency, why frequency matters. A local news affiliate might have a 6 to 7 a.m. newscast, a midday newscast, a 5 p.m. and a 10 p.m. Depending on what time zone you're in, those can be adjusted based on network. But let's say that they ran a story about anything. They might run it in the morning where the demographics skew one way. They might run it at midday, which might have a much smaller audience or potential viewership. They might run it at 5 o'clock, which would have people who come home from work early or those who are unemployed. And then at 10 o'clock generally can be the largest audience. So knowing what time they run it lets us know the demographics, the audience, and even a vanity metric called ad values. We won't get into that, but what time a story airs and how many times it runs, we aggregate that and we can say, okay, this story ran 4 times on this channel on one day and had a total viewership potential of, say, 50,000. That doesn't mean I watched it at all 4 times. That just means the viewership at each of those times has the potential to see it. And that's where frequency comes into play.
So the potential.
Are there
to
types
see
of
it-
media coverage that TrueScope does not gather?
We don't track anything that's illegal. We don't go behind. We don't penetrate privacy rules, such as your personal Facebook pages if they're marked private. We also don't look at streaming entertainment channels such as Peacock, Hulu, where the content on those channels often is broadcast originally in a specific time zone. We call that an ephemeral broadcast, where it aired at 5 o'clock and then was lost to the ether. But Hulu and those streaming channels give the opportunity for that story then to be posted, and you can watch it at your leisure in a time shifting. We don't monitor those adjacent streaming channels, because they're subscription based, demographics are different, and we already have the content as it was aired originally.
I'm going to hand you what's been stipulated and admitted as a part.
He skipped social media entirely. He skipped everyone that gets their news from social, and not from social clipped down, because if it's clipped down from like ABC, today I shared a clip when I was on Nightline that would have originally aired on television. Traditionally, it would then be clipped down on social media by ABC. It would then be shared on ABC's YouTube channel. That's not what he's talking about, because it's encompassed in the ABC airing. He is talking about things that air originally on terrestrial television, things on radio and in newspapers, and that's it. But it's leaving a massive gap, because a lot of people get their news from shorts, either on YouTube, TikTok, or Instagram, but in vertical 1 to 3 minute segments from non-traditional media outlets, like a Phil DeFranco, like an Under the Desk News, where you're following that creator and getting the news from them. And then that's not on television traditionally. I mean, you put it on your TV, but it's not on television traditionally. It's not broadcast that way. It's broadcast through social media. So if you're skipping social media as a broadcast source, you're only accommodating a different demographic. That's odd to me.
Of Exhibit C. I've shown
Real
the
odd
state,
to
Your
me.
Honor.
Thank you.
I'm interested to see if that comes up in cross-examination.
Can you tell the court what that is?
That is a very base level spreadsheet of all the media exposure, just to get some of the topics specific to this account that you've engaged us for, including the topics that you've specified we monitor for your account. It includes various things like the type of media, so it might be Twitter or print or broadcast.
If you're skewing to only Twitter and not the
It
other
would
socials,
include
it's going to
the metadata we include,
skew your numbers.
city, state, circulation, viewership, things like that. There's also hyperlinks. As a client of ours, you would receive, if you exported this from your workspace or we exported it for you, you would have a hyperlink. You would click on that. Because we have a cookie on your computer, it would open that hyperlink and you could see the full story. Unless it's an online story or a social media story, then we take you directly to that end source. So if it's MoscowDailyNews.com and it's in front of their paywall, you would click on that link and you can view that story.
And he's
yourself.
also not covering stuff behind
Is
paywalls.
Exhibit C in front of you specific to Latah County?
Yes, I see under county, spot checking it and spinning through where it can be determined. These are all Latah County.
A lot of these reports are not
related.
public. Some of them are
cities
for
within
the
Latah
filing
County.
from the defense.
Is the list
But this one is,
of
I don't think this one is.
Exhibit C approximately 1,360 entries long?
1,300 entries. So it's a summary of their
Yes, I can
volume
confirm
of media coverage.
The number of rows, which each row would indicate a individual media mention, or also known as a media story, an article or a news story on a broadcast.
And Your Honor, I won't have him hand that to you now, but for purposes of the record, that will be a paper copy for the court's file. You have that in an Excel spreadsheet that's much easier to read than what is in that paper in there.
Right. Okay. So this was agreed by state too. So I just want to make sure, because I have the exhibit C also that was attached to your brief.
which is
which is 300 pages.
Oh,
So,
it is
but
attached to the
then we
brief.
have the additional C, which is more, I guess,
I'm pulling up the
thorough.
brief
so
now.
this is a part
I'll link-
of C related to TrueScope.
The brief is 319 pages long. I will link the brief in the description of the video in case you are interested in the brief.
Which is this list of the 1,300 stories. And then I'm about to get into the other part
I'm
of
looking for the
Exhibit C,
chart.
which is TrueScope's report.
Okay. Okay, great. Thank you. Just wanted to clear that up.
Did you prepare some other documents that represent media coverage in 4 counties in Idaho for this case?
We did. Once TrueScope had, and it's an ongoing thing. We're constantly monitoring your news. So even this morning,
News
you
is
would have
dynamic.
received a report of any media exposure that has happened since yesterday morning. It runs on a 24-hour cycle where we pushed out a report to the clients, but we're collecting it in real time. So if a client wanted to look at their workspace at 3 p.m. today, all that news would be in there.
That's
I may have
the beginning of
digressed
their
from your
chart.
question.
No, this is their
That's coming in
PowerPoint.
handy exhibit.
Okay.
This is the second part of C. And I'm going to put that in front of you because it might be easier to see. You've got 2 screens.
Yes, that was the second part of my answer.
I'm going to try to keep the
We
closed
did prepare a
captioning from
media
covering too
measurement
much,
analysis,
but I want them
showing
visible
this
for
is
you guys.
food and
These
that's
are attached. We are
part of
linking
the
it if you need
combination
it
services
or want it.
that we're providing.
Okay, looking at this page here, can you please explain to the court what this is?
Sure. You have 2 pie charts.
Yes.
On the left, you have the volume of media coverage specific to the keywords and phrases searched for our client related to this case. You see on the left, out of all the media coverage between January 1st of 2023 and July 15th, 36% of that coverage, or just over 36%.
Here's my question about this as we're going through it. At the end, it says at the bottom where I'm covering it a little bit, it says media exposure in Latah County population 40,924 makes up a total of 36.13 of the media coverage in Idaho, or percent of the media coverage in Idaho. Latah County represents 2.75% of the population in Idaho. Of these 40,924 people, approximately 61%, or 24,963 people, are age eligible to serve on a jury. Here's the issue, though. Just because the media is coming out of Latah doesn't mean that others in Idaho aren't consuming media that comes out of Latah. You're gonna have to explain it to me.
That was seen or had the opportunity to be seen in Latah County. On the right side, you have another pie chart that shows the population of Idaho, and it shows what percentage Latah County represents of the total percentage of Idaho, which is 2.75%.
There's more people in the state of Idaho than in Latah County. Thank you, sir.
On the second bullet point of notes there's some reference to census. Can you explain that note?
Sure. The census data used for this was from, I believe, July of 23. Of the 40,924 people in Latah County, we were asked to look at age eligible to serve on jury duty amongst all of that, the people in the county, which equated to 61%, or just under 25,000 people of the nearly 41,000 all are age eligible to serve on the jury.
Right.
In Latah County.
Going to the next page. What does this page tell the court?
This is the same analysis framework performed on a different county. Again, on the left, you see the total media coverage in Idaho for the same date range, but 34% of the media coverage was seen in Ada County, which is just a couple percentage points below that of Latah County. The primary difference is the right-hand pie chart, which shows the population of Ada County relative to all of Idaho. And it's over a quarter of the state population, 78 or 26.42%.
What conclusions do you draw when you compare the two counties' data?
There's a lot more people in Ada County. And where I would be going with that as a media analysis, when I would interpret this from a media analysis perspective, is the propensity to dilute the media exposure in a larger population is a factual function of that. If you have a certain number of stories divided by the population, the number of stories a person can see is fewer if the population is larger. Did that answer your question, or was I?
I'll follow up with another specific one. Out of the two counties, where is the most opportunity for a
My text,
resident
not
to
yours.
view stories about this case?
It's by far in Ada County. When we did the analysis of the age eligible process, nearly 300,000 people in Ada County are jury age eligible.
I appreciate that he changed the colors of the graph so it's clear when he's looking at Ada County where Boise is versus Latah County where this happened.
Compared to just under 25,000 is Latah County.
I'm gonna just ask my question again. It was probably inartful on my part. Do more people in Latah County, is there more saturation in Latah County or more saturation with media coverage in Ada County?
Yes. A person in Latah County would be exposed to far more media coverage than people, a community in Ada County.
Can we now switch to the third slide? What does this show?
This adds in 2 additional counties that we were asked to look at. It reflects media exposure specific to Bannock and Camden counties.
And and then there's also a gray area, rest of Idaho. You just
How
want
are
to
you
explain what
really
we see
evaluating
here.
volume
Sure. So
with
if you
that?
look at the volume of media coverage for the same date range that the first 2, Latah, Ada, and then 4 counties we're looking at, out of all the media exposure for the state of Idaho, Latah received 36%, Ada had 27%, Bannock 1.56%, and Camden just over 3%.
I'm going to squeeze myself so we can read that better.
And the rest of Idaho had just under a third of the meetings. So outside those 4 counties, the rest of the counties in Idaho, or the rest of the people that
People in
the rest
Boise
of
can
the
read media
regions in Idaho
coming out of Latah, though, if they're
would have been
interested in the
exposed
case.
to approximately 31.5% of the media exposure.
You turn next to
So the volume is still fairly high in Ada. The thing is, the volume per percentage of population is what he's going to argue. Like, yes, the volume's high, but there's a lot more people, so it's easier to find people who aren't exposed because it's a larger county. Yes, I did restart it. They're not talking. I'm now confused. Talk. Where'd you all go?
explain what
There we go.
opportunities to be seen
The attorney was
are
buffering in
and the
real time.
differences in the counties.
Next
Sure.
slide.
So in this pie chart, again, we're looking at the same date range. Opportunities to be seen.
These are like impressions. What are the impressions? What is the theoretical opportunity for you to see it? So if the same news story ran 3 times during the day, then there's 3 opportunities for one person to see it, which is highly theoretical.
Are maybe best described relative to probability versus possibility. Each person in any of these 4 counties, or the rest of Idaho for that matter, have an equal possibility to see a story. It's like flipping a coin. You can flip a coin 100 times and the possibility of it coming up heads is equal every time. The probability of it coming up heads every time is much different. Probability is a mathematical statement, a quantitative measure. And so opportunities to be seen are dependent on the media type. So we measure opportunities to be seen for, say, newspapers based on their circulation. These are paid subscribers who you then infer pay to receive that news, they consume that news. Television has Nielsen audience figures. Nielsen measures those in smaller markets quarterly, in larger markets 6 times a year, I believe. Any of the broadcast markets we're talking.
How long until Nielsen starts measuring YouTube, by the way?
About, and the DMAs affecting this pie chart would be measured quarterly. So opportunities to be seen are the possibility that people in that county would see it. It's the volume of those opportunities that creates the potential opportunity.
Also, yes, I'm interested.
Probability that
when I was a poli-sci major back in my day, political statistics was my favorite. I loved running these kinds of models and graphs. I was
discrete
fascinated.
Articles, stories about this topic you're having us track. The numbers reflected on the pie chart show that over half of those opportunities to be seen reside within Latah County, nearly 60% or 57.03%.
I didn't know that.
The opportunities to be seen per person in Ada County is 31.2%. Not quite half, but nearly half the opportunities. And that's a simple mathematical function of all the media exposure in that county divided.
Please never assume that a mathematical equation is simple.
By the population, or in this case, potentially age eligible for jury population.
I mean, I get it. But
And in terms of the green sliver there, Canyon County is close to Ada. And so if we assume that Canyon County residents might review Ada County news with its population of 180,000, is the dilution of Latah County or the dilution of Canyon.
Here's what's frustrating to me is that it is ridiculous to me to think that those that might be interested in this story in Boise aren't looking for media coverage for it wherever that media coverage comes from, whether it comes from, Washington State or somewhere in Idaho or directly from Latah. When I'm covering a story sitting here in Tennessee, I look for the local media outlets first. I prefer local media coverage. So the amount of coverage on a story in Nashville is irrelevant to me because I'm looking for local coverage of the story if I'm interested in the story. So the opportunity to view it is part of this is going to depend. So they've got to find a way to show the judge, look, this much of the jury pool could be exposed to a high volume of media. And that's what they're trying to show. I just quibble with it because it's completely theoretical and the internet exists. It's not like somebody would have to drive to Latah 300 miles away from Boise to pick up a local newspaper. The world has changed quite a lot. So it's interesting, but they're trying to show the potential volume, like, oh, people in Latah are getting inundated by this every single day versus people in Canyon County who are apparently like, meh. I don't think that's actually true, but that's the argument that's going to happen.
Canyon County is still significantly greater than the saturation in Latah County.
If I understand the question correctly, how I may answer that is Canyon, and I would also say Bannock, unless you don't want me to mention Bannock, but the media exposure.
What did Bannock do to you?
Specific to those counties.
We don't talk about Bannock.
Statistically insignificant relative to the rest of Idaho, Latah County, Ada County. In fact, if you combined all those two and group them into.
I mean, it's interesting theoretically. I don't know if it helps in a modern analysis.
The inferences that we make on the data between Ada and Latah.
I want to know more about jurors that are seeking out this information
turn to the,
than not.
Next slide now.
But that's a voir dire question.
Tell the court which line represents which
readout.
county and the color.
Sure, the darker line, the red line is maybe the easier one to see. That's Ada County, and the darker line, it's a blue or might look black.
The first date that my face is covering is January
is Laytown County.
2023, then February, March, April.
And for Judge, for your purposes, this is C1 that was filed with the reply, which is an update from the original memorandum to include a more recent date, the date that we filed, August 19th, the reply. So I don't know what one you're looking at, but the one on your computer screen is the one that we're talking about right now.
Thank you to tell me that.
Could you explain, Mr. Murphy, what
the red and the blue, not the chart with
purpose
the
of showing
green.
this over time does for the court?
Yeah, one of the more interesting charts that we develop for our clients is media coverage over time. And in this case, we're looking at January 1st of 23 through August 19th of 24.
These are very reminiscent to me of the charts.
If you look at
of the charts in like a Depp v. Heard case, which I think is actually more helpful in that case because you're looking at defamation and the conversation on social media regarding a certain thing, and they can say, this is how much of this conversation is happening. It's different than trying to apply it to a jury pool because it shows impact and volume in that case. But this is similar, but still quite theoretical because you're trying to determine how many potential jurors potentially saw the news coverage and how much potential news coverage there was in a given area, given that the media landscape is like omnipresent.
the red line, which is Ada County, you can see that aside from May 2023, it often lags by volume of coverage behind Latah County. In most cases, by 50% or more of the media coverage. So if I rephrase that in maybe simpler terms, the media exposure in Ada County for the majority of time between January 2023 and August, continuing into August 2024, has been far less in Ada County than in Utah County.
And what can you tell from the spikes? Have you correlated those with case events?
Sure.
That I'm interested in.
It might be.
So they're asking about whether the spikes correlate to case events, and we're seeing a big spike in around April 2023 in Ada County, Boise, and then we're seeing a big spike in December 2023 in Latah County. Let's just, for a quick refresher before we go listen to him a little bit more, the arrest in this case was back in 2022. So they're only looking at things that happened in this case in 2023. So I imagine we're going to hear about different court events and different motions filed, because we also see a big spike of interest, or not interest, in coverage in Latah County in April 2024. I imagine those correlate with different court dates and different hearings, because that's when an interest spikes here too. So let's hear what they have to say. I'm interested which court events these correlate with.
Convenient to look at it analogous to maybe a stock portfolio. Oftentimes a peak is followed by a valley, unless you've invested.
Can you just tell us what happened?
But May 2023, you see 198 stories. I believe that highest peak for Ada County was the indictment is what's driving that peak. Now, when you compare that to Latah County, I can see that.
That doesn't make any sense that there's an indictment in April 2023, because he was arrested on December 30th, 2022 and charged on December 30th, Oh, no, it does make sense. This was after the grand jury, because it was going to go to preliminary hearing and it was leading up to preliminary hearing. And then all of a sudden they're like, boom, grand jury indictment. That does make sense. Okay, let's keep going.
Moving towards that indictment, there was ongoing media coverage. So while
that
Ada
was kind of
spiked,
surprising,
it had a quick uptick in what I would call a fairly slow decay because of the extreme nature of the topic of this story. When we look at Latah County, it is more consistent. And after the indictment, Latah County surpasses media coverage over time consistently up through August of this year.
And this was filed with the court on August 19th, and we're here on August 29th. Have you been able to review and see what's going on with the coverage regarding
Camilla, I see
this
your
case
question in the chat. It's a great
right
question.
now
I'm gonna
as we
hold
sit
it.
here?
Yeah, I took a look Tuesday. I started seeing the media exposure ticking up again.
Ahead of this.
It was fairly high yesterday. In my professional opinion,
There was a lot going on yesterday.
wager it's going to be extremely high today.
Mm-hmm.
And that's a function of
People are
public
interested when
interest
shit
in an
happens.
extreme news story. A story, you may have heard the phrase, this story has legs. A story that is extreme, unique, atypical, has greater legs than, say, high school football scores you hear on the 10 o'clock news on a Friday night. Those would
They
have a
put high
very
school football scores on the
fast
news.
decay
Still?
of memory on consuming viewers.
Emily, have you watched local news
This
in the
type of
last 4
story
years?
will remain on the
No.
mind and be of interest up to and beyond the conclusion of this case, however that might be.
Would you flip to the next slide? This green line, what does it show?
It shows somewhat of a similar pattern across the entire country. It's the same date range. It's also showing media coverage over time, but it's looking at all media exposure nationwide. So while you feel things very acutely locally, even a story as extreme as this garners less interest the further you get away from the local community.
Not
And to
necessarily true, sir.
look at this on a nationwide chart like this, you can see it remains
There's
in the mind,
interest
and these
here.
are large numbers. The indictment of over 13,268 or 13,268.
I will say for those of you that are like, bring me back after the data,
2023 shows that the nation
we'll
was
send a
interested
text
in it,
alert
but
when we switch
that
witnesses.
decay has been faster
I got you.
on a nationwide level, just because according to the decay of engagement on news stories, the further you get away, the less.
Decay of engagement is a very weird way to say it, but I kind of love the phrase. I'm gonna have to use that. I'm gonna be like, as my husband who can speak slowly at times, and I'm very spicy. I'm gonna be like, honey, we're experiencing a decay in engagement. I'm gonna need you to tell me what the point is first, and then tell me the other things, or literally there will be a decay in engagement.
I don't mean to sound callous, but the less interesting it is if you're in Florida than if you are in.
I appreciate that he acknowledged that.
So in terms of looking at decay, I want to ask this in the context of the story waning for the court's purposes of projecting, say, months down the line next year at trial. Based on the data that you're seeing, is this story waning in the news?
No. In fact, if we could make one more line on any of these media coverage over time charts, you would see an upslope on the first one, this chart. So you already see it ticking up when I compared Laytop to Ada. If we could bring that chart forward to today, you would see that going up. And that will be consistent anytime this case has significant news or a significant hearing in Laytop and Idaho County, it will be of interest. And I would say that the delta or the
For all of you
difference
that said
between
decay
Laytop and Idaho County will continue
in engagement,
to be
sounds like a great band
similar.
name. Agreed.
It will probably potentially always be of greater interest in Laytop County than in Idaho County. Not to diminish the interest in Idaho County, it's just, I believe it's further away than Laytop County from where the alleged crime.
I mean, the community's less invested, perhaps.
Is Nez Perce and Lewiston?
The media is going to follow the interest. So the media volume is going to follow the interest. So I understand what he's saying. The further you are away from the thing, the less interested you may be in general.
Are they a part of
we're
Laytop County's designated market area?
We're unique.
To my knowledge, yes.
What does that mean for Lewiston and Nez Perce to be a part of the designated market area they talk?
That's real simple. If the population, those are counties or cities?
Nez Perce is a county, Lewiston is a city.
Okay. So the population of those, I guess, could you rephrase the question?
What does it mean for those, for Nez Perce County and Lewiston City to be a part of the Latah County designated market area?
Okay, so that would increase the population of people that have opportunities to see the story within the same designated market area. So if you're in Latah County, you have the same potential to see the stories in Nez Perce and Lewiston. Does that change?
Part of what the defense is trying to show is how many jurors have been exposed to intense media coverage
those two
of this.
counties combined with Latah County would have to exceed the population of Ada County in order for this dynamic to change. I don't know how many people are exactly in each of those counties, but if together with Latah County, they exceed 295,000 potential jury eligible jurors, then you might be able to say the impact from the media on those two populations, exposure to media could be equal. But if Nez Perce and Lewiston are smaller counties and together with Latah are still significantly lower than Ada County, that's not going to change the determination I've made in this statement.
I have no further questions.
Thank you.
And that is the end of the direct examination for this expert?
Ms. Beatty,
Yes, Your Honor.
Thank you. Cross-examination.
Just briefly, Your Honor.
So we're on to the state's cross-examination. They are trying to show, they're building their motion like puzzle pieces. So they are trying to show the extreme volume of media coverage to show that the jury pool in their defense's argument is that the jury pool in Latah County is so helplessly tainted that there's nothing to do but move this trial. And the other thing they have to show is in another county or somewhere else in the state of Idaho, it's better. So if you say the entire state of Idaho is so deeply invested, then there's not much you can do. You can't move it out of the state. So then you have to voir dire vigorously and maybe expand the range to pull in a larger volume of jurors and find a jury that way. But if they can show, look, in Latah County, it's a small county, it's a small population, it is intensely inundated with this. That is different than it is in Boise, where people are like, oh, that thing happened over there. That was wild. But they don't have as many opinions about the case. They're not as deeply and nuanced invested. It's different. It's like if you are talking to your friend about the Corey Richins case and you're like, oh my God, did you hear about the Corey Richins preliminary hearing? And your friend's like, which one is that again? And you're like, oh, the children's book author. And they're like, oh, the who, what? And you're like, wait, no. Okay. So she wrote this letter about Walk the Dog and all of this. The person who knows all those details, very invested. Me. The person who's like, tell me more about this case is somebody who might have been exposed to it, might have heard it once or twice, but still could be a juror. They're like, yeah, I heard about the case, but like, I don't really know that much about it. That's why the defense is bringing up all of this information. All right, let's continue on. So you can be exposed to a case and have heard about a case and still be on the jury. The more intricate details you know, the harder it may be for some to keep an open mind because they're like, you can't unknow what you know. Like you can't unsee it.
Just for my own clarification, on those pie charts, when it says Latah County and Ada County, are you limiting that to the boundaries of the specific county, or are you talking about the broader designated market area?
When what we're looking at is media mentioned that impacted the county.
The county specifically.
Right. So.
Thank you, sir.
Yeah.
So in looking at those line graphs that you presented, I noticed that they started in January of 2023.
Correct.
So December of 2022, Mr. Kohberger was arrested. Were you able to make any determinations of media coverage in December of 2022 at the time Mr. Kohberger was arrested?
we were not engaged nor tracking the media.
Okay. And that's not possible to go back and track that.
We can do what's called a back search, but we can't. Certain media types have expired. Online news links, social media might have been taken down. So you can do it. I wouldn't say I would present it with confidence.
Why you don't look backwards?
I can show you a
saying.
number.
Thank you. So fair to say, though, that there probably would have been a pretty substantial spike at that time as well.
I would say yes.
And possibly, although you can't say for sure, that spike could have been even higher than any of the other spikes on this graph, possibly.
The possibility exists.
Thank you, sir. So for the first 6 months on this chart of volume of media coverage over time for Latah and Ada County had more intense media coverage in January, February, March, April, May, and then June, and then in July, there's that crossover where Latah County is higher than Ada County. So fair to say for that first 6 months, Ada County did have, at times, fairly significantly more media coverage than Latah County.
Correct.
Okay. And counsel talked with you about these peaks and how they correspond with specific events in the case, such as court hearings. She actually only asked about
one, though.
Would you expect that if the court were to make a decision to start closing certain hearings, particularly evidentiary hearings as we approach trial, that would be a mitigating factor that would decrease the amount of media coverage in this case?
I can't say yes or no on that. I would say it depends if those.
Ma'am, I do not like the direction that question is going. But sir, wouldn't this smooth out if we just started closing all the hearings? That's not a mitigation here. When the defense is advocating to close court, I get it. They need to protect their client. When the government is advocating to close court, I have issues and questions. No, ma'am. No, ma'am.
Closed meetings were a public record, then the media most likely that's following this would still have a high probability of
I think it would make it worse.
They may just not have any
accuracy,
image or interviews or some of the elements that go into.
If you close the hearings, there will still be a fuck ton of media reporting. It will just be fuckery and not facts. That is not helpful.
To a more engaging news.
So the coverage might be less intense.
No.
Intense is a qualification that I'm not able to make. I can't tell you how intense something impacts you as a viewer or a consumer.
Sure. Thank you.
Wrong use of word.
And I noticed in that chart of Latah County and Ada County coverage that in the last couple months, that coverage intensity in both of those counties has become pretty close again. Is that fair to say?
Yeah. Yes.
And so based on these charts, it's really not beyond the realm of possibility that Ada County could again surpass Latah County in coverage, at least at certain points, correct?
That's a fair point for her
again,
argument.
There's an equal chance of possibility. The probability based on the data, I would say is no, in my professional opinion. We've already seen an uptick, and it appears that
the defense wants to move it to Ada County. The prosecution doesn't. So the prosecution is like, but on this chart, we're seeing upticks in Ada County and Latah. So all things equal, if both counties are equal, then it generally would stay in Latah. Both things equal, we're not going to move everybody hundreds of miles away to another county. So that's why she's trying to point out, look, these spikes at Ada County show that there's a lot of interest there too.
In Ada County, the news is much more focused and attentive even to what I might consider a less weighted story. I think there was a story recently about a memorial garden or something that this county garnered quite a bit of media exposure. But that's logical.
Sure. Well, in June of 2024, it looks like they got so close that they were just 2 points apart. Is that correct? Latah County just 2 points above?
Yeah.
And you're not willing to testify that there's a possibility that Ada County could potentially surpass Latah County in the future?
That's not what he was asked to do.
I'll absolutely guarantee that. possibilities are always equally available.
Thank you, sir. I have no further questions.
Okay, thank you, Ms. Beatty. Ms. Mathis?
This is redirect.
Mr. Murphy, in terms of this discussion on Ada versus Layton, you mentioned the Nielsen rankings. Could you please tell the court the difference between what the Nielsen ranking is?
Seems outside the scope.
And then I'll follow up with what Layton's is, and what Ada County's is. So what's a Nielsen ranking?
Sure. So I don't want to assume that most people have heard of the Nielsen ratings, but anyone who's involved with selling advertising or the news media knows that Nielsen for more than 50 years has measured the top 200 designated market areas. New York City is number one. It's the largest DMA. The media in that market reaches the most people. And so it's a measure of how many active news consumers, is the way I would describe it, are in a city or a city's area. I know we're looking at counties, but your designated market area here in Layton County fall under the radius, I think I mentioned earlier, Spokane, Washington.
Right, because they're not big enough to be their
Ada
own
County,
market area.
Their designated market area is Boise, Idaho.
Because Boise's bigger.
A different deal.
And what's the Nielsen ranking of Layton County?
It's ranked 64 out of 210.
And what is Boise?
97.
I have nothing. So I should follow up and say, in terms of how that's measured, 64 mean that is a higher rank than Boise at 97.
The DMA in which Layton County resides has far more opportunities for media stories to be seen based on the strength of the DMA. As you get down to the smaller DMAs, for example, Glendive, Montana, has historically been market 210 last. They have one CBS affiliate. There's just not a lot of news coming out of us. An area, a DMA like Glendive. But on the two counties you're talking about, they reside in a DMA that's 64 for Layton County. A larger DMA is going to have more media opportunities to be seen and more media outlets available. As you get to smaller markets, you have fewer and fewer media outlets serving there.
Nothing further. Thank you.
Thank you. Ms. Beatty?
Nothing from the state, Your Honor. Thank you.
Okay.
All right.
Ms. Witness be excused.
He can, Your Honor, and the exhibits that are with
And that's the
him
first
can go
witness?
through you for the court's paper file for the record.
Thank you. Okay, sir, you're free to leave or you're free to stay. Thank you. Appreciate it. You being here. Thank you.
All right.
Thank you.
Exhibitees. There's a sampling of those in the defense's motion. Not all of that is in the defense's motion. So let's see who the next witness is, shall we? Your Honor.
They're very small letters.
Me?
I agree, Your Honor. It was
All
really
the
hard to
time.
get them on one page. Sorry about that.
Thank you.
Your Honor's like, excuse me, your font and my reading glasses are fighting.
Why don't we take a quick break and then maybe come back at 10:20. Okay?
All right.
Thank you.
What we're not going to do is that. So give me just one moment. We're going to zoom past this court break. I am going to zoom us past court break and get us back to them being on the record. I love being able to zoom because
All rise.
it's going to be a long day.
Seated.
If we can make a long day shorter, I'm here for it.
Hey, let's get that on the record, please.
So we are back after the break.
Back on the record, State versus Kohberger, CR 2922-2805. Sorry for the delay. I think we had to adjust some mics.
So it
make
was a
sure
longer break
everybody
than he
can hear.
expected.
And
Great.
counsel and Mr. Kohberger are here in the courtroom, so we're ready to go forward.
Let's go.
Next witness.
Witness 2
Thank
for the
you, Your
defense.
Honor. We will call Dr. Amani El-Alayli.
All right, thank you.
All
Thank you, ma'am.
right.
Please raise your right hand.
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, thank you. Please have a seat and then please state your name and spell your name.
My name is Amani El-Alayli. Last name is E-L-A-L-A-Y-L-I.
Thank you.
El-Alayli.
Ms.
Hello,
Taylor.
doctor.
Thank you. Good morning. I can see you brought some papers to the witness stand with you today.
What are
Can you
those?
identify what those are?
Yeah, it's just copies of the slides. It's nothing. It's not on my piece. I couldn't see.
Okay. And if the slides, does that refer to the PowerPoint
I brought the
presentation that
slide
you
deck in case I couldn't see the
shared
monitor.
today?
Wise.
Okay.
A
At this
well-prepared
time, will you
witness.
place that document in front of you face down? And if you have difficulty seeing the slides, let me know and we'll have you turn it over so you can track and help us understand.
Can you imagine Ann Taylor versus Doctor, this is not a memory test in Depp v. Heard, where she's like, I don't want this to be a memory test. Ann Taylor is just a really good attorney. I like her. A jury's going to like her demeanor. I don't always like all of her arguments. I don't always agree with her, but I like her. She's like, we're going to turn this over and we're going to just talk about this without you referring to your notes. Can you imagine this in a different case? I can.
Understand what you're going to teach us today, okay? Sure.
Yeah, I want to make sure then the state has stipulated to admit that.
That's correct.
Slides. Okay, thank you.
It doesn't.
So all of the slides that we might be
She's going
considering
to go through
today,
her slides. It doesn't really matter for this,
correct.
but
Okay,
that's
thank
fine.
you. Go ahead.
It's not a huge deal here. It will be at trial. It's not
Can
a
you
huge
tell
deal
us
for
what
this
you
hearing.
do for work?
I'm a professor at Eastern Washington University.
What do you teach?
I teach social psychology, which is the study of how people interact with each other and influence each other, how we're all affected by social situations.
Can you explain why I have 4 Stanley Cups? Like, I love my tumbler cups, but then I had to have them. I need to understand more. I'm
going to
too
ask you some
influenced.
questions so that I can understand your background that led to your ability to teach. But I want to know if you're here today in your capacity as a professor or in your separate role as an expert consultant.
And here's my separate role as a consultant. So what I'll be talking about today is based on my expert opinion, based on the research I've conducted and what I've learned about in the field, and they're not affiliated with the university.
Very interested
for that. Now let's go to your education. What degrees do you hold?
So I have a bachelor's in psychology, and I have a master's and PhD in social and personality psychology, with a focus on social psychology.
Social and personality psychology.
So our area, like I mentioned, it studies how we interact with and influence each other, the power of the situation and how it affects us, like how we're all behaving differently here than in our living rooms. It includes things like how people influence us to purchase things. Like I teach a class on social influence, or influence us to donate money.
Ma'am, can we audit your class? We're fascinated. We want to come. Can we just participate from our living rooms, please? I want to take your class. I'm so fascinated.
And then my specific area of focus is on social cognition, which is how we select, remember, and interpret social information.
How long have you been teaching?
I have been teaching since before I graduated with my PhD, so since the late 90s. But I started my positions as a professor in 2002.
2002?
2002 at University of Florida, 2003 at Eastern Washington University.
In your role as a professor and a professional, have you written articles and been published?
I have.
How many, roughly?
Roughly 15, give or take.
Do any of those relate to human bias?
Yes, most of them. So a lot of them are focused centrally on bias, and then many of the others are tangentially related to bias. So it could be biased perceptions of ourselves, how we tend to overestimate ourselves in a lot of ways. It includes biased impressions of individuals.
Ma'am, are you studying a neurotypical audience? Because I feel like when we're looking at neurodivergence, the neurodivergence audience leans highly the other direction in underestimating. So I've got a question about how people are opting into their brains, because what is that like? I find people overestimate themselves. Who are people? Can we be them? I would love to be people. I'm going to let her keep going.
Like you might take one thing about a person and make a whole bunch of conclusions about them when you don't know them. And that could influence how you perceive their behavior later on. It includes biased perceptions of groups, so stereotyping and prejudice. And I've also studied biased impressions of businesses.
Have you consulted as an expert in other cases besides Mr. Kohberger's case?
Yes, I consulted in a case around 2016 or so, and then I was involved in the non-dissemination hearing here as well for Mr. Kohberger's case.
So you're telling us that you testified before Mr. Kohberger's case. Is that correct?
Correct.
And have you testified as an expert in any other hearings besides that one for Mr. Kohberger?
For Mr. Kohberger, no, just that one.
How about other people?
Yes, one for, in the case I didn't seek it out. I have a full-time job, plenty to do, but I've been asked to do expert testimony, and I feel like it's the right thing to do to share what I know about bias.
Thank you for that. What is your role today? What did we hire you to do and ask you to do?
So my role was to evaluate how publicity about a case could shape potential jurors when they come in and sit on a panel, and to see if maybe people who were living in Latah County or have some connection to Latah County might potentially have more problems being objective.
I think these are very important conversations to have.
Did you prepare a PowerPoint to help walk through what you have to share today?
Yes, I did.
I'm going to do my best to open that up.
Ann Taylor is like, technology versus lawyer, round one, ding, ding. And yes, the screen does go dark every time they switch between the feeds for the PowerPoints. Can you put it in presentation mode, please? Please, 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 Ann. Please, presentation mode. Please. Help us. Help us help you. How many of you want to just yell where it is?
I am trying to find the right.
You just go to slideshow.
She's going to help her.
Right to the,
this is how you put it in presentation mode.
One more, right.
Ann, this one's for you. We feel you. We feel you, Ann.
And then.
Okay.
We feel you, Ann.
I think we're there. Thank you for helping me through that.
Do this regularly. I'm not teaching.
All right.
This is also in the linked document.
If this is the background of the research on potential juror bias, what do you know about that?
Yeah, so there's been a lot of research on how publicity affects potential jurors. It says roughly 40 years. Really, it's been longer because in the 1960s, there were some high-profile cases, and so social scientists wondered, does it matter if there's a lot of publicity about a case? Could that potentially make jurors less objective? Could that influence actual outcomes in a case? And so the research started then, kind of trickled in, and then became more and more popular. And then in 1999, there were enough studies that somebody conducted what's called a meta-analysis. And another one was conducted in 2022, so it's nice to have a recent one. A meta-analysis is when you take a bunch of studies on the same topic and you statistically combine them into one giant study.
I didn't know.
So they do this in every field.
I'm not a scientist.
Medicine, every discipline, where you really want to know an overall effect of something. Because I might run a study on the effects of pretrial publicity and find maybe a small effect. and somebody else might find a big effect, and somebody else might find no effect. And it's hard to trust any one study with, a few dozen participants, or even if it's hundreds. I would want to see lots of studies. Just like if I were trying to decide if I want to take a medication, I don't want just one study that tells me it works or doesn't work if I have a serious illness or the medication has a serious risk. But I would be much more confident if there were a whole bunch of studies, dozens of studies combined, and thousands of participants' data.
Right.
And so a meta-analysis basically does that. It narrows down a specific topic, in this case, the effects of pretrial publicity on judgments.
I love it.
And it examines overall, combined.
Your nerd heart is tickled.
And so there were, like I said, one is quite recent from 2022. So it's the simplest way to describe this research. It's the easiest way for somebody to know where it stands, even if they don't read all the articles. And what this work has found is that if somebody's exposed to publicity about a case, something about the defendant, something about the case, fact, fiction, that the tendency is, if you look at everything as a whole, for it to affect judgments, and specifically how much you like the defendant, your inclination to say that they're guilty, your judgments of their criminality, etc.
Likability matters pre-trial, likability matters in court, and half the time likability in court is based on somebody's face, hair, body, and demeanor, because oftentimes they don't ever hear from the defendant. And likability of the attorneys is hugely important and can be imported to the defendant or what have you. It's really interesting, but they are talking about pretrial publicity and whether it paints a positive or negative picture.
And this has been shown with individual judgments of guilt, but even more so with group judgments, with juries. And it looks at participants who are randomly assigned to get pretrial publicity information or not, so that you can really determine cause effect. So this would be a formal experiment. We do lots of studies, and experiments are the ones that I like to look at, because what you do is you hold everything constant except for one thing that you change. You get one experience, another group of people, another experience, and then expose them to all the same things. So all the same trial stimulus materials. And you see, okay, the people who got some information ahead of time that they weren't supposed to pay attention to, did they evaluate the evidence differently? Did they come up with different judgments? And so the meta-analysis in 2022 is based on over 11,000 total participants, and it summed up the studies on that specific topic.
And the sum up, what was the sum up?
Yeah, essentially what's on the slide there are the main findings. The fact that if you get exposed to publicity, you're more likely to render a judgment of guilt, and less likely to, or have lower liking for the defendant, and have higher ratings of their criminality.
Based on your years of teaching and work and understanding human bias, do you know why this happens?
Yes, if you don't mind advancing to the next slide, I have a couple sections here. One is on why we sort of soak up this pretrial publicity in the first place. And then the next section is on why that stays with us through a trial if we are to serve as jurors, even when we don't want it to stay with us. And so if I just start with the first topic, why is it that we soak this up in the first place? One reason is because of how we process information. Since the 80s, social psychologists have studied this model that suggests that it's pretty straightforward. Sometimes we think deeply about things and we scrutinize arguments and find flaws in them. And then sometimes we make quick decisions. We like decision shortcuts.
Sometimes you act like a lawyer.
We have so much cognitive capacity that the vast majority of our decisions and thought processes are more automatic. And we call this peripheral processing when it involves an influence situation. So if you're making some kind of determination about something, whether you should purchase a certain car or vote for a certain political candidate or something like that, and you can go through and you can analyze every single thing and try to be as objective as possible, or you can make a decision in 2 seconds. Oh, my neighbor has that car and they like it, And so the problem with peripheral processing is sometimes you're going to come to a conclusion that you wouldn't have come to before if you had thought about things more methodically, more systematically. And so the reason this applies here is because people, when they're consuming media, are often processing peripherally. Why? Because they might not be completely able to focus on a story, or they're scrolling quickly through a newsfeed. So if you're scrolling through a newsfeed or a social media feed, or if you're watching the news while you're cooking dinner or something like that, you're taking in information, but you're not able to really devote the resources cognitively to nitpick. And so you'll see something like Bryan Kohberger arrested for the murder of 4 students, or you'll see something like this: among items taken from suspect, knives, guns. And automatically, when we're processing at the superficial level, which again, most of the time we're doing, we'll say, oh, okay, so they found the person who committed the crime and they have evidence. And we don't take it a step further. But if you actually stop and think, then you realize, oh, wait a minute, people get arrested all the time and it turns out they didn't commit a crime. Or wait a minute, we all have knives in our homes, but we haven't all killed somebody. I have a lot of knives in my kitchen. A lot of households have guns. And so we don't take that extra step to really think deeply about things a lot of the time when we're consuming media.
It sounds like you're telling me that we're just absorbing information, and in Mr. Kohberger's case, from the media, people may take bits and pieces, and that starts to create a level of knowledge or human bias.
We might feel like we know about something more than we do, yeah.
But
are there other ways that bias?
This is a motions hearing. There's no jury, so I appreciate that Ann Taylor is like consolidating the answer. Yes, it's leading. The judge is the finder of fact here. And all of this is in their filings. So it's trying to make it easy to take in and understand what the point is of this testimony. So though it's leading, I'm not going to
gets created.
Really be too critical about it.
Looks like you advance to the next slide. So one thing that's relevant here too is listening to authority figures. So I mentioned that we're processing superficially a lot of the time, peripherally, and one readily available peripheral cue a lot of the time when it comes to this type of situation is hearing information from authority figures, people who have status or expertise, any kind of power. And we tend to listen more to people in those positions. And yes, a lot of the time they have more knowledge, but there are big problems with this. One is that we assume that they're accurate. We forget that they're humans too, that they make mistakes too, that they have biases too. Like if I'm in charge of trying to make a community feel safe by, arresting the right person for a crime, I have a motivation. I want to make sure.
Conferences of we got the guy
myself,
is to
maybe, but
assure the community that they're safe.
If I'm in that position, doesn't make me less biased, right? We all have biases. All humans have biases, and they also could be wrong. Like I said, people can get arrested for a crime when they didn't commit it. And what we found in research over many, many years, decades, is that if somebody has any kind of indicator of authority, even if it's something as minor as height, but certainly, an occupational.
Right. Something as easy as height. Remind me next Members Only Live to tell you about some of the attorneys that would use their height to impose on others. We have stories. But yes, height, voice, tenor of voice, language used, especially in professional capacities. People do this to raise their own authority.
Status, title, that people will take their words so far that they'll do things to contradict their own morals, and they'll be influenced in areas beyond the person's expertise, like a doctor influencing you in your relationships or something that's totally irrelevant. And so we take it a little bit too far. And in the case of Moscow and Latah County, it's a really small community, right? And so the authority figures are often going to be people who are known and well trusted, and so that makes this effect even potentially more problematic.
Next,
as you know, Chief Fry, the chief of the police at the time, had said that he was certain that he arrested the right suspect, and he didn't have any doubts. And so the community would say, "Okay, well, the chief of police is sure, so then I can be sure too." But like I said, we can't assume. And there's no trial that had taken place yet. And so we can't assume that that's accurate information, but we tend to take that a little bit too much at face value.
The example that you gave of the police chief speaking out and offering what he thinks about a case, does that Is that something that creates more bias in the minds of the Latah County residents that heard that?
Yeah, I mean, they're familiar with him. They know him to be an authority figure. They may know him personally or trust him personally. And so, yeah, somebody outside of Latah County, they'll still be affected by his authority status, but maybe not as much, right? And then he also has power over people in that community, and that seems to carry some weight when it comes to this type of influence. And then also, the president of University of Idaho saying, we can feel safe now, they found the person. It sounds very conclusive when there hadn't been a trial yet. And so another authority figure is pretty major in an area like Latah because so much is centered around the university.
Interesting.
Are there other ways that you found that create bias?
Yes, if you don't mind advancing to the next slide.
You summoned Cartman.
This is a phenomenon that goes back maybe a century. We've been studying this in so many different contexts, tons and tons of research on this phenomenon called classical conditioning. And it's basically when we make associations between things and it causes us to have reactions that we didn't have before. Like, for example, if your alarm clock, we don't really have alarm clocks that much anymore, but if your alarm sound on your phone alarm, if that's what you use, wakes you up this morning and you have kind of a negative response to it, it might be because you associated it with waking up before you wanted to. Before, I know I always try to choose a sound that I don't have an aversion to, but then it doesn't take long before now I have a negative reaction. So you make this connection, right? But if that same tone was used every time a loved one texted me, then I wouldn't develop an aversion. I might develop a favorable reaction. So classical conditioning is when we develop a response to a stimulus. It could be a sound, it could be any stimulus at all, including a person, because we've connected them with something that it has been paired with, especially repeated pairings. So in this particular case, if the defendant's name is seen throughout media and social media a lot, or his image is shown alongside things that are aversive, negative words, things like terror, murder, evil, or alongside known killers, alongside details of the murder, alongside information about, tragic consequences, things that make us feel bad. What happens is it doesn't take that many pairings, and then his name alone, which was once neutral, because most people wouldn't have known him, becomes conditioned, and it evokes those same kinds of feelings. And they've done studies like this where they can make this happen within minutes. If I could take a picture of any of you or multiple pictures of any of you, show those interspersed with pictures of other people, and at the same time present words, consciously or not consciously, that say things like terror and evil, and at the end of the study I can ask people, what do you think of this person? And the rating will be lower. And so if you get that exposure a lot, like in Latah,
very quickly
are getting a lot of media exposure and also social media exposure and having a lot of discussions and attending, vigils, and they're really being exposed to kind of all these emotional reactions. If they're thinking about him at the same time, they can't help but make that connection, even if they don't think he's guilty.
Let me make sure I understand
all media ever.
How big this
PR
is, how far-reaching this is.
Influence campaigns.
We've been with this case pending for a year and a half, and there's been, suffice to say, a lot of media coverage. There's a lot of pictures of Mr. Kohberger in the media. Do you mean that when we walk into trial and the room's full of potential jurors, there's going to be a great majority of them that before we sit down are going to have a feeling of bias against Mr. Kohberger?
Yeah, I do. And we've seen the pictures, these ominous
the ominous headlines. And look, this is all argumentative. This is the defense advocating for their client. But the question is so argumentative and leading, and it's just so dramatic. Are you telling me that when these jurors walk into the courtroom and they see Bryan Kohberger, they're just going to be like, murderer? Is that what you're telling me? And that's what she's getting to. However, it's her job to be persuasive, and it's a hearing, so these things will fly. But it really is very much is what you're telling me.
A great majority of them that before we sit down are going to have a feeling of bias against Mr. Kohberger.
Yeah, I do. And we've seen the pictures, these ominous headlines. That connection can't help but be made.
She's saying the jurors won't even know it. They don't even mean to do it. They want to be objective, but the media has just fucked it. So people cannot walk in and be objective. So they are going to come in, even if they want to be objective, they just can't. And that's what this testimony is eliciting for the defense.
That's all the way that bias gets created, or do you have another one?
I have one more. As far as things that happen largely while the publicity is coming in and you're getting exposed to it, and it's sort of.
I hate the fear-mongering lean in of media. It's something I bitch about quite a lot, but it drives engagement. Negativity, anger, vitriol, sensationalism, all of it algorithmically drives engagement, and that drives it to the top. So the fear peddling in media pisses me off more than anything. I think it's irresponsible, but I will save my TED Talk about media trying to sway the actions of the population through fear for another day.
We have a category of a lot of different influences that are emotional and motivational. And this one I think is especially relevant to, sourcing people out of Latah County to be jurors. So the media played a role in inducing some emotions like it does. It likes to attract attention, things like fear and anger and sympathy and empathy. But in that community, people are going to have those emotions anyway from everything that's going on. But if the media uses phrases like killer on the loose, everybody stay vigilant, make sure you report all suspicious activity, then they're arousing that even more.
Right. Stay tuned here. Something's happening. Don't click off the news cycle. Don't click off the news cycle. Stay here. Stay tuned to our coverage. This is happening. It's bad. Be afraid. Stay here. Right. Because 24-hour news cycle. Over and over and over and over again. We've just opted out up in here. We're like, nah, we'll talk about it when something's happening. We're just here not doing that.
And so what happens is when we have emotions like that, they filter in how we process information. Just like when you're angry, you're more likely to remember things that have made you angry in the past than things that have made you happy. And when you're angry, you're also more likely to have kind of an agenda with new information coming in.
Now.
And so, for example, and this is something that could stay with somebody, this distorted information processing could stay with somebody and could get, there could be a resurgence during a trial where it keeps affecting somebody as they are reminded of their emotions. Because, they've associated moods with different judgments of guilt. Like, for example, if you're angrier, you tend to be more punitive and you want retribution. And in fact, in one study, they associated anger of mock jurors during a trial with support for imposing a death sentence for somebody. And they, when they were angry, they were less likely to pay attention to defense arguments.
I will say, sometimes the rage is justified when the behavior matches it. I'm not talking about this case. I am talking about other cases. I think there is a difference between coming into a case with a preformed opinion. Jurors should not do that. But as the evidence comes in, I think there is room where the evidence justifies the response of jurors. So if jurors see overwhelming evidence of horrific shit, yeah, they're going to be mad because they're going to sit there going, that's horrific shit. Don't do that. Yeah, we're mad. Yes. But that can go either way. I was real mad during the Karen Reed case about the police investigation. So it goes both ways. And I think there's a difference between coming in with that feeling and that feeling being based on what you're seeing in a courtroom. And I think people can, distinguish between the two. So. She's saying we need to be careful.
Aren't trying to be biased. It's just that when we're in moods, those moods filter how we process information, how we take it in. And, I think I may have mentioned this already, but there's also kind of an emotional, motivational component to feel like the person who committed the crime is under arrest. It is the right person. I think I mentioned it as, being a motivation by the police, but the community has this motivation too in Utah, because they were living in fear during all these weeks where they were trying to find somebody to arrest. And somebody was arrested and people could take a sigh of relief. But that sigh of relief assumes that he's guilty. And so we have this coping mechanism, basically, where we want to get rid of these negative emotions. And one way to do that is to feel like, well, if he committed a crime and he's under arrest, then I can feel safe now. And so that's something that could come into play too if you live within the region where the event occurred.
And that's because of the fear that was associated with.
Any of the emotions really could potentially distort information processing. That last point relevant to fear, but a lot of research on how anger influences judgments.
Yes, ma'am. Yes. Anger influences yes, ma'am. Brains.
And how sympathy for victims, empathy for victims influences judgments. And certainly if you are in Utah and have attended vigils or offered social support, you're really getting a lot of that empathy and sympathy as well. Or if you're exposed to the personal media stories about what happened.
So I think I understand the ways that human bias.
You understand perfectly. You just want you want Judge to understand
what happens if we seat a Latah County jury and those biases aren't there. What happens as we put on the trial and evidence is presented?
Yeah, well, I mentioned this one can get carried through the trial, this idea of motivational and emotional sources. But there are other things that can happen during trial too that kind of exacerbate the problem. And one of these is confirmation bias. So this has to do with us wanting to confirm our expectations of things. And one of the most fundamental human needs we have is a need for predictability. You don't want to walk into this courtroom and feel like you have no idea what's going to happen. That's
to all of my neurodivergent people who hyperfixate on a particular meal because the predictability matters to you. You have been seen. It is just your brain saying, can we please just do the same thing so it's predictable and I don't have to pick something new? And it gives me anxiety to have to pick something new because what if I don't like it? And then I have to make another decision and that's really fucking overwhelming. And then it's going to make it worse. So can I just eat at the same 4 restaurants every single time? And please don't push me into that comfort zone. So, yes, confirmation bias is real. And we see that play out quite a lot with these cases on social media. I think for us as a law nerd community, it's helpful that we get to talk it out with others. I think the hard thing for jurors is jurors don't get to talk this out with others. They sit there in their bubble and they can't talk about the case. And that's really hard. So I understand what she's saying. And some of this might be persuasive and might not.
Uncomfortable. We want to feel like we know what's going to happen. And we know how people are going to behave.
Answers.
And so part of this need for predictability is that it causes us to distort reality a little bit. And so in one way that this does this is through the confirmation bias, which is once we develop an expectation of something, once we decide that this is true, this is the case, or the defendant is guilty or not guilty, or the defendant lives a certain lifestyle or behaves a certain way, or then once we decide something, everything goes through that filter. I talked about an emotional filter. This is a cognitive filter that we actually process information differently based on what we expect to see and hear. It's just like if, you're going to meet up with a friend and you think somebody called your name, you expected it. And so it made you hear it even when it didn't happen. And if somebody does call your name, you hear it more readily. So we're kind of tuned in. And so the processes I mentioned here, this filtering can happen via 3 different processes. One is selective attention. So if I'm a juror and I have expectations about Mr. Kohberger, and it doesn't have to be just that he's guilty, but it could be expectations about him as a person. If I have expectations coming in and I'm getting all this new evidence during trial, going through that filter and paying attention to information.
Again, it might be the neurodivergence. I see the selective attention when people are discussing cases that we're paying attention to online, in the non-law nerd spaces that I really don't engage in anymore because we have an app and I can just be there. But you can see the selective attention when people are like, but XYZ proves ABC. And you're like, there's a lot else. Were we watching the same thing? And you can see it play out. And they're saying if jurors come in with if jurors come in with a preconceived notion because of all this extreme media around the case, then these things play out. So if they come in with that preconceived notion, if they come in with the extreme media attention that forms a, unconscious bias, then the brain takes over, and the brain does this even if they don't want to. Sometimes it's a lot easier to come into a case like I went into Karen Reed with like, la, la, la. I'm not listening to anything. I want to watch the case play out. But I'm going into Corey Richins watching all the pretrial motions, and I have some deeper feelings about everything we've seen in that case. So we'll talk it through as the case goes on. But this is what she's saying, for Your Honor, even if, because the case law says if the jurors come in and say, I can be fair, then that's enough. And the defense is fighting that, saying even if the jurors say, I can be fair, brains don't work that way. And that's why we're getting into all of this. Because even when people say, oh yeah, I've seen about this case, but I can be fair, they want to believe that. They intend to believe that, but also brains. So she's trying to explain, even when jurors are well-meaning, brains process this way. So it's a nuanced argument that's really important to whether or not a jury that knows about this case because of the media coverage can sit and be unbiased, not just because they say they are, but because they haven't been exposed to things that would create bias. Because brains. Keep going. Come on.
That backs up my idea. Well, I had this idea that he's a bad guy, and this information backs that up. So I pay extra attention to that. And then they talked about something where he was kind to someone, and I really have to pay much attention to it. So, we have this filter, and then we process information too in a distorted manner. We actually will change the information to fit in with what we think. It's just a way of our minds simplifying our worlds. And while these processes all help us not be overloaded cognitively, they distort what we take in. So we have to be aware of them. And recall is distorted as well. So, a trial takes place over a long period of time, potentially, and somebody has to remember a lot of information. And if they have distorted recall that's consistent with their expectations before coming in, that's obviously problematic.
Is that the only thing that happens when we have new information at trial?
Chad, I'm going to deal with some tech stuff. I'll be right back.
I'd like to talk about. And the first one is belief perseverance, which is really a direct consequence of the confirmation bias. So it's just like it sounds. This is the tendency for our beliefs to persevere, even in the face of contradictory evidence. Confirmation bias supplies us with this filter. And because we have this filter, if somebody gives us all these facts that go against what we think, logically, we should just change our minds. A lot of the time we don't. In fact, there's some evidence to suggest that sometimes we even cling more closely to our beliefs. And anyone who's looked at anything on social media has probably seen evidence of this, where somebody has a strong belief about something and then somebody provides actual facts that contradict it. And then instead of saying, oh, you're right, I see your point. Of course, that can happen sometimes. The general tendency is for people to still stick with their beliefs anyway because they formed them. When you're in the process of forming your beliefs, that's different. But once you've formed something, it tends to stick. It's the same thing with stereotypes. Somebody has an assumption that elderly people are bad drivers, and they see a whole bunch of evidence suggesting otherwise, and even research studies and things like that. Then they no, I still think elderly people are bad drivers. So that's belief perseverance. And in some cases, people will even double down. Again, social media, they might even get more aggressively in line with their initial opinion after seeing evidence to the contrary. So this is one reason it's directly aligned with confirmation bias.
It sounds like they can work together when somebody already has a bias. They've already made decisions about.
Yeah, really any expectation or decision or judgment, even if you don't know that you have it. I heard the phrase of growing legs. Well, there's a famous social influence researcher who used that same phrase with decision making. Like once you've decided something, your decision grows legs of its own. And so now it's not just the normal information necessary that pretty rational person, because we all kind of have this tendency to be irrational in situations like this. But it ends up causing us to distort reality a little bit and need a lot more evidence now than we should to change our minds.
What else impacts getting new information for your post trial?
We'll advance to the next slide. I want to mention a little bit about cognitive dissonance. And cognitive dissonance is an uncomfortable feeling we have when we have like an inner clash, like an inner hypocrisy. Like if I'm religious, but I don't adhere to one thing about my religion, and there's this inner clash. And we don't like that feeling, and we like to reduce it, minimize it, prevent it. So why is that relevant here? Well, if somebody lives in Latah County, they might have a dissonance experience, because if they start during trial to believe that, oh, maybe the defendant is innocent, maybe he shouldn't be convicted, that belief might be battling another belief about loyalty to their community, because they know the community wants closure. They know that the community wants him to be guilty. They know the community wants to feel safe. And so they have this inner clash. And what happens when we have this inner clash, lots of things can happen. But one thing that could happen is we could distort reality. That's another reason for kind of being a little bit less accurate when taking in information. So if I'm if I'm a juror from Latah County, and I'm starting to kind of think, oh, maybe he didn't do it. There might be part of my brain convincing me that no, he's guilty because of this inner clash. I want to get rid of the clash.
Is that because of the loyalty a person would feel to Latah County, to their community?
I think that's a big part of it. And there could be other reasons with regard to community connections that could create that clash too.
Like a concern that they might be known who they are as a juror?
A concern that they might be known. They're just kind of picturing yourself sort of coming back to your community with the news that you were involved in a process that actually, acquitted somebody, for example, and having to face people in your community, which is something I touch on later a little bit too.
All right. Should we move forward?
Yeah.
All right. I know the court's going to want to know, can we fix this?
Sure.
Can we get our jurors in here and tell them?
And this goes to the ultimate issue of the case, right?
This? What do you think, knowing what you know about it?
Can you fix it by moving somewhere else?
I would love that to be the case. I just don't see that as feasible when bringing jurors out of Latah County. And I can tell you some problems with all the methods that people try to use. It's just, if you look at the research, there are limitations to these. And so one of them, of course, is juror selection. Let's try to find people, for example, who haven't been exposed to publicity. So there are problems with that. Can you recount all of the publicity that you've been exposed to? No. If I asked you to tell me about all of the interactions you had with people over the course of a week, you're going to have forgotten some, right? But doesn't mean they're not going to be affecting you. So maybe when I was at the grocery store, the person checking me out had a negative expression on their face, and I didn't recount that to you, but maybe that memory is there and it's buried. And when I go back in the grocery store, I'm a little colder to them. And another possibility too is that retrieval cues can make some of these unconscious memories actually become conscious, and maybe they affect us at that level. So if I'm a juror and I'm sitting in and hearing all of this evidence, something might remind me, oh yeah, and I remember they found this information, and maybe it's something that's not admissible, but now it's affecting me. And I didn't report that I knew that because I didn't remember that I knew it until something cues that up. And so that's a retrieval cue, is basically something that reminds you of what you know and can't articulate yet, or maybe don't have knowledge about it at a conscious level. And so there's a problem with that, picking people who haven't been as exposed to a case. And of course, in Latah, we talked about the saturation of media. It'd be hard to find somebody to even say that, but if they say that, I don't know if that really would be something we could rely on as being totally correct. And then this is something I focus a lot of my research on, and it's bias. So there's a lot of research on how we overestimate ourselves. We have overconfidence. we tend to rate ourselves as better than average, like better than average in intelligence. There's one study where the vast majority of people rated themselves as better than average drivers, but we can't all be better than average. It included people who have gotten into multiple car accidents.
I'm a better than average driver.
So while people might be thinking that they're making an accurate assessment of themselves when they're asked, hey, do you have any bias, for or against the defendant? Do you have any, or are you capable of setting aside your bias? People probably often believe that they can set that bias aside. Because it's in line with all of this research that we know about how we tend to overestimate ourselves. So they're going to say they're less biased than they are. That's been shown over and over again in a lot of settings. And by the way, the people who are the most biased have the most distortion when they're estimating their bias in at least some cases that they've studied so far. That's some research I've done too. And then also they're going to be biased about how much bias they have. That's called the bias blind spot, which has been studied too. So I might acknowledge that other people might be biased, but I won't be biased, and I'll be capable of setting it aside. So that's one process, jury selection that we would hope would work, but there are a lot of drawbacks to it, so I wouldn't rely on that.
Do you think that it's less likely to work in a situation like this with the amount of negative media coverage that has been going on for a long time?
Yeah, if you ask somebody from Latah County to forget everything that they've heard about the case, forget all the discussions they've had, forget all of the media they've been exposed to, forget all the emotions that they've experienced, set all that aside. Can you really do that? Can you unhear things and unfeel things for an extended period of time to be objective? That's quite an undertaking. So yeah, I think that's problematic.
You mentioned extended period of time. This trial is projected to take 3 full months. Is that what you mean by extended period of time?
She did not stutter.
Really,
long trial.
The longer it is, the more potentially distortion there can be because your decision has grown legs and things are getting filtered through filters. And then emotional things can carry a little bit more longevity. So I wouldn't expect it to just go away if it's a long trial by any means, but I'd expect to see it in a short or long.
Is there anything else that can be attempted that might or might not work?
Yeah, my next slide is on instructions. And of course, people who would want to try to give instructions to jurors to be unbiased. And like I said, people overestimate their ability to do this. They don't even think they're that biased to begin with. And the first step to not being influenced by bias is to acknowledge that you have bias. So there's already an obstacle there. And then you have to have the motivation to not be biased. And I hope jurors have that. You also have to have the cognitive capacity to be unbiased. And that's where we run into a lot of problems because their cognitive capacity is going to be occupied by serving as a juror, paying attention to information. They don't have time to spend 80% of their mind, trying not to be biased and catching all the bias. And in fact, there's research that suggests that when we try to suppress thoughts, that we can think about them even more as soon as we let our guard down, which is very soon because you have to think about other things at some point. So if I try not to think about something like an argument I had with somebody or somebody tries not to think about cigarettes, but they're trying to quit smoking. They could do that for a really short amount of time. But as soon as they think about something else, their mind gets flooded with those thoughts. Because in order for you to not think about something, you have to think about it so that you can catch those thoughts. And that process is automatic. Most of what I've been talking about today is unconscious, automatic processing, and that's why it's so hard to control. And with regard to instructions to disregard information, whether it's something that people learned pre-trial or something they learned
really
during
hard
trial
to
that
disregard
turns out
what
to
you've
be
heard. You can't put the shit back in the horse.
research shows that those instructions typically don't work, and sometimes they can backfire, partly because of this thought suppression rebound effect. And then there could be other reasons too, like people not wanting to be told how to think. And I mentioned too that, it applies to emotional information too. So factual and emotional pretrial publicity would still have influence even if people say, don't let this affect you. I wouldn't assume that works at all, unfortunately.
How about jury deliberation? is that, will that work if you have a juror in there who's going to maybe accidentally bring something in or interpret something based on something that heard before, or they remembered something over the course of the trial? Will the other jurors push it out, help them not to think about that? Will the group overcome that bias?
Yeah, so we would hope that you get a bunch of people together who are trying to be objective for them to sort of correct each other. And while some of that might happen, what the research has shown is that if some people are exposed to pretrial publicity and some aren't, that can spread. Because you can't expect a juror to remember where they learned things. Like maybe they have information about DNA evidence and some of it came from trial and some of it didn't. And how do you disentangle that? That's really, really hard to do. And so they might spread it unintentionally. It might be spread intentionally too. But even if we're assuming perfect jurors here, it might spread unintentionally and then sort of contaminate the jurors during discussion. And then there's also this phenomenon we've been studying for a long time called group polarization, which is when you get a group of people and if they're leaning towards a particular opinion, when they discuss a topic, that opinion gets stronger and stronger the more they discuss it. Another thing you could see potentially on social media, like groups that, are invested in a particular issue. And if the group is leaning towards negative judgments about Mr. Kohberger or judgments of guilt or anything, even a little bit, then discussions could actually make it worse and worse over time. It could get polarized. So I don't anticipate that discussions would fix the problem. In fact, I would expect it to exacerbate the problem. And that might be why in that meta-analysis I talked about, the effect of pretrial publicity was stronger when it came to group judgments, verdicts versus individual judgments of guilt.
Based on your years of teaching human bias and your extensive study of human bias, do you have an opinion about whether the extensive pretrial publicity has impacted the Latah County jury pool?
I do. I think it would be so hard to be a member of that community
and
be able to come
trying to prove, right?
And
You've
be
got to change it
and arguably impossible. So we don't have a known method for undoing things.
Can't put the shit back in the horse.
Things have been done. They've felt the emotions, they've seen the publicity, they've had the discussions, they've been to the vigils, and even if they want to be
not
as
everybody's
objective
been
as
to
possible,
a vigil,
and even if we disregard some of the limitations I talked about before, research has not uncovered a way to undo this after it's there. And so the recommended best practice by the vast majority of researchers on this topic is find people who don't have that information.
Find people that don't have the pretrial information.
Find people who don't have that information. And the same goes for that emotional experience and investment and so on. Utilize jurors who have less exposure, they have less reason for prejudgment, less motivation to find the defendant guilty. It doesn't affect them, their feelings of safety, the community. They don't have to worry about reporting back, and other people maybe ostracizing them if they didn't make the judgment that was expected or wanted. And so my recommendation would be to find a community to recruit jurors from that's as far removed from Latah as possible, physically and psychologically.
Physically and psychologically. How do you screen jurors for how psychologically removed they are from Latah, though? Like, how do you screen for that? Do you feel psychologically connected to Latah? Like, that's a hard question.
Questions for you, but if you hold on just a minute.
So we're going to get to cross-examination in just a moment.
Okay.
Thank you, Ms. Taylor.
Let's see who's doing cross for the state.
Your Honor.
I think the social psychology is really interesting. There are issues of bias with humans. It's why we have jurors of 12. It's why we have voir dire. It's why we want good members of the community to step forward and say, you know what, I disagree with that, or I agree with this. And it's a communication. It's not just one person making the decision. Let's hear what Cross has to say.
In any jurisdiction where there's been a tremendous amount of pretrial publicity, at least.
Emily, stop pausing. I'm also going to pause. And that's one of the things. The state is going to argue, look, people have been exposed to this case all over the state. And if that's true, then we just screen for a jury here. We don't move 300 miles away.
some of these biases would apply to a prospective jury pool, correct?
Yeah.
And
if everywhere's
best
bad,
thing,
here is best.
If I'm understanding your testimony correctly, for this trial would be to have a jury pool with the largest percentage of jurors who hadn't formed an opinion on this case already. Would that be fair to say?
I mean, you need, I can't speak to percentages. You need somehow to find enough people to serve on the jury who have not been exposed. Now, this is a high profile case, so we know that exposure is all over the state, and of course, this is part of it.
Extreme
But
exposure.
if you can have less exposure, you have less bias.
In a case like this, where there's been so much exposure across all counties, are there unique challenges in selecting a jury that would apply anywhere?
So, I mentioned some unique things about Latah County and emotional investment in the community, concern for community members, and having felt that fear and wanting the defendant to be guilty so that they could resolve the fear and anger. So there are all those emotional and social connections, and of course, Dr. Edelman's report, which will come up later, shows that a lot of people who live in Latah County are connected in some way to the university or the police involved in the case. So they actually, know people or they lived in Latah County. And so those kinds of things make, because it's such a small community, make Latah a unique experience.
And so you've reviewed Dr. Edelman's survey.
I have.
So does it sound correct that 75% of folks in Latah County are not affiliated with the university?
I don't recall his percentages.
Okay.
So offhand, I'd have to see the report. I could look at it if you'd like.
Okay. And I should be more precise. I believe the question was, are you or a family member, a student or employee at the University of Idaho in Moscow? And the percentage of folks who responded no was 75%. Does that sound right?
I couldn't tell you about seeing it. Sorry, I don't remember.
Would it surprise you to find out that 60% of Latah County residents who were surveyed reported that they did not feel higher levels of stress or anxiety during the hunt for the killer in this case?
I don't know. I don't know what percentage I would have estimated. I just would have estimated it to be higher in Latah.
Okay. So is one strategy that the court could use in any jurisdiction, whether the trial stays in Latah County or moves to Ada County, would bringing in a larger jury pool alleviate some of these concerns across any jurisdiction?
Well, if we're talking about Latah County, a lot of the things that I mentioned were not in the survey. So, there are emotions I mentioned that weren't assessed during the survey, impressions of Mr. Kohberger that weren't in the survey. So it could be that 90% of people think he's a bad guy, but they don't think he's guilty. And then that still could influence judgments. So it's really hard to answer that question without, I didn't make the survey, and even if I did, there'd be a lot of things that I would miss too. So I can't make that determination about, you said maybe if you can,
well, if you can't make that determination, then what do we do?
Answer. Thank you. Now, I guess the last question I'll ask you is, would you be surprised to find out that in the survey, when jurors were asked, potential jurors who were responding to the survey were asked what their opinion is of Bryan Kohberger, the highest percentage of prospective jurors that were surveyed who had no opinion of Mr. Kohberger were Latah County survey respondents? Would that surprise you?
That they have no opinion about whether he is guilty.
I think the question is just, do you have an opinion?
No, they said they had no opinion about him at all, which is interesting because that goes through, well, to the heart of her analysis, which is it has to move out of Latah County. And they're like, well, actually, in the survey, the highest percentage of survey participants who did not have an opinion on Bryan Kohberger are from Latah County. And isn't that what we want? People who don't have an opinion on him.
Opinion of Mr. Kohberger.
Well, it's a high profile case that had a lot of coverage.
They're talking about the findings from it in cross-examination.
People who have an opinion, I imagine, I don't have those in front of me, but in statistics, we call that a ceiling effect when all the percentages are high and you can't really see differences. So I don't know if we're talking, I don't know what numbers you're looking at, but I don't know if that applies or not in this particular case.
Thank you. I got further questions.
So they're using the defense's survey.
Ms. Taylor?
Yes, just a few questions for you. Your focus is on
Pepsi Man said,
human bias.
how can a bigger jury pool not help? She didn't even answer the question. Yeah, a bigger jury pool is what they're looking for.
Okay. And you talked to us about media exposure and how that forms bias. Are bias and forming an opinion, you're willing to say, different things?
Bias can come from lots of things, one of which is an opinion that was formed, and then bias can shape another opinion that gets formed, if that answers your question.
It does. Thank you. You talked to us a little bit earlier about how that bias gets formed. And then you told us sometimes we won't be able to spit out our entire bias or what we looked at to form bias. Is there a danger in a case like this, where there's been a lot of media coverage, that somehow we seat a jury, but they start remembering things they read in the paper and trying to make the evidence fit into that filter?
Oh yeah, of course. So Dr. Edelman's report, I remember, said that, people didn't list everything that they recalled, but when they were prompted to ask to indicate whether they remembered specific things, then they remembered a whole bunch of things. The same thing would happen during a trial, right? Those retrieval cues, anything that reminds you of something. So our minds have kind of an association network. All of our memories are sort of connected in some way. You could just mention the word white, and maybe I think of snow. So our memories can come up from so many things that I would be surprised if there weren't some memories rekindled.
You say pumpkin, I say spice. I got it. Association.
Thank you.
Fair.
That's it for me.
Thanks, Ms. Taylor. Any more questions?
No, thank you, Your Honor.
Thank you, Mavis. Witness.
All right, and that is the end of witness 2.
And no objection to that. All right. Okay. Thank you. You're free to stay. You're free to stay or leave.
Free to stay.
Thank you very much. That was
should I stay or should I go now? Free to stay, free to go. All right, let's continue.
Okay, next witness.
Next witness is Dr. Bryan Edelman.
Okay.
All right, I'm going to take a brief second here because we had a feed glitch on our feed that we are streaming. So I'm going to switch feeds real quick so that we don't miss anything from Bryan Edelman. And then I will come back to our feed when the court is back from break. So give me one moment while I switch feeds. And then when the court goes to break, I will come back to our feed after break. But we had a power, which is why I was dealing with, hey, we've got backup options. So we're going to switch to this witness up until the break, and then, or switch feeds real quick up until the break, because it's the internet and we can do things. We can make anything happen. It's fantastic. And then the court's going to take a break. And when the court takes a break, we'll switch back. So, or we'll do some questions and then switch back. So let me zoom to that witness so that we have uninterrupted testimony for you from Bryan Edelman. And we saw him in the last hearing. I thought he was fascinating. He's the one who did the surveys. So in the hearing over the surveys, he is the one who compiled those, completed those. I found it to be really interesting. I hope you do too. So let me cue this back up with let's reboost our sound, because that's needed every time we switch feeds. And then we will get ready to rock. So thank you, Law Nerds, for the brief break. I just want it to be a good viewing experience for y'all. And for those on the replay crew, they're like, girl, we just hit the timestamps because they're all down below. But this is testimony I was really interested in. I thought the survey process was fascinating. I'm interested to see what is decided when we get to the cross-examination, because this is the person they went the most in-depth into, and then his analysis and his surveys are going to be in that document that I linked down below if you guys want to read the entirety. This is a summary for the judge. All of this has been filed. They are asking the judge to determine if this venue needs to change out of Latah County to a larger county where Boise is. The prosecution is objecting to that and wants to keep it in Latah County. They need to show that he can't get a fair trial in Latah County because of the pretrial publicity. So that is what they are trying to do with these witnesses. So let us go to court and hear from Dr. Edelman before we get to Dr. Dahir, which I'm fascinated by.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth.
That does not
and
sound
nothing
gained up
but the truth under penalty of
enough.
I did. All right. So please have a seat, and then please
That's better.
state your name and spell your last.
Hopefully. I think it's better. Hopefully you agree. We lost our closed captioning though. Our feed's better, but we lost our closed captioning for the beginning of this witness.
Edelman.
Sir, go ahead. Stay with.
Thank you. Good morning.
Good morning.
Dr. Edelman, I see that you brought some things to council table with you.
I did.
What do you have?
It's just a copy of my
Report.
presentation.
Your PowerPoint presentation? Okay. And is that face down? Perfect. Will you let me know if you need to flip it over to refresh your memory?
Sir,
I
can you
can tell you
answer
the
out
second you
loud?
start, I won't be able to see anything, so I'm gonna need it.
Okay. Your Honor and counsel, then I'll ask if he can leave his PowerPoint presentation
All right,
face up
Mr.
so
Edelman,
he can help us understand this test.
he's ready to spar with Santa already. Do you see him? He's just like, bring it, Santa. Once you start talking, I'm just locked in on you, and I won't be able to see anything anyway. Okay. Michael, thank you so much for the gifted memberships.
No objection to that.
Okay, thank you. Go ahead.
All right, let's start with your background.
Going back how far?
Welcome to our new members. Sir,
Well, let's start with what you do.
don't make me regret saying that I liked you, Dr. Edelman. Michael, thank you for the gifted memberships. Tell the new members welcome. But also, sir, don't make me regret my words. Don't make me regret my words. I'm so qualified. How far back would you like me to go? I was born. Isn't that enough? Sir, you're going to kill me.
Right now and then work backwards and forwards. How about that?
Okay. I'm a trial consultant. So in that capacity, I'm often in a courtroom doing jury selections and assisting with that, running juror questionnaires, helping attorneys craft oral voir dire questions. And I also do pretrial research, so that's focus groups and mock trials. And then I also do post-trial interviews and do a lot of presentations and writing in terms of trying to educate or help the legal community. And then I also serve as an expert witness in this capacity. And in that scenario, I'm often focusing on pretrial publicity, the impact of pretrial publicity, and whether or not a defendant's due process rights may have been undermined by media coverage. And I also do post-conviction work, which kind of ties into that,
by media coverage.
where I might be brought in to look at a case to see if there was a lot of media coverage and whether or not there should have been a change of venue or a request for a change of venue, and looking at the adequacy of voir dire to uncover what jurors knew. So that's kind of reviewing the voir dire transcripts and use of challenges, that sort of thing.
How long have you been doing that work?
That part? Since I think the first one, maybe like 2011, 2012, something like that.
Where do you do that work? What company?
So all over the place. So all over the country in state and federal cases.
Everywhere.
Florida, Michigan, Washington, DC, Idaho, California, Texas, New York, a bunch of others. So
I'm international, sir.
How were you
Check the chat.
educated to do the work then?
So I have a background in social psychology. So I have a Ph.D. in social psychology from the University of Nevada, Reno, which is a program that really focused on psychology and law. That's where the judicial college is, and something called the Grant Sawyer Center for Justice Studies. Am I going slow, or I do it better? Okay. And while there, I worked at the Grant Sawyer Center for Justice Studies as well, and did research on
there's a bit of it feels like a bit of an attitude today.
So on pretrial release programs and the impact of media coverage, so kind of similar to this. And when I finished that, I went to England and got an LLM in international humanitarian law. and then came back here and started working at a trial consulting firm. I think I started in 2000, I want to say 2004. That sounds about right. 2000, I think. And then started my own or co-founded Trial Innovations, where I am now, with a business partner in 2011.
Do you do any teaching about your
teaching? So I do like CLE classes and things like that for bar associations. I've done it for public defenders, for district attorneys' offices. I've been like a visiting lecturer at like different law schools, at the ASTC, which is the American Society of Trial Consultants. Did classes on like trial consulting and change of venue. I think I've done one at APLS, which is like the American Psychology Association, a legal society. And I'm sure there's some others out there too. APE, ABOTA is one, and that might be more on like jury selection. That's like a legal organization.
Are you a member of any organizations, professional organizations specific to your work?
Currently, I don't think I'm a member of ASTC, which is American Society of Trial Consultants, but I might have forgot to pay my dues this year, so maybe not.
Are you usually a member?
I think I liked him Furious better.
And same with APLS. That's
what's APLS again?
That's the American Psychology Association, and it's the Legal Society Division. And then I also do for like the ASTC, I've been on like a committee that helps write some of the professional guidelines, particularly around change of venue.
And
so he's invested.
I understand you do consultant work. Do you testify as an expert?
Yes.
What states?
What states?
Roughly.
Okay. Kind of the ones I mentioned earlier. I'm sure there's more. So,
what states? Where do I start?
Florida, Michigan, California, Washington State, Washington, D.C., Texas, Idaho. Wish I had a map in front of me right now. Tennessee, Georgia.
Your resume's in the record.
Minnesota.
I don't know if we need to go through all of this.
And I'm sure there's others, but it's been a long time, so I've done a bunch of them. I've probably done over 100 that I've been retained on in some capacity related to pretrial publicity in both state and federal cases.
I heard you mention Idaho. You testified as an expert in Idaho, is that right?
He's like, yeah, the last hearing when I yelled at Santa.
You testified before in this case?
In this case, yes. I did.
All right.
Yes.
We remember.
Last time we were here, we were talking about a survey that was in progress.
Last time we were here, we were feisty.
Have you now completed your survey?
Yes. So I completed the survey in Latah County and then conducted several comparison surveys after that hearing in Ada County, Bannock County, and Canyon County.
Before we get to all of those, I'm going to start a PowerPoint presentation that you've provided for us today, so you can walk me through the process of what you do and how that works. Give me just one moment.
Sure. I'm going to flip this over then.
No. You're just going to watch it on the screen. I felt his righteous rage over the survey. I get why he was frustrated with that. We're going to zoom until that's up on the screen because nothing's going to happen until it is. Oh yeah, I didn't love the PowerPoint. I do remember that. Can we normalize putting PowerPoints on a
we have it now.
Non-white background, like just something a little darker?
Thank
I don't care what color it is,
but patients, I think we have it now. Will you give us a or an overview of what we're going to talk about today?
Yes. So the presentation is broken down into 3 parts. So the first part is just kind of a cursory review of some of the social science research, some of the basic general research, foundational research, and then research specific to pretrial publicity and juror decision-making. And then to get into the actual change of venue analysis, which focuses on the media coverage, so the extent and nature of the coverage, and in addition to whether or not that coverage has had any impact on the jury pool. So that really gets into the survey. And the last part gets into the unique challenges that cases like this pose when we talk about jury selection. So is what you're an effective remedy in cases like this, when there's been a lot of media coverage and people have a lot of knowledge about the case.
You're blinding me, but not with science. You are
cases like this. What do you mean?
Sir, this is so dramatic. Where is that photo from, chat? This is incredibly dramatic, but the white background for the PowerPoints literally make my eyes want to yell. Where in the world is this from? The Idaho murders, the case against Kohberger. Where is that from? I need to know, because it's incredibly dramatic.
Sorry, when I say what?
Cases like this.
Oh, cases that have a lot of media coverage. So in a normal case, like a car accident or something like that, people come in, they might have general attitudes about drinking and driving.
Sir, if you talk to us about a drinking and driving car accident right now, we are not your target audience.
But they don't have case-specific attitudes about this person that are well-developed from information I know about the evidence and the person and so on. When you have a case like this, people come into the courtroom with case-specific attitudes that are well-developed and based on, it could be emotional information, it could be evidence that they already have read, seen, or heard.
I'm emotional
so they have very
about how much I hate
attitudes.
this.
So that's a unique thing because they're no longer blank slates when they're hearing evidence. They're confirming what they already know, as opposed to jurors who don't know anything and are learning and building attitudes and knowledge structures as they go.
All right, let's go to the background of why we do this, why this matters.
Yeah, so there's decades of research in general documenting the impact of pretrial publicity on decision making, and it kind of falls into two areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read the newspaper, I watch it on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions.
I'm reverse Googling the image.
And we can't really learn the types of pretrial publicity that are most impactful.
So that image might be out now.
And whether or not remedial measures like an admonition or Dahir mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial, how does pretrial publicity impact decisions, and things like do remedies work and so on.
Do you have
I have an answer,
example to
chat.
help me understand?
Thank you, Google reverse image search. That is a podcast cover for a parent podcast about this. So that is what it is. And that's what he was pulling from. So I'm sure other media outlets will share it now because it has been used in the PowerPoint, but that's where I found it. So I didn't have any idea what True Crime Today was. So I Google searched it. All right, let's keep going.
And maybe
we saw all this at the last hearing.
Difference starting with field research.
Sure. So the one we're looking at here is one of the earlier pieces that was published, and it looked at 3 cases that were high-profile cases in California. One involved the murder of 2 police officers, I think it was in Yolo County, and then the murder of a dental hygienist from a prominent family. So it was the status of the victim was important in that. And then I believe the third one was a rape of a young girl. So they did 3 cases, and they did surveys to assess the impact of that media coverage. And they learned a couple of interesting things. So they learned that people who consume news, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I'm.
People who follow the news and learn information about a topic, then have information about the topic? What? Sir, you're telling me that people who consume information about a topic have information about a topic? I need to know. I'm going to stop being snarky. No, I can't promise that.
News, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I'm to have detailed information about that specific case. So there's the first relationship that we look at. And then the next thing is case knowledge impacts presumption of guilt. So people who have well-developed case knowledge, they've read a lot about it and they know a lot of detail, they're more likely to think the defendant is guilty. They're more likely to have an opinion about that. And
Not
that
always.
stands out as more important than a host of things. They looked at gender, education, attitudes towards the criminal justice system, and ultimately case knowledge was 10 times more impactful, more important than attitudes like towards the.
So he's saying case knowledge, if people have more case knowledge about a case, then their view is that the defendant is guilty. That's what he is saying. So that, I don't know. I've seen cases where people have a lot of case knowledge and they're like, I don't agree that guilt is the thing. So he's saying that this is what the studies show.
Criminal justice system. So it wasn't something like, I'm just a pro-conviction person who tends to favor the government and think people are guilty. It was far more important than that when it came to these attitudes and opinions they developed.
It sounds like the field research has been important in your profession.
Yes.
Fair to say?
Yeah.
Help me understand what experimental research is.
Yeah, so these are more, again, traditional studies where we are able to control. We can look to see, maybe we're testing to see what types of pretrial publicity are most impactful. Maybe we want to know if voir dire is an effective remedy at mitigating the influence or impact. An interesting study someone recently did was looking at the set aside question. And they were looking to see if you did something
that information?
Like normally what happens to jurors on the spot, it's just like, what do you know about the case? And it's kind of like on the spot, I need to think about it and try to recall everything from memory and spout it out right there. So the remedy was, what if the person was given time to write down everything they know and think about it? Think, can they really be fair? And then come back to them and then ask them again. So they were looking at that as a remedy. So that would be an example of an experiment. And like globally, what we find is exposure to pretrial publicity impacts perceptions of guilt.
I'm not going to say
and it influences the defendant's credibility, likability, and sympathy towards the defendant as well. And overall, most of the research shows that judicial remedies are not effective. We talk about admonitions, so like the judge telling the jurors are not allowed to consider media coverage; they have to set that aside. Voir dire, kind of like I was mentioning before, those don't mitigate the impact.
Here's why this is coming up and why I think they brought their witnesses in a very smart, logical, strategic way. The defense brought their witnesses in to show first, there's a ton of media coverage, right? Hey, Your Honor, fuck ton of media coverage, mostly in Latah County. That's what the defense is arguing. Then they bring in the witness that says, hey, when there's like a fuck ton of media coverage, people form unconscious, subconscious bias. That bias leads to confirmation bias. And then even if they say things like, I can be fair and objective, that's not enough because brains. So when you're exposed to this much media coverage, and in this case, there's this much media coverage, then brains. So you need to go to a different jury pool. Then you bring in this witness who says, look, we've done all the surveys. This is what's actually happening here. And these are the remedies or not, because the case law really says if you ask jurors, can you set that bias aside? And they say yes, then that is sufficient. So the defense is trying to show the judge, Your Honor, that case law isn't addressing this situation here. He can't get a fair trial here. And the remedy of just asking jurors, can you put that aside, is insufficient. So they've built their case today in that way. I wonder if they'll have, we've got Dr. Dahir after this, which will be interesting, but they're getting towards the end of their witnesses for the day. And then they've admitted stuff via affidavits.
Impact media coverage. Delay is another one. Sometimes there's a long delay between when someone reads the coverage and when they come and do the experiment to see if that mitigates the impact. So overall, those are the key findings and takeaways from the experimental research.
All right. You have a slide in here called, I'm not going to say this word correctly, Potower and Singer. What's this about? How is this important?
So this is, again, just an example of some of the research. So in this study, the researchers recruited people who had been excused for jury duty, so they were at the courthouse. And they were put into two different conditions. So in one condition, the experimental condition, they read an article, and that article contained information about the defendant. It was a criminal record. And it also included a retracted confession. So they were looking at something that's inadmissible. It wasn't going to come in, I believe.
That's hard when the media is,
and
when
the
people have already
controller read the
heard
same
about
article absent those two pieces.
A confession is really like, that is full shits out of the horse. So if jurors come in hearing, well, there's a confession, and then they go to trial and they don't see a confession, a lot of jurors could think, well, I wonder why they kept it out, because we know that that's there. So that's an interesting case.
Didn't mention anything about the criminal past, criminal record, or the retracted confession. And what they found, if you go to the next slide, is that there was a significant effect. So those participants who are in the experimental condition, the ones who had been exposed to the background, the criminal background information and the retracted confession, were much more likely, I can tell I'm talking too fast, were much more likely to convict and perceive the defendant as guilty compared to the control group. And that was a significant effect.
That seems like a pretty high percentage. This is an experiment with two otherwise equal groups of people, some exposed to negative publicity and some not, and almost 30% of the people in that experimental group would have voted to convict just based on that difference alone.
So 28 percentage points higher. And again, it's a controlled study. So they're controlling for everything. So the only variable really that should be that's impacting is the fact that one group heard this negative prejudicial information, the other one didn't.
Seems like a high.
What's that?
That seems like a high amount.
Well, it's a significant find. It's statistically significant.
All right. Let's talk about pre-trial publicity.
Okay.
How does it impact information that you might get in trial?
Yeah, so we already heard about this a bit in terms of this selective process for filtering information. So the one that really is significant for me that stands out is the belief perseverance research. I'll tell you why. And like it was mentioned, so a common study would be someone would read an essay. For example, it might be an article about why risk-taking makes you a good firefighter, and people who are cautious that's not a good characteristic. And then someone else might read the exact opposite, where implying that cautious people are better firefighters than risk takers. And then they're asked to write an essay, and whichever one they read, they're more likely to write to support or write an essay that's consistent with what they read. And then later, when they're confronted with information that disconfirms whatever they had read and written, they're resistant to change. So we see that in our everyday lives quite a bit. And the thing that really is significant to think about is jurors who come in as a blank slate in a normal case, who haven't been exposed to media coverage, have no opinions or attitudes that are specific about the defendant, about the evidence, about guilt. And they're just processing evidence in a controlled setting through direct examination and cross-examination. The rules of evidence apply. So they're learning and they're developing opinions. They're considering the evidence for the first time. That's the ideal situation. In a high-profile case where jurors have been exposed to a lot of coverage and they end up serving, they already have well-developed attitudes about the defendant. So opinions of the defendant. They have well-developed attitudes about guilt, for example. And they have case knowledge that they've already been exposed to, not in a controlled setting. So maybe it's information in this case about cell tower data, or information about a vehicle being seen on video, or what the results of DNA tests are. And it's not under a controlled setting of direct examination and cross-examination and another expert from the defense side where they weigh all that. It's in the context of a news story. You know, there's editorial, there's public personalities, it's Nancy Grace, there's all this sensationalism around it.
There's a lot of sensationalism.
Exposed to all that, but they're also getting the information, the evidence.
We know what media he's watching, don't we?
That they're going to hear at trial. So when they hear that information, it's not new, and they're not considering it and weighing it as a blank slate. What they're doing is just activating the beliefs and the knowledge structures they have, and it's just confirming what they already know. So one side is just giving you the information I already have, which strengthens it. And it makes that information more accessible, in memory and so on. And then the other side is giving information that is attempting to disconfirm what I already know and believe. And it's scrutinized in a very different way. They're much more likely to reject it. They're much less likely to attend it, to store it in long-term memory. And it's really shifting the burden. So now the burden, whether intentional or not, is shifted on the defendant to change that juror's mind. And that's what we see when we talk about a filter, like our knowledge is, our impressions serve as a filter for processing new information. So it's really important to think about putting yourself in the shoes of the juror and what the task is and what that's like when you already have all this information compared to a jury who doesn't have any of that information.
Chad, I've got to take a quick break. I will be right back.
Sounds like a tough road that can be created by a lot of
running. I will be right back.
Can be.
Can you tell us about any studies you know about how evidence might be evaluated?
Yeah, so this is just an example again. So in this particular piece, the researchers were looking at something called pre-decisional distortion. It's kind of like disconfirmation bias. So people were exposed to negative pretrial publicity or positive pretrial publicity about the defendant. And then there was delay. So I think it was like 5 days or something like that. And they watched a murder trial where a husband was accused of murdering his wife. And it was intentionally balanced. So it was kind of like a 50-50 split of guilty, not guilty. And what they found was that at each point in time, they would stop and do a case evaluation and assessment. And people hold the evidence to be consistent or supportive of whichever leader they had. So if they had started the case where they were supporting, they had been exposed to negative pretrial publicity, they would be supporting conviction, let's say the prosecution. So they didn't look at that evidence just for the probative value, but it anchored closer to it supports conviction. It's consistent with the belief I already have. And it was consistent like that throughout the entire study versus those who maybe had seen neutral pretrial publicity. You didn't see that. So people were more likely.
How about when you've had a lot of pretrial coverage and then you have a lengthy trial? What do you know about a risk of confusing where you heard the information? Yeah. By that I mean bringing in something that you heard a long time ago that didn't sound the trial.
Right, and think about it based on what you were saying. These studies we're talking about an effect that was discovered with maybe 1 or 2 articles, and it still had an impact. Case like this, you're talking about inundated with pretrial publicity over a significant amount of time, repeating information, and then new information that's sensational. And so it's constantly reactivating those memories and making those knowledge structures more accessible, both consciously and unconsciously. So those attitudes are even stronger. So you would expect to see an effect like this to be even more robust in a trial setting over the course of weeks, months, or whatever it is.
All right, let's talk about surveys and what you do.
Sure.
Tell me what you do when you want to do a survey.
What do I do?
Yeah.
Well, so there's 2 different phases. So I don't start with I'm going to do a survey. So when I'm first asked to look at this, the first thing I do is collect a newspaper coverage. And I try to take a conservative approach. So I take the papers that have significant circulation in the county, that are based in the county. So I'm not looking, for example, at a paper in Spokane or in Ada County. I'm just looking at the ones here. And I read that coverage and I make an assessment if there's extensive coverage and potentially prejudicial coverage. So what is the nature of the coverage?
Remember, with
does it include inadmissible content? Does it include a lot of detail about test results like DNA results and things like that? So conviction-prone evidence. Is it have presumption of guilt or guilt-oriented detail? For example, public officials making statements about a defendant's guilt, victim families talking about that, things like that. Emotional pretrial publicity, because we know from the research the most prejudicial types of media coverage is emotional pretrial publicity, inadmissible content, and information about the defendant's character. So those are 3 big ones. So really looking at that. In every case is different. So in some cases, it's all about the community impact, and there's candlelight vigils and memorials, and just
they really are talking about those candlelight vigils quite a lot
so
here.
It might be something very different. So it's always dependent on the case. If there is not a lot of coverage or it's very neutral,
hydration game doesn't stop.
And basic, I wouldn't recommend doing anything else. So it would just stop there. If it's extensive coverage or sensational coverage or something like that, we would move to this next step, which is doing a phone survey in the venue. Sometimes we do a comparison survey, sometimes we don't. Yeah.
All right. I think you told me a little bit about the analysis of the coverage, but will you again tell me what you're looking for specific to a county before you decide to do a survey?
Actually, the main thing I'm looking for
when you're deciding whether or not to do a survey.
It really depends on the case, right? So every case is different. There's no like, I'm looking for X and is there or not. Every case is unique. Every case has, like, sometimes an example would be maybe this case went to trial 5 years ago and there was a conviction and then the conviction was thrown out. So really the unique thing there is exposure or knowledge that this person's been convicted is highly prejudicial. Sometimes there's a confession and we know from the research in the Supreme Court that confessions are considered one of the most prejudicial things that could be out there in terms of media coverage, that when we talk about change of venue. So maybe that's a factor. It always just depends on the case.
And do you look at the coverage to the local area you're talking about?
Yes.
What did you find for Latah County as far as coverage?
We already know a lot of this.
Just looking at the Moscow Pullman Daily News and the Idaho Argument, I found 240 articles going from 2022 to 2024, stopping in June. So I don't know what's been published since in terms of collecting the coverage. So that's the extent of the coverage in those two papers. I believe I also provided the Lewiston.
Just because I think
Daily,
this is the issue.
Or the Tribune.
Most
right?
news isn't news anymore.
Well,
it's just commentary and
in the
opinion.
survey, a lot of people mentioned they read that paper, so I put that in there as well and turned that over.
And he's looking at other cases, right?
Like that.
Do you know the total number of newspaper articles you collected from those three papers between the dates of November 13th, 2022 and June?
Yeah, so approximately 441.
Now you've provided this chart and you have Mr. Kohberger's name highlighted at the bottom of this.
Yeah.
What's significant about this chart that you've presented?
So one of the tricky things is always what is a lot of coverage. So there's no decision that I'm aware of where it says if you have X number of articles, that's considered sufficient for a change of venue. So what I did was I pulled cases where the population or the county where the case was initially venued were between 27,500 and 62,000. And I did that because we fall somewhere in there. We're at like 32,500, I believe, 18 or over here. So I was just trying to look for a range of cases to get a decent sample size and look to see how many articles were published in those cases and what the median was. So it's not impacted by extremes. And what I found was these 16 cases that fall within that range, and the median number of articles in those 16 cases was 85. And in those 16, there were 12 change of venues granted in that case. And if you look at those which had more than 80 articles, should be 85 median, it's 78%. And Kohberger would fall at the bottom right now because he's at 444. And I think, is it Daybell would have been, I think there was approximately 200 and change in that one. And I know that one was recently moved to Ada County.
And these are articles from the three newspapers only, not talking about any other source of media coverage.
Just the three papers.
Okay. Let's talk about how much media coverage there is. It's not just these three newspapers, is that right?
Right. So I did an analysis of the coverage that's in the declaration, which is more of a qualitative analysis. So I'm not going to go through that because that would be pretty laborious. So what I have here is looking at kind of consistent, some of the television coverage and some of the information that's been spread through more informal channels, such as social media.
What did you find?
Yes. So again, like
what
this
did
is
you
really
find?
looking
Yes.
at what people are seeing on social media and through informal communication networks. And the reason I did that is because it's a small county.
If this looks familiar, these are the same slides from the last hearing.
So
this is
people are more likely to
very repetitive from the last one.
Rumors and speculation because people know
Laura,
the victims.
I think it's like a throwback at this point with the old,
somebody
like
who
it
knows
feels
the
retro.
defendant or victim. So from my experience,
Twitter's
you have
still
a lot
bird.
of information
The old
disseminated
Insta.
through informal communication channels and through social media and high profile
Feels
cases.
retro to me.
Did you find that in this case?
I did. There was quite a bit.
What are we seeing on this slide?
So this is just an
Nicole,
example.
I try to stay out of conversations in court.
And just did one
And I don't
search,
do a lot
which
on
was
Facebook.
just the search term was Moscow murders to see what would come up.
And that's not
And
what
this
I,
is what we would call a results page, essentially. So if you hit play, you can see the extent of content that's out there from groups that are just talking about this case and sharing information and discussing what they think happened, and videos and posts, which may include anything from influencers and podcasters to sharing traditional news stories through local newspapers or television stories. But there's quite a bit. And again, this is just one search.
It's just one search. Yeah, but what does your algorithm look like, and how much have you been
Like
searching it before you searched it? Did you search it on a clean feed? Did you did you have a clean algorithm,
this
not
is
a
me
clean
just
algorithm?
scrolling
I've
through
got
the
so
search
many
engine results
questions.
page from that one search term. And what you're seeing is a combination of everything. And then if you click on the tabs like posts or groups, you would see other categories. What's remarkable is the number of groups that have been created discussing this case. Some of them local, some of them national, with, some of them have hundreds or thousands of members, others have hundreds of thousands of members. So this case has captured the public's attention.
We'll just keep scrolling for a minute. I think this goes on a little bit.
Sure, let's just
These are all groups that you're looking at right now. So these are just Facebook groups that have been created talking about this case. These are videos.
Is anyone contending that there's not media coverage here? Because there's media coverage here. We know that. We know that people make Facebook groups, but are these Facebook groups just of people that live in Latah County? Probably not. Should have gone through Reddit, sir.
These all popped up from that one search term.
Ma'am, that's how searching works. Y'all don't expect me to pop up.
No,
this is Facebook.
We need to advertise
we don't do
all these.
Yes,
honestly.
Thank you, Your Honor.
Okay,
we don't do a ton of stuff on Facebook.
From this kind of stuff,
the court's like, I don't need to see what's on Facebook.
I'm aware of it. I don't look at it. I don't read it. We know it's there.
May we take a brief break, Your Honor?
Sure.
The defense wants them to see it.
Go off the record.
The court's like, can we take a brief break? And then this just stays up. The judge, can we not advertise that? Defense attorney, can we take a brief break? Judge, sure. Court feed leaves this up. I'm going to zoom to when I think to see if I hear them come back from the break. Okay, now we've got the court is on break screen. All right, let me get past the court is on break screen real quick and see what the court does. All right, we're zooming past court is on break. Also, of all the state seals, wait a second, that went too fast. Of all the state seals, I kind of love the seal of the state of Idaho. I love that this isn't in presentation mode because it just feels so accurate with how today is going that it's like court is on break. Here's our slide to tell you court is on break because it's hard to stream court and the court is finding that. But the seal of the great state of Idaho, I'm kind of here for. I love it. I'm here for it. I've learned a lot. We have gotten to do a tour of the seals of the states, except for really Massachusetts because we only got a fan in that one. But I kind of like it. It feels kind of majestic. It gives outdoors. Lady Justice holding the scales is slaying. Like, we got a little reference to the gold rush. We've got multiple cornucopias. I'm kind of here for it. So I think the court's going to be breaking for lunch soon. So we're going to let the court break. At some point, we are going to need like a law nerd map with all the different states we've been to. And then we're going to need to rank the seals of the different states at some point. I think we just need to keep a map, like a travel map, but like a court travel map, like an EDB Air map. We need to do that. Like, where have we been together? Virginia, Massachusetts, Idaho, Utah, a bunch. Yes, we need a tier list of state seals.
Let's get back on the record. Thank you.
Ooh, we could do a passport. We could do a passport cover.
State versus Kohberger, case number CR 29222805. Counsel are in the courtroom, and as does Mr. Kohberger. We had a certain break here so that we could discuss about what we want to send out to the public. But we also have to make a record on that. So what we're going to do is we're going to take a break. We're going to make sure that we have the families of the victims can observe if they want to on Zoom. Some are here. And we're going to come back at...
Are we not going to have cross-examination of this witness? I'm going to back up. I was looking at all your amazing comments because I thought he was just breaking for lunch. And I'm sorry, the ADHD got me and now I'm confused.
Versus Kohberger, case number CR 29222805. Counsel are in the courtroom, and
because we didn't do cross.
Does Mr. Kohberger. We had a certain break here so that we could discuss about what we want to send out to the public. But we also have to make a record on that. So what we're going to do is...
So are you telling me that there are things that you are considering not broadcasting? Sounds like
we're going to take a break. We're going to make sure that we have the families of the victims can observe if they want to on Zoom. Some are here. And we're going to come back at 1:30.
But
did I say that right, Ms. Taylor?
I'm confused. What he's saying is we need to make sure that the victims' families can see what we're going to do, which indicates to me it's maybe not going to be broadcast. Let's hear what he has to say.
Yes,
you can correct me if you need to.
Yes, and I believe that the court will not be live streaming about the first 15 minutes after our lunch recess, and then live stream will pick back up.
Yes.
Do I understand that?
So there is testimony that they are taking outside the presence of the public. I think the court is careful when they're talking about the excessive media coverage to not make it worse. But people that are already watching court are already exposed to the media coverage. So it sounds like they are going to do 15 minutes or more so that the victim's family and those in court can see, but that the public cannot see. So we will have to rely on those on the courtroom to tell us what happened, which is why being in the courtroom is always important to have somebody there. So the court is going to take a lunch break till 1:30 Pacific. The way it breaks my head that this part of Idaho is Pacific and the rest of Idaho is Central is something. So lunch till 1:30 PT plus 15, well, probably plus 15 or 20. All right, let's see what the court says.
The courtroom is otherwise open?
Yes.
Got it. Thank you.
Yes. So it's kind of a compromise.
That's not a good compromise.
There were certain things that maybe we don't want to send out to the public.
It's all in the motions, Your Honor.
I don't necessarily know what it all is, but I need to look at it and.
Though I will say, if that's what Ann Taylor wants, I am internally annoyed, but I appreciate the court being cautious. We are here because they are worried that the defendant is not going to get a fair shake. If that is what Ann Taylor thinks needs to happen, I'm very curious as to what comes up after the break. I guess we'll find out.
See it for on the record. So that's how we're setting this up. Okay, Mr. Thompson, anything else on that or corrections?
No, Your Honor. We appreciate the court's concern. We have the same concerns, and I think this is a reasonable way to proceed. We'll reach out to all the families.
Great.
We know
Thank
you do.
Okay, so we're going to.
Though they should allow an audio feed only for media that cannot be present, because when the court when the court says that they are streaming media, not just me, relies on that. So the court should actually grant an audio only feed, not for broadcast, which is what happened with the delayed feed in Utah on the Corey Richins case. The court is like, hey, we will give you an audio only feed so you know what's happening in court and can report on it even remotely. But if you are relying on the video feed, that's going to be on an hour delay. Fine. The court can do that too, but he seems to be opening up the Zoom just for the victims' families, though it would make sense, even if it's not being streamed, that the media should have access to it to report on what happens, because they can walk into the courtroom if they're present. So the courtroom is still open. And Fala in the chat said, can they make non-family leave the courtroom? No. Ann Taylor said clearly the courtroom is otherwise open. So if people are there if people are there in person, then they will have access to it. That is interesting.
Big break, and we'll start up at 1:30, but the first 10 minutes will not
She
be
didn't
streamed.
say that. It's going to be the first half hour, I bet you. All right. We're gonna take a lunch break too, but we're gonna answer questions and super chats and stuff before we do that. And then we will probably take a break. I guarantee you this court's not going to come back on time. So we will take a break. As the court takes a break, I will give myself a little bit of Zoom time when we come back. So that means I probably won't be back realistically. And we'll send you a message in the app till it's going to be 2:00 Pacific before they're back. So it's going to be, no, is that right? They're coming back at 1:30. They're going to need a half an hour. So it's going to be 2:00 Pacific. So I will probably be back 4:15, 4:30 to give us a little bit of Zoom room and to let everyone take a minute, get some food. We've been streaming for over 3 hours, but I'm going to answer your questions. I'm going to send out a app notification when we go back live. We will give it a little bit of Zoom room in the afternoon so that you guys can take a minute. We're going to leave the chat open as we always do. We'll put up the court. We'll be back. But what we're going to do first is answer your questions, because we haven't had a chance to do Q&A yet. And then we're going to have to get back to cross-examination of that witness. So that witness testimony is not done. Vicky said, aren't they mountain time? This part of Idaho is Pacific time. This is the part of Idaho that borders, it's like the little pointy bit at the top that borders the state of Washington. They are Pacific time. The rest is Central time. I don't know how these lines get drawn, man. I don't know. But I live in a state that's half in one time zone, half in another time zone. And I tell people, oh yeah, I'll come down to Atlanta. It's not that far of a drive, blah, 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 blah. And I'm like, we'll just roll out. I love Atlanta. We'll just roll out to Atlanta. It'll be fine. And then I'm like, fuck. There's a 1 hour time change. That drive is not as short as I think it is because it's in Eastern time, but it feels like it should just be Central time, because I'm like, what are we doing? So I always forget that I need to add to it when I'm planning on driving to Atlanta. The times that has been like, oops-a-doodle. I forgot that I needed to plus an hour is tough. But what I will say is in Apple Maps and Waze and stuff, if you put it in, it will give you like a red line that says time zone change. Literally never happened to me living in California. Nothing in California you can get to that's out of your time zone. So there was no driving across time zones. Here, we drive across time zones and drive in and out of state lines in a whole different way than I used to, just because I moved. So let us answer your questions. I will do a whole rundown when we come back from the break and then at the end of the prelim. Real quickly, though, midway through prelim at the lunch break, we have heard a lot of witnesses that we heard from at the last hearing over the surveys. The defense is seeking to prove that, and we'll go over the standard for a minute real quick, just for us. This defense is seeking to prove that Bryan Kohberger cannot get a fair trial in Latah County where this crime occurred because of the extreme amount of media coverage. They're using that word specifically because of case law. The case law is pretty clear on the subject that if jurors say in voir dire, hey, I can put that aside, I can put exposure to the case aside, I've not made up my mind yet, that is sufficient. But the defense is arguing even if people want to believe that, they don't necessarily get it right. So even if they want to put that aside, brains. And they brought in a witness to show how much media coverage there was with pie charts and graphs. And then they brought in another expert in social psychology to say, look, when people are exposed to this kind of media, this is the kind of connections it can make in their brain. And then, even if they want to put those connections aside and keep an open mind, they are going to listen to the evidence differently, fundamentally differently, because there is going to be some confirmation bias. The brain is looking for that certainty, looking to confirm what they are already thinking about the case. And it makes it harder to pay attention to things that don't align with their viewpoint. We've all had a conversation with someone like this, where you're like, it doesn't even matter what I tell you, because you're not hearing things that contradict how you see the world. So we're not actually having a conversation. I'm talking and you're not actually having a conversation. But it's also why the jury instructions say things like, do not state your opinion too fervently or too fast. Do not make up your mind. Try to keep an open mind. And I think people can if they actively engage in that and want to. I think that if people want to, they can listen and they can learn. And that's why juries deliberate together, because they're supposed to point those things out to each other. And I think when people come at it with good faith and really want to engage in good faith, that minds can be changed and conversations can be had. Humans change their point of view, new information, new perspective. So they are arguing all of that to show that this case needs to move to Boise. And that's very much what the defense wants to do. The prosecution does not want to do that and is saying, look, everybody's been inundated with media in this case. So if everyone's been inundated and the jurors say they can be fair, then this stays here. This stays here in Latah County. It will be tremendously expensive for the state, and that's not their only consideration. It will be tremendously expensive for the state to move this case. That means the prosecutors have to move. They're not commuting, 300-ish miles from where they are in Latah County to Boise. They're not commuting. The state is going to have to put up the entire prosecutorial team to live in Boise for 3 to 4 months, if not more. The state will also have to pay to have investigators there. The state will have to pay to transport witnesses who are local into Boise and potentially house them there as well. The victims' families, the state will probably not pay for the victims' families to stay in Boise, but the victims' families can't commute 300 miles daily. So that puts onus and expense. If this was a 2-week trial, the argument might be different. We are looking at 3 months of trial to ask the victim's family, hey, if you want to be present in court, you need to move to Boise for the entirety of the summer, puts a substantial financial onus on those that have a lot of interest in the case. However, the onus on the victims' families is one part of the consideration. The rights to the defendant are going to outweigh that at the end of the day. That the weight is more strongly weighted towards a fair and impartial jury for the defendant than extreme hardship on behalf of the victims' families. And it might end up being that victims' families have to access the trial remotely. And they might not want to do that. We have seen lots of cases where the victim's family wants to be physically present in court every day. So this is what the court is trying to discuss. This is what the court is trying to determine. I don't think the court is going to rule today. And so we are going to get to your questions. And that's what it is. Let's see. Rocky says, I live in a fantasy world, only if there's dragons there. And then, yes, I'll absolutely take it. And I saw a lot of you say that's hard on the victim's family, but if that's what needs to happen to get a fair case so it doesn't get overturned on appeal, then that's what needs to happen. Yes, it's a really difficult balance, but the right to fair trial is going to win if those are the only two things in the balancing act, which is why the prosecution is really leaning into, well, everybody's been exposed to the media. They're not leaning into the hardship argument yet. 7Lil7Boo7 said fairies for me. I'll take that too. A lot of you said don't forget the unicorns. Also living in the land with me. So Angela said, what about fairness to the victims? It does not outweigh the constitutional rights of the defendant. So the constitutional rights of the defendant will outweigh the hardship to the victims' families. I know that does not feel like the right result, but that is what our Constitution demands. The hardship on victims' families is substantial in lots of cases. So it is absolutely a part of it, but the rights of the person at this point, it's a death penalty case, the rights of the person the state is seeking the death penalty against, those constitutional rights are set up higher. And those will take priority. At the end of the day, you don't want this to get overturned on appeal because an appellate court looks at all of this media coverage and goes, you're right, it should have changed venue. That would be a much higher expense to everyone and a higher emotional toll. But technology can overcome some of those things. So, and that's what the court might say. It's like, yes, it's a hardship, but technology can actually overcome that hardship. And if technology can overcome that hardship, we need to lean in to whether or not Bryan Kohberger can get a fair and impartial jury. That constitutional right is the right that is primary in this argument. Let's take a look real quick at the way the defense has laid out the standard here, and then we will answer some more questions before we take a break. So before we do lunch, we're gonna do lunch. We're going to do lunch. So let's look at this real. We have not covered, because of the amount of trials that have been going on and live court is Bay. We have not covered all of these briefings. I am going to link this document down below if you guys want it. This is the wrong, Emily, this is the wrong document, girl. I was like, this document is, that's the wrong one. This document is 319 pages. So if you are deeply fascinated, it is linked below. You can go grab it. I just gave you the direct link from the court website so you can pull this document for yourself. We have not gone over all of these because they are essentially the same arguments that we saw in the original hearing to see if the surveys would continue. And it's reiterating what we are going to hear in this hearing today. So, and we've been in trial for a substantial amount of time. This is the defense motion to change venue. I like the way they lined this out. Issues. Bryan Kohberger could not receive a fair trial in Latah County as protected by his rights under the United States and Idaho constitutions because of the pervasive, inflammatory, often inaccurate, highly prejudicial publicity and the small size of the jury veneer. And while I love Judge audiobook in Utah, I cannot stand that he pronounces veneer, but that is a personal choice. Yes, it is gross hypocrisy for me to ever correct anyone's pronunciation on anything when I literally cannot. But my law school and all the lawyers I know say veneer, not venire. Anyway, 2, a change of venue is necessary under Idaho Criminal Rule 21 and Idaho Code. We're not going to go through the factual background. We're going to go through the standard. They are saying that Bryan Kohberger cannot receive a fair trial in Latah County as protected by his rights under the constitutions because of the pervasive, inflammatory, and inaccurate publicity and the small size of the jury veneer. They go on to say that under the Constitution, the 6th and 14th Amendments in the federal one, and then Article 1.7 in the state of Idaho Constitution, the accused is guaranteed a fair trial and an impartial jury. The constitutional mandate of a fair trial with an impartial jury requires a change of venue where an impartial jury cannot be impaneled in the district where the indictment is returned. Quote, due process requires that the accused receive a trial by an impartial jury free from outside influences. That's the Shepard v. Maxwell case. Law students have all gone, wait, how do we get here? Like this case is covered so much like 1L coursework law. It's been interesting to see. Again, there are these cornerstone cases that set the bedrock principles of law, and that is one of them. It goes on to say where there is reasonable likelihood that prejudice in a community will prevent a fair trial, a change of venue should be granted. That's from Shepard. Consequently, the question posed by a motion to change venue is whether a, quote, reasonable likelihood, that's what the court needs to find. Reasonable likelihood. Whether a reasonable likelihood exists that pretrial publicity has affected the impartiality of prospective jurors. Based on what you've heard so far today, do you think there is a reasonable likelihood that the impartiality of prospective jurors could be impeded? The state's going to argue against it, but is that where we're at? This is not that's not cute, internet. That's not very demure of my internet. Not very mindful. Not very cutesy. So, is there a reasonable likelihood that pretrial affected the impartiality of prospective jurors? The phrase reasonable likelihood denotes a lesser standard of proof than more probable than not. So even lower than more likely than not. So they are saying reasonable likelihood is like our low, like low, like that level of standard. They say a reasonable likelihood of prejudice does not mean that the prejudice must be more probable. My internet is wildin'. That is not cool at all. Oh, I want to do Q&A, but if my internet keeps wildin', I'm going to lose my mind. The weather, the internet, not very mindful. Live streaming is dynamic. It goes on to say prejudice may be presumed when either A, inflammatory publicity about a case has so saturated a community that it is almost impossible to draw an impartial jury from that community, or B, so many jurors admit to a disqualifying prejudice that the trial court may legitimately doubt the avowals of impartiality made by the remaining jurors. That prong B is what we see when they're already underway in jury selection, and the jury questionnaires are coming back with people saying, I know a lot of this, I know a lot of this, I know a lot of this. And the court's like, nah, I don't. They're saying they can put it aside. I don't think they can. The defense is going to be leaning into argument A. Inflammatory publicity about a case has saturated the community. That's what they are leaning into here. That's why they want to go to a bigger community. They say publicity by itself does not require a change of venue. However, a presumption of prejudice requiring a change of venue attended only the extreme case. The test for the extreme case remains whether the trial atmosphere has been utterly corrupted by press coverage. So, let's see. Can we? I just had to ask a question real quick. All right. Let us continue. So they're saying this, this is an extreme case because of the atmosphere, because of the press coverage. So that's why we are seeing this happening today. And that's why we're seeing the order of the witnesses we saw. This is the amount of press coverage. This is what it's like. This is the pervasiveness of it. This is how brains work. This is why the disavowal will not work. This is why the only remedy is to change the venue, because the prosecution is going to argue that the remedy is voir dire, and the defense is going to say, no, the remedy is go to Boise where there's just more people, and it's going to be easier to find people that don't have opinions on this case because there's more people to pick from. All right, let us continue into Q&A. This is the standard. We're not going to go through the whole motion, but this is the standard we're looking at. Is this an extreme case where inflammatory publicity has saturated the community? That's what the court's going to have to decide. All right, I'm going to get to your questions, and then court's on lunch. We're going to go to lunch. But first, we're going to do Q&A, because the way I am still outraged about what happened on Monday's stream, I didn't get to your questions. I didn't get to your super chats. What did I get to do? I got to pick a fight with Sinclair Media that's not done yet. Members that were in the live stream yesterday know all about that ongoing battle over an outlet trying to claim pool coverage, the parent company trying to claim copyright on pool coverage. Y'all, we don't make this up. We don't make this up. If Chris, if that's the case, it's okay. Sorry. Don't, we already know. Sorry guys, we're working too. Let's go to Q&A. Let's go. I am not buffering. I just had to answer a question. Court TV said, is this play about us? Not this one. Not this one. Y'all aren't the problem. But we want to know if you also got copy claimed on pool coverage. You guys weren't the ones. It wasn't your pool feed. It wasn't KUTV either. It was their parent company. But it's spicy. That wasn't the FAQ around FAQ bumper, Emily. All right, let's get to questions. Let's do the things. I don't know this case, Crystal. So Crystal asked if I would cover and discuss Devontae Mitchell. I don't remember the case off the top of my head, but we have been down a rabbit hole for like 15 weeks now of the cases that we've been covering. So I don't know that case, so I can't give you an answer one way or the other. Again, we have been so down the rabbit hole in cases that it's really been hard to focus on anything else. Susan gifted 5 memberships. Thank you. Michael Toast, good to see you in the chat, friend. It's great to see you. J. Michael, thank you. You've gifted so many memberships this stream, and I very much appreciate it. Welcome new members. And if you want to go to last night's members only live stream, you can hear all of the spice. Casey Cat is saying Law and Crime got copy claimed as well. I'm not surprised by that based on what we saw go down. You heard me read to Sinclair Media, but I told them they were risking KUTV's ability to be the pool feed, because if they also claimed Law and Crime is going to, say the same shit that I said, which is everyone's going to complain to the court and say, you can't be the pool coverage if you're running around copy claiming videos that you don't have copyright in. And then the court's going to be like, fine, then we're not going to give the pool coverage. We'll give the pool coverage to another outlet. I guarantee you when there are pool coverage issues that other outlets like Law and Crime will just be like, hey, Your Honor, we volunteer as tribute. We've got this. We've never had a problem. That's not true for Law and Crime. Court TV has not been the problem. Law and Crime has, on occasion, copy claimed people. They've learned, they've stopped, they've moved on. But if Sinclair is copy claiming Law and Crime is just going to go to the court and be like, excuse me, just give us the cameras, which isn't really fair to KUTV, right? Because it's not on KUTV. I will stop ranting. We're just going to go to Q&A. Court TV will be like, we volunteer as tribute. We'll do it. So we're talking about the Corey Richens case. The parent company of the pool company was copy striking channels for using the pool coverage, even though they had access to the pool coverage, including myself. They had my stream taken down while I was still streaming. We're not mad. We have not picked petty. We have absolutely picked petty. Mad. Kimberly said, I thought that when there was a change of venue, it had to be a place with a similar demographic. Boise is much bigger than Moscow. It has to be within the same state. It does not have to be like a similar makeup. So it just has to be the same state. So Kristen said, excited to catch a live. Thank you. Can you please give a shout out to my fellow law nerd, Amy? Yes, if you seek Amy, hello, fellow law nerd, Amy. Shout out from your friend, Kristen. Thanks and love you, Emily. Love you guys too. Cumulus Cloud said, is Dr. Dahir going to tell us to say no to drugs? Probably. And to say no to LATAW? Maybe. Dr. Dahir is on the witness list as a potential rebuttal witness, so I don't even know if we'll get to see Dr. Dahir, but I really want to. AK Disgrace, we're going to celebrate your new job again. Thank you for keeping us in the loop. I appreciate it. I just appreciate it. I love that you shared that you bonded over the love of my show. I think that's amazing. Absolutely amazing. Court TV, yes, I will tell you all the tea offline if you guys would like to know, and what we've gathered on what happened. But yes, it took the stream down while I was still live. It was special. Becky said, how can he say he basically knows all the media if he just found out about Judge John Judge? This was a great question. This was the first witness whose company was compiling the media. He said that he was analyzing the data, but he wasn't gathering the data. So he had stayed away from it to look at it with fresh eyes. So his company was compiling the data and then he was reviewing the data is how I took that. So he was trying not to skew his own perception of things by looking into it on its own. So that, let's see. My argument would be OJ and then walk out. Boujou Girl said, look, a high profile case is this. I'm actually surprised we haven't heard the Scott Peterson case get mentioned. It comes up a lot when we talk about high profile cases and the media and potential media impacts. And it's been discussed quite a lot lately. As it's still wandering through the court system. So that is why. But my brain glitched. The overriding court cases in this area say that it is enough, and this was after the Boston bomber case, say that it's enough if the jury says that they can be unbiased. So the court cases are saying, if people say they're unbiased, we're good. And the sociologists are saying, okay, but even if people mean that and say that and mean it with all good intentions, like all good things, even if they mean it that way, that's not how brains work. And we know that that's not how brains work. So even if people say, hey, I can put everything I know about this case aside, your brain actually can't do that. You can't unhear it. You can't unring the bell. I'm actually surprised it doesn't get argued. Hey, Your Honor, this is why mistrials get granted when evidence comes in that shouldn't be heard by the jury, because the jury can't unhear it. It's the same. The jury can't unhear what they've already heard, can't unsee it, can't unlearn it. Attractive Nuisance, the best law reference ever, says, hey, ADB, can you please give my mom, Julie, a shout out? It's her birthday tomorrow. We both love your content. Happy birthday, Attractive Nuisance. And well, happy birthday to your mom, Julie. And thank you for the super chat. And thank you, Julie, for the shout out. And thank you both for watching. A non-mouse is a rat? No, what is it? I'm not going to try to answer the riddle. Emily, just answer the questions. A non-mouse. How many people remember not just Lost to the news cycle? That's a very good question. How many people hold on to that information? And I think that's why you see a lot of lawyers waiting until they're getting those questionnaires back to bring motions like this. This is early in the proceedings to bring this motion, but the defense brought in experts that are great. Camilla said, why not have a bench trial? This is a death penalty case, so you're going to need a jury to decide that. The defense absolutely doesn't want a bench trial. The defense has an absolute right to a jury. I don't even think the prosecution would want a bench trial in a case like that. Bench trials deal heavily with civil matters and then small, like, infraction traffic matters. But in cases like this, in incredibly serious cases, you're not ever going to see a bench trial. I don't even know if the law in Idaho would allow for it, because you're going to have a jury to determine the penalty stage. So I don't even know if you legally could, but nobody would want that. Hopefully that helps. Let's see. Thank you, Sharon, for the gifted memberships. I appreciate it. Danetta said, this is kind of insulting to the intelligence of potential jurors. I think there's a lot of times that the talking down to happens, but the defense is advocating for their side and saying, look, there's, no matter how well-meaning someone is, there's only so much people can do with their own bias. So it's really the social psychologist trying to say, hey, I just met you and this is crazy, but you know too much about me, so we're not going to make that work. So I don't think it's insulting. I don't think it means to be insulting. I think it's just trying to put scientific quantification around the fact that you can't unknow things that you know. I mean, unless you are particularly neurospicy, and then you unknow things that you know all the time, and then even some of the things you know you just know wrong, like locations of appointments and times of day, time zones and what time stream starts and all the rest of it. Jan says, a non-mouse is anonymous. Thank you. I appreciate all of you. My brain wasn't going to make that happen today. Casey Cat said Dracarys, me on Monday night. It is. Look, we love living in Fantasyland with the dragons and the fae. Nishay, good to see you. One can be tall and be about as intimidating as a cute, cuddly, adorable little squishmallow. Sometimes I want to be looming and scary. Damn it. I think it was interesting when they were talking about the way humans, like the way our brain defaults into like early human brain, and is like, this is how we're evaluating things and making judgments quickly. And so that when they were talking about the way that there's authority, they're like, somebody's profession, their title, what they're saying, where they're saying it. Do some view it as more authoritative if it is on television versus on YouTube versus on a podcast versus on, I don't know, 4chan? Like, is where it's being broadcast determinative of authority? Is who is saying it determinative? Is the intrinsic nature of the person saying it important? We've had comments on the chat. We don't get them as much anymore, but when my hair gets more vibrant, we will. And you'll see it when big trials happen. People will pop into the chat and be like, purple hair, miss me, next, and bounce out. So there are some that find my hair color as a denotation of a lack of authority. So they don't even get to the like lawyer for almost 20 years part. They're just like, we're out. And some of you are like, purple hair, I'm with my people. So it's one of those things that, how do you explain to a judge human nature? And how do you explain to a judge that when humans are processing information, all of these things happen real quick because brains are busy and life is short. And ultimately our brains wanted us to like run away from danger. So that's what they are trying to do. So the artful colorist said Jordan the Stallion gives off, he just knows everything. Yes, immediate authority. Once he brings it in close, I'm like, what are you telling me? Yes, all of it, yes. All of it, yes. And then I met him in person and was like, oh, you are a Buddha. And I love you. Like, you are like just Zen and you know things and I trust you. And I'm confused that you're 26 because he has just like old soul wisdom of the universe vibes. But yes, love Jordan the Stallion. Hot Amazon 2020 said, recovering from knee surgery with my favorite YouTuber. Don't forget to ice, take your anti-inflammatories, stay off your knee and rest. And I hope that it is going well. When I was recovering from ACL surgery, I played so much PlayStation. We had a couch with like the chaise bit. So Dr. B would help me get down to the couch in the morning. It was very hard. I was not adequately hydrated because getting up and down to the stairs to go to the bathroom was difficult. And I was just like, okay, I've got my controller. I've got my like ice machine that circulates cold water. And I am playing a zombie game that starts in a mall, and I'm here for it. And then Grand Theft Auto, and then rewatched all of Doctor Who. I was like, we're here for it. ACL surgery takes time. So, when you need to rest, I'm glad we're here with court for you. Sleepy Tigress said they should survey jurors post-trial to see how effective the defense was in forming not guilty or not liable decision, e.g. Gwyneth Paltrow. So in Gwyneth Paltrow, there's a little different consideration, but here the defense doesn't have to prove. So they couldn't pull in this way. The defense doesn't have to prove that somebody's not guilty. The state proves that they're guilty, or the state doesn't prove that they're guilty. And if the state doesn't prove that they're guilty, then it's not guilty. The defense doesn't have to prove anything. The defense can sit there and not ask a single question. And if the state doesn't prove their case, it should be not guilty. If jurors shift, and this can be a problem with pretrial publicity, is like, oh, well, I've seen all that media about him and I don't know what the defense is going to do to show me he's not guilty. That shifts the burden to the defense, and that is not their burden. David Kamikaze said Dead Rising. Yes, it was. We were playing Dead Rising, me and T, a while back for like nostalgia. And he's like, why are these games so hard? I'm like, oh yeah, older games are for real hard. Like older games are challenging. A, games didn't release as often. B, they didn't have like DLC updates in the way that they do now. C, you had to be able to play that shit for hours and hours. They were definitely more challenging than the games today. Like y'all have fun with that, but Dead Rising was hard. So thank you, Miguelina. I appreciate that. EDB, are you going to Idaho for this trial? Wine Yogi, No, I'm going to be here streaming in my comfy chair. I cannot go sit in a pew seat on the hardwood, because then I couldn't stream. I would be in court all day long, which would probably take quite an early wake up to get into court, in court all day long, and then trying to summarize at night. No, I'm going to stream it because it's going to stream. I also can't move out of my house for the entire summer. And I'm definitely not bringing my kids to go to court every day for the entire summer. So no. Nope. Not going to court. Don't need to be in court. Gonna stream here from my orthopedically friendly chair. And that's hard enough. The court streams for long trials definitely take it out of me. I could not. I don't know how members of the media do it. I really don't know how they move to a jurisdiction to stand outside the courthouse and cover court before everyone goes in, then go sit in court, then cover it at the lunch break, then go back to court, then cover it on the evening, then go to bed, then get up and then do it again. I have no idea how they do it. Like when we're watching Chanley Painter still look flawless 6 weeks into Depp Heard after getting up, doing a live hit from outside the courthouse, being in court, doing hits of media over lunch, back in court, then doing like closing arguments in the evening. I have no idea. I have no idea how people do it. I couldn't be me. When I was doing my own trials, I was exhausted. It's tiring enough doing it from here. Music to My Soul said motion to add an app feature EDB Air Passport. Music to My Soul, you are touching on something that Team Baker has been working on because you're reading our minds. But this is something that we're working on for the member space of the app. So we will keep you posted, but this is something that we are working on. We have some fun app updates. Our first update was make all the notifications go real fast, and then we got to build in the fun stuff. I think Brian Edelman was also, I don't know which other case he was involved in. I know he talked about some of the other Idaho cases, but I don't know which one he was involved in. Let's see. Sleepy Tigress said, EDB coming in late. Has anyone referenced a TikToker? We won't see any references to the TikToker in this proceeding. It's not relevant to these proceedings. It doesn't really have to do with the media coverage. There's a whole ass separate defamation case. We're not going to see anything about that. Michael Love said, watching while studying. Michael Love, cheers to you, and we're here for it. Don't forget, we're going to take a lunch break in just a minute. Misconduct said, I love the member stream. I watched it today. We had fun. I ranted. Casey Cat said, isn't the point of voir dire to find jurors who, even if they know about the case, agree to put their bias and knowledge aside and follow the evidence instead? Casey Cat, yes. What the defense is trying to argue here is that won't work in this case. That even if people say they're going to put their bias aside, they can't, because brains and because the media coverage has been so much that they can't do it. But this is what the case law says. What you're saying is what the case law supports. But the defense is fighting an uphill battle with the case law to show that voir dire is not the remedy. And that's what that's what this witness was trying to show. So let's see. Jury should be made up of law nerds. Problem solved. We know way too much about the case. We're way too much about the case. Way. Friendly Farm Girl said, I like EDB collector pins. We are working on things. You know, we are nerdy. So Caroline said, how could I forget this was today, coming in late? Don't worry. We're taking a lunch break, so you've got time to catch up. We will, I will be taking a lunch break for an hour. I will send you a notification in the app. We will be a little bit behind court time to give us Zoom room. It is going to be a long day in court. Hydrate, get some food. If you've not downloaded the Law Nerd app, get the app. We're going to put on some of our, StreamYard music. We've had some very productive conversations with StreamYard. I'm optimistic. So I will keep you in the loop. I'm optimistic. They just added dark mode, which is really nice as a streamer. So Chetta said, collector pins, AKA pieces of flair. This is literally what I said in our team meeting, and this is how I think of it. I absolutely think of it as Law Nerd flair. Like 100%. 100% think of it that way. So, let's see. Young Black Economist said that 20-second summary was a lot better than watching The Expert. That's a really great compliment. Thank you so much. I appreciate it. Thank you. I like to digest information and share it with y'all. I feel like that's why I really gravitated towards, Emily, be honest. It's really why I gravitated towards fraud cases, because I couldn't distill large amounts of information. That my brain works that way. But I'm also nosy as fuck. And in fraud cases, you learn like all the tea. I think good lawyers just have to have a whole lot of creativity and curiosity. And if you're not curious, you're probably in the wrong field. It's like, oh, what about this? What about that? So ADHD doesn't work well for like the meeting deadlines and not feeling like you're constantly behind, but it works really well for the making unusual connections to things and maybe connecting things that other people would miss and then following those connections. So that's the superpower and the downside. But the downside part, other people can help with. And the superpower part, you can just do, which is why we're here. Law Nerds, we're going to take lunch. I'm going to put on some of our music. We love our music. So we're going to have a little jammy jam. Look, I will let you know when we are back. So if you have your volume on and you are vibing, don't worry. I'll give you a heads up when we come back. And you can still body double here in the chat with everybody. Make sure you get some food, hydrate, take a break. We will be back in about an hour. I will also ping you in the app when we are back. So, Law Nerds, I'll see you soon. What did I do? That's not the one. That is the one. We're going to do that one. We're going to do this. Bye, guys. I'll see you in a minute. Hello, law nerds. Welcome back from lunch. I hope it was good. I was giving the court some Zoom time, had to take a quick call, but we are going to get back. Remember, when we broke for lunch, the court was like, yo, we're not going to make like all of what's happening after lunch public. We're only going to make like some of what's happening after lunch public. So the court took lunch, then the court took a break so that they could do whatever they were doing outside the presence of the public. I'm sure we'll see reporting on it. There's reporters in the courtroom. We're going to find out. Like, they're going to tell us, but we're going to go back to what they deem they want to share with us. And you know, again, that is Ann Taylor's right to say, hey, for my client, this works better to do it this way. So for all of you that I'm seeing in the chat saying, I just caught up, great. For all of you that are like, we've got some Zoom room, this court has taken numerous breaks today. So yes, we have some Zoom room, which I love because like Zoom. It's like boom, bump. So we're ready to go. Emily, are you feisty after lunch? I'm hydrating. I still have a protein bar. I didn't finish all the way because I took a call, but you know, we're ready. We're ready to do the things and go to court. So judge, let's
bring the jury.
We're going to bring the judge. Oh, damn it. You know what I forgot to do? Chat, you reminded me of this and I forgot. I owe you an apology. I need get the gray hoodie. I forgot to add "not today, judge" to the soundboard. I'm going to do that because that's what we need. Do you remember Prosecutor Santa being like, "Not today, judge"? That's what we need. Okay, we're going to do this again. Take 2. We'll fix it in post. Not today, judge. Which has so many meanings because his last name is also Judge. All right. Let's make sure. Okay, that's not enough audio.
About that, but we're going forward now. Okay. Ms. Taylor?
Thank you, Your Honor. May I attempt to share my screen?
Back to Idaho, land of court recorded on a potato. All court recorded on a potato. These slides, man.
All right, Dr. Edelman, let's talk about community attitude survey. What is that?
Let's see.
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Okay.
Is there a specific way you set up to do a survey?
I might need to speed them up.
Yes, of course.
Can you tell us about it?
Sure. So
is there
a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial.
We're at 1.25. I think that'll work, but it'll kill some of those pauses in between. So, yeah.
And also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample.
This
Everybody
is
has
how they did
chance of being included. And the first section is a screener to assess to make sure people are jury eligible. So we have to live in the county, have a driver's license, or be registered to vote, be 18 and over, and so on. And then they're introduced to the survey. There's an introduction actually at the beginning, even before they answer a question, or they're told why they're being called. We're calling to get their opinions about an upcoming trial. and that their opinions are important because they were selected as a representative, household or whatever in the community. And then after they go through that screening process, they're instructed that there's no right or wrong answers to any of the questions. They can always report that they have no opinion or they don't know, and everything will remain anonymous. So the first few questions try to measure just basic criminal justice attitudes to get them familiar with the process, familiar with the survey, answering questions. And then they're introduced to the actual case, the case recognition question. And then if they know about the case, they continue and are asked prejudgment questions, open-ended questions to assess some key opinions, then case knowledge questions, which are recognition questions. And then they go into the demographic section, which is how they consume media. And yeah.
You mentioned 2 organizations, and I think earlier you mentioned that you were regularly a member of those organizations. Do they help set standards for how surveys should take place?
They do.
And tell me a little bit more about the introduction. Why do you do that?
The first introduction or the instruction after that? They get through the screener.
The introduction and then the instruction.
Yes. Well, you're trying to encourage people to participate to increase response rates, right? So you're told, again, why you're calling. It's not a sales call. We're calling to get the opinions of people in your community and why. So it's not just random. So they understand it's about an upcoming trial. We don't tell them what trial because that would clearly lead to potential response bias. And they're encouraged to continue participating because they represent their community. They were selected randomly. And then there's efforts to increase response rates by we do callbacks. So everybody, each number is called up to 3 times at different times of the day. So if somebody maybe is at work, you still have a chance
calling
to
me 3 times a day. I would never answer.
Soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy. Can you call me back? We try to find out when can we call you back.
We'd love to talk
to them later.
Nope.
Just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They don't have to, not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question, or I'm not going to answer that.
All right. So you did a community attitude survey in this case. Did you only look at Latah County?
No.
What counties did you look at?
So we
did a whole
did
a whole damn hearing over whether he was just going to survey Latah County. Ma'am, we know this. The judge knows this. We were all together the last time that you were fighting over not just surveying Latah County. Okay.
So we looked at Ada County, Bannock County, Canyon County, and Latah County.
I'm going to talk to you a little bit later about the 3 comparative counties.
We'll circle
but for now, can you walk us through your high-level findings for Latah County and Ada County?
Sure. So I think high level, you can see case recognition is very high. And it's also high in Ada County. It's 93% there. It's almost everyone in Latah County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. So this is extremely high. They're pretty much the same.
That's the case he
and it's not just a passing
recent high-profile case.
It's not that they recognize it but don't know much. You can see people in Latah County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder. And
these are much, much closer than I thought they would be. Like some of these are within like statistical thresholds for how close they are. Followed this case somewhat or very closely is not the number I'm looking at, but believe Bryan Kohberger is guilty, 68% in Ada County. That's a lot more people because it's a lot bigger county. Those numbers are surprisingly close to me. Like surprisingly close to me.
25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at
than the preponderance of the evidence. So
I'm sorry.
Second question is where. In a case like this, you're going to see high case recognition.
That was me, chat. I apologize. Hold on. Let me back him up just a minute. Ann asked a fantastic question, so I'm going to back it up. I'm so sorry. That was completely me. I was just checking to see if you were paying attention. I'm teasing. I'm sorry. I didn't want you to hear me crunching because then I'm going to get all of the like, oh my God, there were food noises. So I did it wrong. Sorry, chat. We're back.
And 51% reported what I call a mixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
To everyone that said, Elaine, your mic, I deserve that.
Look at the prejudgment, I'm guilty of murder. Am I using that term right? Prejudgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the prejudgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's two questions. One is,
great question.
Should the case be moved? Not where. It's should the case be moved? Has presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So second question is where. In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67%, 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So
they're saying even though the numbers are the same, it's more people, but it's still more people. That might be too close to justify moving. We'll see what the court does. It is more people, but it is a tremendous burden to move this case 300 miles away. So those numbers are much, much closer than I expected.
That's one variable you look at, but it's not just that. There's a host of other things.
First looking
extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors at play, and it's not just one item. It's the totality of the findings, not just one question.
Well, we do love a totality of the circumstances.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 49% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has.
That's a good argument for the defense that, look, in the county where this happened, people were incredibly invested because they were under stress while it was unsolved. That is a good argument for the defense. And I'm not surprised they're leaning into these numbers.
If you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside or running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Latah County. And that correlates to the sampling of things you showed us a few moments ago, just your sample of what's out there on social media, on Netflix, and that sort of thing. Is that right? It's higher in Latah County?
It is higher in Latah County. Now, when you say correlates, like I didn't do a statistical analysis, I would say that's the stuff, the content out there. That's what it looks like if you just do a search, you're following it. And on the anxiety question, that number for Ada County is about 32%. So it's much lower.
Looking at this slide, what does it mean with these differences we're seeing in numbers?
Well, to me, again, it shows personal connection. the personal experience. In a big county, there might be a sensational crime, but you don't see people feeling that way. Because crime is unfortunately frequent, and it might be something else that captures their attention, or there's so much going on. It's not shocking. Here, this is something when people talk about again. There's an idyllic community where everyone felt safe, and this person took it away from us. It was like shattering this sense of security and safety that we have, and everybody experienced it. And my guess is a lot of people can probably reflect on where they were when they learned this and how it impacted them personally.
We talked about that earlier.
What are we looking at on this slide?
I think you skipped a slide. Yeah.
He's like, I think you skipped a slide. I have my slides here. It's when the numbers drop off. When the numbers drop off, that
so
is
again,
where they're
this
going to
comes
argue.
back to personal connections. So 78% of survey respondents either lived or know someone who lived in Moscow when the murders occurred, compared to 20% in Ada County. That's not surprising, because if you look at the size of Latah County, it's about 32,500 people over the age of 18, compared to about 406,000 in Ada County. And I think it's like 66% of Latah County is in Moscow, so it's a huge percentage. So it's not shocking that people were here or know somebody who was here heard. And a large number of people are students or employees of the university. It's a quarter of the sample. I ran across one citation where it was 36%, so it's even higher, much lower in Ada County. You can see 40% of people have visited a home or walked by it where this crime occurred. And again, if you look at some of the opens, somebody talks about seeing the house from their office window. So it's a constant reminder of this awful thing that happened. These are things, again, that jurors coming into that courtroom will see. It's like indicators in the community of what impacted them. People may be fearful of people know they're on the jury and all those things because it's such a small community and people are so invested. And you can see that 22% of the respondents actually work or know someone who worked for a law enforcement agency involved in the investigation. 22% compared to just 4% in Ada County. So again, direct connections to this case.
Those direct connections, those are things that...
Those people, though, would automatically be yeeted. It's like, oh, do you know the investigators in this case? Generally, they would just automatically kind of be out of the jury pool, but we'll see.
Latah County juror would bring it. Is that right?
Yes, and that's where we see these big differences in national cases like this. This is typically what you see when the entire state is saturated with coverage. Everybody's going to know about it and have opinions to some degree, but it doesn't necessarily have personal connection. That's why cases like the Oklahoma City bombing case was moved. I mean, that was a national case. Everybody knew about it, but they still moved it because of the personal connections.
Now advance to the slide.
I wonder if he'll lean into the Valo.
Well, this goes back to case knowledge. So we talked earlier in the day about how case knowledge and impacts prejudgment and how we have this belief perseverance. So people develop these more complex schema and case knowledge. They're more resistant to change. And you can see almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey. Almost 80%, and 52% knew 7 out of the 9, or at least 7.
And in Ada County, 42% were familiar with 7 of 9 of the media items. So...
for those items.
Oh, I'm going to pause because I've seen a lot of questions in the chat about this. And so it seems like now's a helpful time to interject. Why are they just selecting Latah and Ada County? The defense wants to move to Ada County. They ran numbers and did surveys in other counties in 4 total. So they are saying, this is the county we're in. This is where we want to go. They're not telling the judge about the other 2, but they did survey the other 2, but they're choosing these 2 because that's what they are most interested in. Resume.
So they have a lot of case knowledge here. It's quite high.
While we're here, I'm talking about the media items. Did you test on every media item you could find?
Kate, you're right about that.
Did you have to select a certain number so that you could do the survey?
Kate reminded the chat that these numbers are a subsect of those who are aware of the case. So we're like drilling down. If you're aware of the case, how aware are you? And it's drilling down into the numbers, not the totality.
I read all the media coverage that is local, those local newspapers, and I'm pulling items that stand out, that are repeated quite a bit. So there's like multiple references to certain things and things that are inadmissible, prejudicial, things that are likely to have create bias and have impact.
All right. I want to talk a little bit more about how you set up the survey. What are we seeing?
So this should kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper and TV. to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's the recommendation, again, in the ASDC professional guidelines. We usually pick up 1 to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information questions?
Yes, it's actually even deeper. So you get the introduction. First you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right.
It's like, have you heard of this case? No. Okay, well, did you hear this? What? Okay, well, what about this? It's like, we're going to keep talking about Corey Richins because it was this week. Oh my God, are you following the Corey Richins case? Wait, what? The woman in Utah who wrote the children's book. Wait, who? She's accused of murdering her husband with like fentanyl in a Moscow meal. Oh, that one. So that's what they're trying to do here is like, you say you don't know about the Bryan Kohberger case, but do you know about these things? And then go down further and be like, oh, you actually do remember some of these things more than you thought. So trying to trigger the
answers. You can always say, I don't know. I can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information, and now I think he's guilty because you just told me he confessed, or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey is designed that way?
Yes.
All right, let's talk about some of the survey results. Walk us through what we're seeing here.
Okay, so again, the data suggests that this case has captured the community's attention. This is not a case where people have moved on. Almost everyone in the community recognizes this case. We're at 98% recognition rate. And it's not just a passive familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
All right.
Sorry for the ASMR typing if it picks up on the mic.
So this is one of the ways we test the validity of our survey. So we talked again, when we talk about the research, we know that people who closely follow a case, people who have a lot of case knowledge, are more likely to believe a defendant is guilty. So one of the things we would expect is to find a similar relationship in our survey, which indicates validity. And that's what we find.
This dovetails with what the last witness said. The more the people know about a case, the more they think someone is guilty. And I said it with the last individual, and I will say it again. It really depends on the case. In a lot of cases that go to trial, they are charged and they go to trial because the evidence is already quite high. High-profile cases tend to be more serious crimes. Those cases tend to get more investigation. There tends to be more evidence. Not always, because we've definitely seen cases, including civil cases, where we go in thinking one thing. Gwyneth Paltrow comes to mind. You go in thinking one thing and you come out and you're like, huh? Well, the more I know about this case, the more I think that this dude shouldn't have sued her. So it depends. But by the time you get a high-profile, serious and violent crime that is getting ready to go to trial, in a lot of those cases, there is overwhelming evidence. It's why the case was brought. So it's really difficult to correlate like, oh, well, if somebody was arrested, they're guilty. I don't think a lot of people feel that way. But the more you learn about the case, the closer you get, the more information that comes in like a preliminary hearing, you're like, wait, how are you going to defend that? Because now we've seen quite a bit of information. But there's also cases where you look and the more information you see, you're like, why is this even at trial? What are you doing? So I think that percentage correlates with the fact that this is a cherry-picked sample of high-profile cases, and high-profile cases have more money in the investigation, so they're not bringing charges unless they think that they are going to get a conviction. So there's some discrepancy in this just because of the nature of the cases that reach this level of attention and investigation.
So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely, within that group, the guilt rate is 84%.
And I think this case has
it's 73%.
Some questions
just kind of
in it.
Looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant's guilty.
Murdaugh's a good example.
The more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to have it.
I mean, The more I learn about
what did you
Richards.
learn about prospective jurors who are talking to each other?
So one is the fact they are talking to each other, and we don't always see that. Sometimes that's 40%, 50%, or even less in terms of talking about a specific case. And you can see here, it's almost everyone. 88% of people who know about the case have talked about it either in person or online. That's quite high, and they're following it, saying,
come on now, isn't this all high profile cases? If you are invested in a case, don't you want to talk about it with other people? I have bias in this because when there's cases I'm invested on, Emily, what do you want to do? I want to stream it with thousands of you, tens of thousands of you. That's what I want to do. So yeah, when you're invested in something, you want to talk about it.
Things on social media, they're watching, Netflix episodes or Paramount or whatever was on, seeing shows, they're seeing it in their news feeds. They're closely talking about it in a small community.
And if you're talking about it and if you're clicking on articles in it, then your newsfeed is going to give you more articles on it because there are algorithms to all of this. And if you express your interest in it once, you are going to see it till the end of time or until something shifts in your algorithm. Like it's just so much easier to opt into interest on something now because it's like, oh, you're interested in that? Here's all of it, which is a factor that they're going to have to talk about at some point.
So information gets spread.
Not in this hearing, but as we go forward into the brave, wide future.
Did you have an opportunity in your survey to learn more about different rumors and things that are going around in Utah County?
I did. So we asked an open-ended question after the prejudgment question, and then it should be what they know about the case and their opinion. And we asked what rumors or theories they heard in the community to see if they're regurgitating some of the stuff that's been on in the newspaper, on social media, the idea, again, of informal communication networks. In smaller communities, you tend to get a lot of like, well, I knew somebody who knew this person, or personal connections and information gets spread that way. And that's what we saw here. There's a lot of references to things that, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder in a paper.
What?
Or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made from years back, all that kind of stuff. And then references to him, having obsession with some of the victims, ritual animal killings. And these are just a couple examples. Like you'll see that stuff everywhere, but the amount you see in Latah County is much higher. Like, if you go through comments in Ada County, you'll find some too. You can find examples, and I'm sure if you go to Bannock and Canyon, you're going to see them. The case has gotten so much attention, but not to the degree you have here. And
these are things that are rumors in the community. So what he is pointing out is the things people on the phone said to them when asking about this case. Hey, what did you hear? Oh, I heard this. I heard that. So they're reporting what people in Latah County said to them. So this is a sampling of, what do you know about the case? Oh my God, well, I heard that he's obsessed and pathological and wrote a Reddit post. So that's what they're lining out now. They're not saying that any of this is true. They're just saying that this is what people who answered their phones and agreed to talk about the case said.
Given the size of the community, it's much more significant.
Did you record and document all of these comments in the actual survey report?
Yes.
Okay. And that's something that we provided to the court, and the state has no objection, so the court can read the full scope of the rumors from Latah County residents on.
Yes, this is a report on the hot goss in Latah. This is the Latah County chisme.
All right. What did you learn about Latah County residents that were related to Moscow, specific Moscow connections?
Well, this is kind of the unique nature of this too, that I see in cases like natural disasters, like wildfires is a good example, where it's this like collective trauma everybody goes through. So you can see 76% of residents here lived or knew someone who lived in Moscow.
Sir, I grew up in a time where we watched The Challenger on TV. So like I understand collective trauma. I don't know how much we need to get into it. I dropped my
at the time of the murders. So they either are here, the loved one is here, and it creates anxiety, right? So I think it was like almost 40% of students left during Thanksgiving, didn't come back because they were scared.
Yeah, it's a horrific case.
And you see that in the other questions. So asking about if people experience stress, anxiety, or fear during that search, and you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a crosstab. And the question is, did you or someone you know? It jumps up to 63%. So a large percentage of people were anxious and scared about their own personal safety or the safety of someone they know and care about.
Tell me about the open question about people's.
This crime shattered residents' sense of security and devastated the community. Okay. There's a
sense of security. People respond to that.
So one of the questions we ask is, how did this crime impact your community? And if I do this in a big county and I ask this, or big venue, federal case, you get a lot of, it didn't, or not much, or, I didn't live near it, so not me, or something like that. You get a lot of that. And I'm sure there's some of that here too. If you look at different venues, Ada County probably has a lot of that.
Homicide.
What really stood out to me was this
anywhere.
Shattering our sense of innocence, right? This is an innocent town and no crimes or horrible things ever happened here. And this guy took it away from us. We had this idyllic, safe community, and this person destroyed it. This crime destroyed it. And they talk about people, they never locked their cars before, their homes. I think one person said, he didn't even have a house to his key when he bought it, or a key to his house. That makes more sense. And suddenly people are locking doors because they're fearful. People are scared to go to their cars. Again, someone mentioned, you could see the house from their office, and students and staff would run to their car to be safe. People's partners were scared to go to the grocery store. And there were tons of comments about that. This idea that we have a safe community and it's never going to be the same. It's lost. It's our sense of safety and security. It's a special place, this tiny little place that's a bubble from all the bad stuff in the world. And then this thing happened.
The comments that you've depicted in this slide, is that all of them, or are there others for the court to take a look at?
There's plenty. On top of reading the other stuff, feel free to read all those opens.
Okay. What about the connection to the house where this happened?
We heard so much of this.
Well, I think it comes to again, this direct and indirect connections to this case, which makes it unique in Latah County, which you don't see it everywhere, is, 40% of residents who know about the case, which is pretty much everyone, have either visited the home where the crime occurred or walked by. And so there's this constant reminder of this awful thing in their daily lives. And
well, y'all tore it down. So doesn't that fix that?
Also, you see a large percentage of people are students or employees at the university, or connected to it, the investigation itself. 22% were connected to the criminal investigation. And then 25% were either students or employees of the university. And we know, if you look at it, the university is a big employer in this community. And when all of these students leave, it has an impact on the economy. Over 60% of the county is made up of people who live in Moscow. And if you look at some of the data, it indicates about 36% of people in this county are either students or employees at the university. So even higher than we saw in the survey.
All right. Okay. I want to talk about the prejudgment question. What did you learn?
So
tell me about this question.
This question is one of the indicators of undermining the presumption of innocence. So I look at it, I'm always looking, when I think about due process, is the presumption of innocence. And you see when it shifts to a presumption of guilt. So in this case, 67% of prospective jurors who recognize the case believe Bryan Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during Dahir, 66% of them already think he's guilty before they've heard any evidence.
Well,
and that's just the prejudgment question.
I mean, 67% of people who said they'd heard about the case, I think this is a subset, but he's saying 67% of all prospective jurors in the county, they're extrapolating out, think that Kohberger's guilty.
And that's not talking about questions. The other factors that you talked about, media awareness, case connection to the community, things like that.
No, that's just looking at everyone. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever. So that's just looking at the entire thing. You start looking at other things, that prejudgment gets even higher.
You've talked about what you've defined as a fixed opinion or a fixed presumption of guilt. What did you find about that?
Yes. So the question I ask is
couldn't he
basically
just
based
summarize
off. I'm going to start talking circuit now.
It's in your
based off of what you've read, seen, or heard. Would the defendant have a difficult time convincing you that he's not guilty? So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, what do you know about the case? And they would tell them some information or minimize what they know. And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing you that he's not guilty? And oh yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with the.
But that question, people are going to, especially neurotypical people, are going to answer the question that you ask. And if the question that you ask is, what would the defendant need to do to shift your opinion? they're going to answer that question instead of saying, well, actually, it's not the burden of the defendant to shift that. The question is faulty. If people have agreed to answer a survey and agreed to be helpful, then they're not going to, well, actually, your question. Some of us will, but most people who've agreed to participate are like, I'll just answer what you asked. So if the question is, what would the defendant have to do to prove that they're not guilty? And then you argue, see, these people say the defendant has to prove he's not guilty. It's burden shifting. It's a tremendously loaded and unfair question. So I don't love that question.
Other indicators of bias, so it seems to be more of a valid question. And when I did it, you see basically 51% indicated a strong opinion that we shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair if you.
So 200 people said that? Is that the frequency?
But this doesn't mean they can't. We heard a lot about that earlier today. Yeah.
That's why you don't ask leading questions.
And did you ask
court.
Similar questions at prejudgment for guilt, I guess prejudgment for the sentence?
Yeah, so because this is a capital case, I did ask whether or not which sentence do they believe the jury should select if he's convicted. And you can see 52% reported that he should get the death penalty based off of what they've read, seen, or heard, whereas just 23.5 or 24% reported that he should get life.
Did you ask a fixed question about the penalty?
Yeah, so I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death, and that you couldn't convince them that it should be life.
There's a question at the top. Given what you have read, seen, or heard about the case, would Bryan Kohberger have a difficult time convincing you that he should receive life without the possibility of parole instead of the death penalty? They shifted the question. It took me a minute to find the question in italics. It's there's a lot happening, but that's the direct question. And the question, the way you ask the question is going to get you the answer that you are seeking. It's like, these aren't the droids you're looking for. You have mind tricked with the question. However, the state could have done their own surveys to rebut this with different questions. And the state chose not to do that. That's the fix to these questions, is the state doing their own surveys with their own expert, and they didn't do that.
Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
This is a small community.
Somebody said they would burn down the courthouse? Folks, when you're taking surveys to be used in court, hyperbole is probably not helpful. Hyperbole in text also is probably not helpful anymore, but okay.
What did you learn about the impact of this case on this small community and the pressure of a juror in Utah County to do this?
So one of the things I wanted to look at, because it's a small community and people know everyone, and the pressure when coming in and out of this courthouse on a day-to-day basis, when it's been inundated with journalists, and my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that.
No, sir. They learn it at the Piggly Wiggly.
Is there pressure? If the jurors ever feel pressure, like there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments on a range of themes, from people would basically kill him.
The thing is, these are people that have answered their phone, agreed to talk about this case, and wanted to be heard on this case. So I wonder how much of an opt-in you get about people that already have a strong opinion on the case, because most people are like, I don't know what you're talking about, I don't want to talk to you. So when you're self-selecting into people who already want to tell you what they have to think, and that makes it hard to survey in this way too. I don't know how to fix that problem. I am not a researcher, but it seems that the people who are like, yeah, let me tell you what I think, probably aren't advocating one way or the other. Well, are probably advocating stronger for guilt at this point, because they are being asked to talk about a case that impacted them, but they're the ones who chose to speak. People are like, yeah, I don't really know about any of that. Aren't going to talk to you.
They burn the courthouse down, or assume that the jury failed, or that he would have to prove that he was not guilty. Again, shifting the burden. So it's like, I can't imagine that.
Sir, if you're saying that he would have to prove that he was not guilty after you asked the questions with that language, and it seems that we're going in order, then you've already set them up in that mindset. It's like when you cross-examine a witness and you get them saying yes, 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 yes. And then you ask questions where the answer shouldn't be yes. And sometimes they're like, yes. And then they're like, wait. And you're like, we're going to keep going. Patterning your questions also can impact the way people respond to you, because brains, and this is a lot of, well, he'd have to prove it to me. You already asked them about that. So, but people don't have to say all the hyperbolic violent stuff. So there's that too. Some people are mad. People are mad about some cases.
Because they have so much evidence against him, we would be dumbfounded. Like, how could he not be guilty given the amount of evidence? Several would be on the hunt for him to make sure he gets what's coming to him. And then just emotional stuff about it would be devastating to the community. Other people talked about the fear if he didn't do it. Well, who did? Like, that means this person's still among us, who creates the same stress and fear and anxiety that people had before. So this community needs closure. And you have to imagine what that's like for a jury for months on end, in and out of this courtroom in this tiny community, and trying to explain to their neighbors, what they did and why. And that shifts the burden again back onto the defense.
The comments that you've captured in this PowerPoint slide, is this all?
Yeah, these are just a few examples.
Plenty more for the court to read?
Yeah.
Your Honor,
did you ask
here
these
is a
open
book
questions in the
about all of the shit people said?
Yes, it's the same question as in all the counties.
The thing is,
the other counties,
the people who said all of this, we're going to get to other counties. The people who said all of this would say all of this at voir dire. Do you have opinions about this case? Your Honor, let me tell you. So these also would be the individuals that would be pretty easy to yeet.
As high of rate in these kinds of answers, do they have a similar kind of answer as Latah County potential jurors did?
No. Now you can read through it and you will find answers that people would be angry and upset, because you're talking to hundreds of people and you're going to get those. But they're much less strong. They're much
thousands,
more, no opinion. They wouldn't have an effect, things like that you see in other places. Very few people in Latah County have that.
All right. I think we have a couple of slides on the questions that were in the survey. I think we know those.
Yes.
It came up.
So these are our case recognition questions. We call them.
It came up quite a lot in the last hearing.
Recognition items, I guess. So we do ask an open-ended question. What have you read, seen, or heard about the case? We'll get into that, but that's the typical question you ask in jury selection. And people answer that, but they often use minimization language or unable to recall everything. So we ask later on these case recognition items to see if they're familiar with widely reported media items. And if you look at the professional guidelines, this is what's recommended. So you first ask an open-ended question, and then later you follow up with these close-ended questions.
What did you learn when you did that in this survey with Latah?
So I'm not going to go through all of them, but we learned that people are familiar with many items that have been widely reported in the media. And you don't always see that. Sometimes case recognition is high, but people don't know a lot of detail. Maybe they know a few items or recognition rates are 40, 50%. But what we found here are people have well-developed attitudes and opinions and ability to recall a lot of prejudicial content. So in Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right?
Yeah, it was a 9.
If they knew 7 or more, then he says they were more likely.
I think you mentioned, but I think your chart's going to explain to me why more media items, more media recognition items correlate with the prejudgment question of guilt.
Yeah, and this goes back to validity of the survey. We know from earlier research that case knowledge is correlated with prejudgment, and that's exactly what we found. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to have developed a perception of guilt. So people who are familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested. You can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. and you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he was a difficult time convincing them.
I had heard that, but that was everywhere.
What about what? Another media item?
So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match.
We heard all this in the last hearing,
and you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail, and 82% of those who do know that believe he's guilty. Quite high.
How about the cell phone tower media item?
So on that one, you see a case recognition rate or item recognition rate of 79%. 79% of survey respondents do that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media item studies?
So this would go down to like
this I had not heard until the hearing last
detail
time.
That was widely reported that the defendant had stalked one of the victims, and you can see recognition rate currently at 45% when the survey was done, and 81% of people who knew that detail reported that he's guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media. 45% recognition rate, and 79% of those who know that believe he's guilty. And these are all statistically significant findings.
Let's talk about some of the comparative counties that you surveyed, and if you can give me a high level of your key findings in those cases.
Sure. So now, in my mind, this shows significant bias, that there's a reasonable likelihood that the due process has been undermined in the sense that there's a presumption of guilt in this county.
We know that you feel that way.
If you were to move it, where would you move it? That's question 2.
We're on to the second part.
We're on to the second part. That's where this comes from.
Where is
So
Bannock?
you'll see recognition rates are high in these 3 counties we tested. So we tested Ada County because it's the biggest county in the state. It's about 406,000 people over the age of 18, and other high-profile cases have been moved there before recently. Canyon County we picked because I believe it's the 2nd largest county, and it is also near Ada County. So it's a big county. We picked that, and we picked Bannock County because it's just far away.
Other cases
it had
moving
less media coverage, so we wanted to see if there was a possibility that people would have less case knowledge there. And you can see recognition rates vary from 90% to, from 84% to 93% across those 3 cases. And you can see
are not that different
in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher. The guilt rates are essentially the same, or it's a little higher in Bannock County. But because of the population size, there's a big difference. So again, you'll find about 16 times more people in Ada County who have not prejudged compared to here. And then similar in terms of the strength of opinion and difficulty in convincing them that he's not guilty, similar to what you see here.
Idaho for
and
answering
sentence
questions
similar as well, so that 49 to 57%. So these numbers are also high.
Where do you start to see differences that matter?
You start to see differences when you talk about personal connection. That's where the big differences come up. So remember, we said 79% of people in Ada County had talked about this case. Might be wrong, might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Bannock, so it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other 2 counties, it's only 11%. It was 39% in county here. And then whether or not they know someone who experienced higher levels of stress, we had 45% here. Here we're down to 24, 19, and 19. So you see big differences there in terms of
we'd like
the
to go
community
to a
connection,
chiller
the personal
county.
connection.
Vibes are better.
What about the connections to Moscow that are unique to this area?
Yes, so just 20% in Ada County know someone who lived in Moscow, 15% in Canyon, and 16% in Bannock, 78% in Latah County. Whether or not they were a student or employee in Latah County, that was 25%, and we're looking at 4%, 3%, much lower. Whether they visited the home or saw it, Latah County is 40%. Here we're down to 8%, 3%, 2%.
So we did see the numbers for
whether or not they knew someone who actually was involved in the investigation. In Latah County, that number was 22%, I believe. And in Ada County, it's just 4. Canyon is 2. Bannock is 2. So much lower when it comes to those type of connections, the personal connection.
Yeah, I'm not surprised that people that live in Boise don't necessarily have direct connections to people who work in local law enforcement in Latah County. We're not surprised by that.
What about the recognition of media items?
Yeah, so we had, I think it was 79% in Leda County knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Bannock. If they do 7 or more, that was 52% in Leda County. It's just 42% in Ada, 27% in Canyon, and 29% in Bannock. So less case knowledge. And we know case knowledge comes back to belief perseverance, right? So the more you know, the more resistant your attitudes are to change, the more likely you are to attend to and process information consistent with what we know. New information about the DNA evidence, I already know about that. That's credible, I get that way. So you're much more likely to see that in Leda County in the future.
All right. I think you told us a little bit about the population size. And is that why you selected Ada as the population size?
So I'm not selecting anything. I'm just pointing out some possibilities. So I selected Ada County in terms of to do the survey because it's the largest county in the state. And it was a Dale case was moved there. So you know that they can take this case in. Right. We know large counties, it's less of a big deal when the case moves there. It doesn't become the biggest story in that community. So I wanted to test Lake County. Pick Canyon because it's the second largest county, over 184,000 people. And then I picked Bannock because it's further away. It's quite far away, hundreds of miles from here, and it's in a different media zone. It does have some of the similarities of Lake County.
Far away.
So, for example, there's a university there that's the second largest employer. So there's a risk there. But 18% of the population is connected to that university. So there are those risks. And I think the problem there, while some of the numbers are good, it'll become a huge deal if that case is moved there. You're gonna have the media circus move from here to there, and it's gonna become, again, a huge story in that community. So there is risk if you choose a smaller venue that something like that. Wow.
And that risk is tied specifically to the size of Bannock County?
Yes. Smaller counties, you don't have stories like this regularly happening. So it's more likely to become a big deal in that county. And you could end up with significant bias between the time the case is moved and the time it goes to trial, because there might be an increase in media coverage there.
Interesting.
When we talk about the survey itself, was it only people who knew about the case that took the survey?
No. Explain to me what you mean by that.
Well, I'm looking at your slide here about people who, whether or not they know about the case, do they finish the survey? I think one of the things the state's criticized about is a non-response bias. So I want to understand if you can tell
what we were mentioning earlier.
About how the survey works, this one and others.
The people who don't know don't answer.
One thing we do is we do comparison surveys in a host of different cases. So if you look at other cases we've done this on, if that were true, you would find that only people who know about the case take the survey in the comparison county as well, right? So you can see in Renfro, this was an Idaho case, in Kootenai County, 89% of survey respondents recognized the case that took the survey, that completed it. In Ada County, 67% of the people that completed the survey did not know about the case. So you would expect you wouldn't see that trend. If people just say, I don't know about this, I'm not going to take the survey, I have no opinion.
That's a much clearer reason to move that Renfro case.
Similar trend. So in Davidson County, 67% of people who completed the survey knew about it.
I actually know where Davidson County is. I feel like I've lived here for a few years. Chat, do you see a staggering difference in the recognition of the case numbers in these cases vis-a-vis the Kohberger case? Because all of these seem to have a dramatic difference in how many people recognize the case. It seems that the numbers in the Kohberger case are very close, which means the entire state may be saturated, where in these cases, there is a clear delineation of people that recognize the case versus not recognize the case, except in the Minnesota case, which I think is probably the most high profile and most recent case where you're seeing across different counties, everyone is aware of the case. So it's just interesting to see the top 3 cases, a staggering difference. And then the bottom case, everybody knew.
Case. In Hamilton County, 84% of people who completed the survey did not know anything about the case. In the United States, v. James Cloud, which was in Washington, you can look at, we did 3 venues, and in Yakima, 55% of the people that completed the survey knew about the case.
So Washington.
In Richland, 82% did not know about the case. In Spokane, 90% did not know about the case. What's unique and why you see high recognition rates across the surveys here is because it's a national case. And when we have national cases, you see high recognition rates all over. So this last one, the state of Minnesota, the Alexander King, was the George Floyd case. And you can see high recognition rates in all the counties, just like we see here.
Everywhere.
The reason is because there's a lot of media exposure everywhere.
Because everybody knows.
It's not that people are hanging up because they don't want to take the survey. In fact, if you look at the call data, after they were told the case recognition question and described the case, only one person hung up out of the 1,200 people that completed the survey. And one person who terminated the survey after being told what the survey was about.
Everyone else, all 4 counties?
All 4 counties, one person.
All right. We have talked quite a bit about the bias and the prejudicial media coverage and the difficulty, the impossibility that will happen seating a jury in Latah County. I want to talk a little bit about jury selection in cases that have a lot of publicity. Are you familiar with that?
Sure, yes.
All right.
She's going to whether or not. Why did you make this look like text bubbles? That's such a weird choice. What she's getting to is there a solution that doesn't involve moving the case 300 miles away? Can you voir dire around it? Can you do jury selection around it? Can you move around it? So is there anything else that can be done? So the prosecution's going to argue that, yeah, everybody knows, so we'll just voir dire. That's what it is. We can resolve this in another way. And they're going to argue there is no other resolution but moving it. But this is just an odd odd template choice.
Why should we talk about this now? Why do we not want to just wait and try to pick a jury first?
Well, I think first of all, I've done a lot of jury selections. I'm sure you have. Your Honor, you have, I'm sure you all have. So we all know how the jury selection process works. So in a normal case, people do not have case-specific attitudes. And we know specific attitudes are predictive of behavior. So I might just have a general passing attitude towards something. I mentioned DUI, or it's like a contract dispute. Like, you can ask me questions. I don't have strong opinions. I don't know anything about the case. So they're not specific attitudes. So jury selection is effective in that scenario. It's fine. But when people have case-specific attitudes and case-specific knowledge, and I've heard information and evidence, even if it's coming into trial, I heard it in the context of a news story. There's no rules of evidence that were applied. There was no cross-examination. There was no counter expert to refute what was said. It was just said by a public, speaker who was on an editorial on a television station, Nancy Grace. So it's very different. And then when I hear it as evidence, it's just confirming what I already know. It's not new, not processing it for the first time. So that's one of the big problems. So why you need to identify people that have that content and information. And there's challenges because of the way memory works. Recall is limited, and we'll get to that. But when you ask people, what do you know about the case? They are not able to give a full account of everything they know. So it's very hard to assess what people know, which makes it very difficult to exercise cause challenges and predicate challenges. And the other thing is just the nature of jury selection. It's very easy to rehabilitate a juror to get them to say they can be fair.
Thankfully.
It happens all the time. So a juror says that I had this experience where I think I'm leaning towards one side. It's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. Give leading questions. In one study, they actually analyzed a transcript or 3 trials transcripts, and it was like 60% of the comments during voir dire were from attorneys and judges. Just 40% were from jurors, and 63% of the comments from jurors were one-word answers. And I see that in the post-conviction stuff I do when I analyze transcripts. It's 3 pages of indoctrination into what a juror is supposed to do, ending with the closed-ended answer, can you set it aside? That's not an indicator of what their ability to do.
In 2024, people are very adept at, like, wait, am I allowed to say this? Yeah, that's a thing. Socially desirable.
I think we may have covered voir dire and honest disclosure with that, and I didn't.
Socially desirable responses.
Can you give us a case example or an example of this?
Sure. So this is an example of stealth juror. So a case like this.
Why are you bringing Coolio into it?
There's a likelihood that people want to be on this case, right? It's a high-profile case. It's going to be on TV.
Out of
get a lot of attention. There might be a desire to seek justice, and you want to be involved in that. Well, how do you identify jurors like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division. Rampart. And basically, there were a number of corrupt police officers who were.
I would love to have a conversation with this man about Rampart. That would be fascinating. Because holy shit, if I ever get to do a historical look back of things, Rampart would be one of them. Like the 90s, we're going to see that with the KPD trial. We're going to get back into everything that went on with the East Coast, West Coast rap wars. But getting into Rampart would be fascinating. Just fascinating. And yes, chat, he is saying, Tracy said in the chat, oh my God, he's saying the jury is looking for their 5 minutes of fame. Yes. Tracy, yes. Tracy, he absolutely did that. Oh, I would love to hear what he has to say about Rampart. Anyway.
Stealing drugs out of the evidence locker, shooting suspects and planting guns on them. It was these rogue police officers. And one of the
this
people,
all ties into the KPD stuff too.
He had been shot by a police officer, this guy Perez, who then planted a gun on him and alleged that Obando had shot at him. So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of a locker room. So he confessed to all these things, and Obando was released. He got like a $20 million settlement against LA County. Then he sued the public defender, claiming that, they should have figured this whole thing out and known that, there was a scandal and so on. And it won like $6 million in that case. And then later, when they looked, it turned out that one of the jurors on that case had been in a movie about the incident called Gang Wars. And when they were asked, has anybody had a connection to the case? She didn't raise her hand. But during the deliberation,
I'm sorry. I'm not sorry. I'm not sorry. I'm not sorry for interrupting. You're telling me the most LA shit ever, that a juror said that they knew nothing about a case and was in a movie with Coolio about the case titled Gang Wars. That is the most LA shit I have, one of the most LA things I have ever heard. There is nowhere else across this land that you are going to hear somebody being like, and after the fact, we learned that the juror was in a movie about it. Fucking LA. So LA. And now I am going to have to find who the prosecutor was in that criminal prosecution, because I am dying to know. I am making a note. I feel like there is a dark history of the Emily D. Baker variety around this story. There is so much I need to know. Sorry, I'm going to try not to ADHD tangent.
She talked about stuff that didn't come into trial, and it resulted in a mistrial. So that's just one example.
And it resulted in a mistrial.
But yeah, so that's one challenge you have in a case like that.
All right, recall and recognition. I think you're going to talk to us about how hard it is to ferret out what somebody knows.
So to me, this is one of the biggest challenges in high-profile cases. So the question you ask on the juror questionnaire and open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is, on the spot, I need to search my memory and see what's accessible and salient and what I can remember on the spot. And I'll tell you. and then you usually follow it up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the trick.
Vader in German literally means father. Also, why didn't R2D2 ever tell him? I'm just saying.
The thing is, you can't ask people, have you read?
Nightbot is going to be like, please stay on topic. Yes, Nightbot, I know.
Seen or heard if the defendant was stalking one of the victims, because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical case.
Have you seen that bear itself out in a real case?
I have.
This made me cackle.
This was a case in Texas where we actually had community.
I have now disassociated from this testimony entirely because we heard it all at the last hearing and we are not moving through it quickly. It doesn't mean it's not important. It's just late in the day. Ivana said Nightbot isn't happy that you're talking shit about other robots. Facts.
Members come in during the venue hearing and treated them like mock jurors in a sense and asked them what they knew about the case, and they told us. It was a big case at the time in Hidalgo County in Texas. And people told us what they knew. And then we asked, is that everything you know? And they'd say, yes, that's it. And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, well, did you know that he allegedly confessed? And then it would stimulate a memory. And the person would say, oh yeah, I did know that. He actually confessed twice at a monastery. So it triggered a memory. And then it was, well, is that everything else you know? Do you know
it triggered a memory, or you gave them the information?
Anything else? And they say, no, that's it. And say, well, did you ever hear that he had committed another crime? And they say, oh yeah, that's right. He actually attacked another girl at a different church in a nearby town. And it was, well, is that everything you know? Take your time, search your memory. I think that's it. And then we do it again. And it was, well, did you know there was a cover up? Oh yeah, the Catholic Church covered it up, and the police department, and it just demonstrated the problem. Now, that was fine in that little demonstration we did, but you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial.
This, though, he's want a little bit for me at this point. This is a very fair point, which is why I am pausing so you can hear the sounds of my voice and maybe break up the cadence of his. This is a very fair point. If jurors say that they don't remember a lot about the case, but might remember more when prompted, you can't do that in voir dire. So then how do you know that the juror might know more if you're not allowed to kind of prompt their memory in voir dire? It is a fair point and a fair question, but you do give facts of the case when you bring the jury in. This case is called this. The facts of the case are this, and you read it through. And if those facts don't prompt it enough, then you're kind of out of luck. So it's a good point, but also it takes out of context the fact that the jurors are given some of the specifics about the case before they're asked to sit on the jury.
When you don't know what they know.
Do we have a glimpse of how that works in Bryan Kohberger's case based on the search warrant?
We do.
All right. How do we know? Tell me about that.
So we always use the open-ended question. What have you seen or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items, to see if there's additional items that they actually recognize that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, what have you guys seen or heard about this case? Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific.
What do you know about this case? I don't know, just what was reported. Oh, okay. You want a dissertation? Because, okay.
Detail. But later when we asked those close-ended questions, that person knew all 9 of them. Another one is just what I've read and seen on the news and newspapers.
All 9 of them were on the news and newspapers.
Read articles about the case. Knew 8 of the 9. Just what I read in the papers. Same as everyone else. 7 of them.
But your questions come from what's in the papers. What do you know about this case? Just what I've read in the newspapers. And then they proceed to say, okay, did you know this? And they're like, well, yes. Well, those are all the things that were in the newspapers, sir. The questions were pulled from the media. So when somebody says, I read the media, and you're like, oh, you're minimizing. Sir, they're just giving you, okay.
So these are just 2 examples.
Not my PhD.
This is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high-profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well-developed schema and attitudes in case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that hadn't reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognize this item when we ask, have you read, seen, or heard it? But when we ask them the open-ended question, what have you read, seen, or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item but 45% actually recognize.
But how many people, if you ask them, oh, did you hear this? Are going to go, oh, yeah, I might have heard something about that. Even if they didn't, because now you've said it to them and they're like, oh, maybe. I don't know.
Later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Bryan Kohberger allegedly stalked the victim? So that's a difficult position to be in.
Let's look at one more example.
That is a difficult position.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items.
I think all the people that said what's been in the media, this has been heavily in the media. I think this is inclusive in what's been in the media.
That are correlated with bias. We know that there's a high rate of recognition in the community.
Not opt-out.
But when you ask in jury selection, what have you read, seen, or heard about the case? Very few people mention it. This is what you see.
All right. The magic question, can you set it aside and be fair and impartial? Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So,
sir, you're being paid for this question.
That question.
This is the. Now he's being coy. This is what you're being paid for, sir. Everything breaks down to when the judge says to the jurors, can you set aside what you know and be impartial and fair about this case? You're supposed to say no so we can move it. Like, move it. This is the entire point of your testimony. The whole point. And he's like, wait, what? He might have zoned out on his own testimony.
All right. The magic question, can you...
She even said it's the magic question. Sir, what more of a cue do you need?
Set it aside and be fair and impartial. Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help?
Will it work? What does work mean? I don't know if you think that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And it's not. There's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it.
Dude, leave people's Facebooks out of this, man.
I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert.
Okay, I do kind of want to talk about Jinx, though. All right, I'm not
first, who had been a suspect for multiple murders. His wife, he went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this miniseries on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, of course I shot them all, or of course I killed them all. He's talking about himself. So
don't misquote Jinx. Don't make a sick John Lewin on you, sir.
It was a highly prejudicial documentary.
John Lewin, by the way, friends with Alan Jackson. That's to tie the 6 degrees of separation back to everything.
And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, this is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested. So if somebody said this in public about this case, I think we all agree that person probably can't be fair. You're publicly.
Okay, for those of you asking what is Jinx, he just explained it. I'll explain it again. Jinx is an HBO 2-part, multi-episodic 2-part breakdown of the Durst case. So it's called The Jinx. It is, I think, well done. I haven't gotten all the way through season 2, but anyway, it's talking about that case and then Excuse me, what people are saying on social media about that case.
Stating it to the world. You think he's a sociopath.
It's a good show.
So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case.
So they went to Facebook and are like, so you called Robert Durst a sociopath. We'd like to ask if you could be a fair juror.
Whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we recruited said that he could not change their mind about his guilt. So almost everyone.
Okay, I'm done with Robert Durst, I swear, but the judge who presided over the Robert Durst case is one of my favorite jurists ever. I adored working with him when we were at the same courthouse. I'm done. You've triggered Emily. We've talked about El-Alayli a lot.
Case recognition questions, and many of these are either inadmissible or very prejudicial. That he was like a suspect in his wife's disappearance. Probably not admissible in a different case. His murder trial in Texas. We asked several of these. And the confession, the captured confession. You see, 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, I cannot be fair and impartial. There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence, common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change your mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why.
But did the person who called him a sociopath say they could be fair and impartial? Like, what did everyone say in this Facebook group where some people are like, wow, Jinx was really good. That's wild. Like, there's a level of comment.
Our person Smith, who mentioned that they were overjoyed by his arrest and they were physically ill, that Robert Durst was a sociopath. Well, they, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning.
So you know exactly who the person was you were
presented and follow the directions and wipe out everything I know.
So this is
I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated as a fair and impartial juror, which demonstrates like a person like that should be answering that question no, but they don't. And even kind of going back to the Rebuttal case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that threw out the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair, and the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
What's up, George? Okay.
All right. Based on your years of experience, your education, all of the work that you do in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments, do you have an opinion about this case and whether we can seat an impartial jury in Lake County?
I do.
What
is
your cats?
So my opinion is, again, is based on whether or not there's a reasonable likelihood, so using that standard, which is less than the preponderance of the evidence. Lake County is a small venue. The crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrate their experience fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convince. I think given the reaction that people think the community would have if he's acquitted, that's particularly concerning. We know from the data that jurors have closely followed the case, they've talked about it, they're familiar with prejudicial details. I think that the presumption of innocence has been undermined and a presumption of guilt prevails in this community. And I think the pre-existing attitudes and opinions will influence how people process evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence. I don't know about the videos versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter that is consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy, given the research I've done, my experience doing jury
That's the
selections,
answer
and the
that
nature of
she
how
was
memory
looking
works.
for.
So taking all that combined, I think it's appropriate to change that.
Yeah, that's
Thank
the
you.
answer she was looking for.
I don't have any other questions, Your Honor.
Can
And,
voir dire
Your Honor,
remedy
I
it?
think statement.
Oh, we're
Okay,
finally to
thank you,
cross.
Ms. Taylor, so this would be a good time to take a break.
The judge is like,
And
I
we'll come
am
back
numb.
at 3:20. Thank you.
He's like, peace. Remember, they are in Pacific time. We're gonna zoom. The court's like, I am done. Let me up. Kohberger doesn't seem to be cuffed or shackled at all. He just like got up and walked out. Okay. They should have court break music. I should talk to the court and be like, hey guys, so we've got a solution for music. We're going to zoom back to court. I love having zoom time. And we're on 1.25. So that helps
and then
us
to provide rebuttal testimony.
That helps us zoom even better. So let's, we've gone too far.
All seated already? All right.
All right. Judge, like, doesn't even look like he has leg shackles on. Interesting. So Judge is coming back on the record. We are after break.
All seated already? All right. So we're back on the record. This is State versus Kohberger, case number CR 29222805. Kohberger is still in the courtroom along with counsel and also counsel for the state. And Mr. Edelman is ready for cross-examination, I believe, and you're still on your oath. So go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Oh, okay. May this witness be excused.
You may, Your Honor.
Okay. Thank you. You're free to stay, free to leave. Thank you. Appreciate for you being here.
I appreciate that.
Okay. Another witness?
Yes, Your Honor. Our last witness is Dr. Dahir.
Dr. Dahir. Okay, I thought maybe Dr. Dahir was going to be...
I thought Dr. Dahir was rebuttal. That's what the witness list says.
To the state?
That's what the witness list said.
Your Honor, we disclosed Dr. Dahir twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony.
Man.
Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but would ask that she stay for that if that's the case.
Okay. So Dr. Dahir, line up.
Okay.
Please face clerk. Raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be.
I apologize, and I regret to inform all of the chat. Humans of the chat, Dahir is spelled Dahir, not Dare. Apologies. Bone Arrow said, why not cross, Emily? Because they already did it in the last hearing. So they're just like, no, we got what we needed. They're just going to argue the numbers. So they tangled with him once before, and we're like, we're just not going to get into that today.
The truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes. Thank you. Now, please have a seat, and then once you're seated, please state your name and spell your last.
Hello, Dr. Dahir.
Yes, Veronica. Dahir, Dahir.
Ma'am, I need you to find a partner named Danger. I would love to see like Dr. Veronica Dahir Danger, like Ph.D. by day, crime fighter by night. I am scripting an entire series in my head because the last testimony was so repetitive that my brain is desperately seeking anything else to do at the moment. And right now what we are doing is scripting an entire superhuman multiverse around Dr. Veronica Dahir. A book series. We're ready for all of it, Doc.
Ms. Taylor?
Thank you, Judge. Good afternoon. All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno. I'm also the director of survey operations for the Nevada Center for Surveys, Evaluation, and Statistics, also at the University of Nevada, Reno.
Oh,
do you also do consultations?
That is where the last expert got their degree.
Outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
Fair.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
I have a bachelor's degree in psychology and a master's and Ph.D. in interdisciplinary social psychology from the University of Nevada, Reno. My master's and Ph.D. are from the University of Nevada, Reno. In terms of my work at the university, I have a joint appointment, as I mentioned. I run two different research centers at the university. One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is a survey lab. I also teach in the Judicial Studies program. I teach a graduate level course called Scientific Research Methods for Judges, which is a course for judges getting their PhD across the nation. They're sitting judges that are on the bench. I teach another course called Scientific Methods for Justice Management Program, which is a master's degree program at the university. I have taught social psychology, criminal justice research methods. I've taught other courses, but that was quite a while ago. Right now, I'm just teaching this graduate level course. I serve on several dissertation committees for various departments on campus: social psychology, School of Public Health.
It sounds like you are very busy in higher
natural sciences. There's many. I serve as a dissertation advisor and committee member for students that are getting their degrees, and primarily in the Judicial Studies program, I have served as an advisor and as well as the social psychology program on campus. In terms of my role on campus, I do primarily, let's take the Sawyer Center first. We do research on justice-related topics broadly defined. My background is social psychology with an emphasis in justice studies and law. And so our research that we've been doing there is specifically related to research in the justice system. We have many different populations that we research and do surveys with, including jurors, judges, attorneys, both defense and prosecution, court reporters. We've done many surveys on diverse populations as well, including people experiencing homelessness, LGBTQIA populations, the elderly, prisoners, inmates, Native American populations. So we've done many surveys in that capacity. In my role as the survey director for the Center for Surveys, Evaluation, Statistics, I am in charge of multiple research projects that have to do with surveys nationally, regionally, and locally. Most predominantly, the one that we have been doing since I've been there in 2006 is the Center for Disease Control and Prevention, otherwise known as the CDC, their BRFSS survey, which stands for Behavioral Risk Factor Surveillance System. I am the project coordinator for Nevada, and I've been doing that role since 2000 for the state of Nevada for the last 3 years. But before that, I was the data collection supervisor for this project since 2006. So I've been working on that project for quite a while. Prior to my role in both of these programs, I also worked on surveys. I've been doing, I would say, surveys and research for almost 30 years. Since I've been a graduate student, and even before that. So not before graduate student, well, I did research, but before my role in this area, I did research. Most predominantly for the Sawyer Center, we did a nationwide survey on DOCKET, and it entailed 400 randomly sampled judges across the nation. And we looked at the effect of DOCKET on judicial decision-making.
Chat, I will pause and have Dr. B say hi. The chat's like, pause and have Dr. B say hi. All of our brains are desperately seeking something else to do. We've heard lots about PhD backgrounds.
I do not want to
and
interrupt
academia.
Dr. Dahir. Is her real name Dahir?
Yes, Dr. B. Her name is Dr. Veronica Dahir. And we were talking about whether she needed to be like a superhero or a supervillain. Because I think that can go either way.
I'm going to say villain.
I don't know. Or we go like Gem and the Holograms, like singer villain. By singer. Yeah. I don't know. Anyway, we're all intrigued, but it's getting to the mind-numbing part of the hearing today because we've heard all this like 7 times today.
From different experts?
Uh-huh. Oh. Lots of academia today. Lots and lots of academia. So.
All right. Yeah. Glad to come over. Hi, everyone. Just quick.
Mm-hmm. Nobody's talked about teeth today, though. They did talk about Rampart, and they talked about a juror on a case in LA who forgot that she was in a movie about the case.
Well, I mean, what do you say about actors? And
I don't know where you're going with that.
Neither do I. I'm going to try and bow out gracefully.
I don't know. He's like, you know what they say about actors, folks. Bye. I I don't know what they say. It's good to see you.
Yeah.
I know it's been a long day. All right. Well, we'll text me about dinner.
Oh.
All right. Appreciate you.
Bye, chat. Good
I
seeing
know
everyone.
Travis is
Enjoy.
probably very hot today at band. So.
Oh, it was 101 when we got in the car.
Yeah, it was 100. It was 105 yesterday afternoon. All right, B. Anyway, I told him, chat said hi. All right, let's get back to court. Thanks all. Dr. B is like, I've had a long day. Back to court with from Dr. B to Dr. Dahir. Dr. B is more in the medical side of the field, less in the academic side of the field, but now is a combination of the both.
In both of my roles, I work with many organizations to do surveys. We do work for, besides the CDC that I mentioned, many state agencies, Nevada Department of Transportation, Department of Training and
they do surveys.
Department of Employment, Training and Rehabilitation.
Surveys.
I won't do all the acronyms. I won't do that to you, so because I can shoot off all the acronyms. But we work with the National Judicial College. They're right on campus. I'm in the building actually. National Council of Juvenile Family Court Judges. We've worked on projects with the Federal Judicial Center, the State Justice Institute, and many more organizations. I know you're going to ask me other questions, but I want to get those out. So,
I do have a couple of questions for you.
Dr.
You
B
said
was
30 years about of your life you spent doing this work.
Yes.
And it sounds like it has a whole lot to do with survey work.
Did you just say 30 years?
And is that both design?
Ma'am, you've been doing this work since you were 7. Okay. Okay. She's like, you've been doing this work for 30 years. She's like, yes. Then again, it breaks my brain that I've been a lawyer coming up on 20 years. Like that doesn't make sense to my head. So, I mean, I guess if she was working in this field in undergrad, it's a lot.
Surveys and then critiquing surveys.
Yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals.
We do this and this and this.
I personally published on different aspects of survey research in Judicature, Justice System Journal, Future of Evidence by the American Bar Association. I have a chapter in there. That was not specific to surveys, sorry. I have other publications, but specific to surveys, Survey Practice Journal, Law and Human Behavior on the judge survey that we had done. There are numerous. I don't know if I can remember them all right now, but in terms of technical reports, we do a lot of technical reports for our projects. And those are basically reports of findings that we give to our clients specifically to use for their organizations based on whatever topic it is that they want us to survey or study. So I mentioned some of them before. We DETR, which is Department of Employment, Training and Rehabilitation, Nevada Department of Transportation, Nevada Department of Corrections. I don't think I mentioned that one. And we've done 140 over my career there, 140 technical reports, all of which in some way or fashion have related to surveys or survey research. We do a lot of evaluation projects, needs assessments, and most of those always entail a survey of some kind.
Are there guidelines or standards that govern survey work?
There are. The last witness explained them.
Ones that have been mentioned here already. APOR, the American Association of Public Opinion Research, and specifically for change of venue surveys or community attitude surveys, ASTC, which is the American
really
Society
specialize
of Trial
on change of
Consulting.
venue motions and then
Are you familiar with the standards
litigation?
of both?
Yes, I'm a member of both organizations.
Okay. I want to know why people do surveys. It sounds like you've had a hand in a lot of surveys over the years. Why do people do surveys?
Many different reasons to find out information about a specific topic or population. People do it for needs assessments. They do it to find out more about support services. If they want to increase support services in their organization, or if they want to just find out an evaluation of what their program is, if they receive funding from a government organization or a grant to do a specific project, they want to get evaluated, and that usually entails surveys. People want to know community attitudes. For example, as I mentioned, a couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing
to
research.
See how people feel about
been asked to take many surveys about projects that not projects, but things you bought.
We want to know what people think.
That, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have got bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of
this is how we get info.
That reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization, and in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information. And that's in order to make a decision.
Yes, decision making,
yes.
And especially within the organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to the legislature for whoever our clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call Assembly Bill 122 in Nevada, where they were looking at the assisted living communities within the entire state of Nevada to see if there should be change in those areas. So those are some examples. And primarily, like, I guess a good example would be the behavioral health, BRSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes.
Ma'am,
so we ask questions like behavioral risk that's related to
what you're doing in nursing
how many
homes,
fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practices, substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Yes, I mentioned a couple of the examples that we have done community attitudes on. And that's basically measuring attitudes of the community on a specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted relating to vending issues?
Ma'am, were best practices followed here and how the surveys were conducted? Thanks. That's what she wants to get to.
Excuse me. I forgot. I have these. Okay. Exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
Okay. And I can see you just placed those face down. If you need to place them back face up, will you let me know?
Yeah, I will. Sorry. What was the question?
That's okay. I'm wondering if you had an opportunity to review the survey work done and conducted by Dr. Bryan.
She is speaking academia
and
grant
writing. Do you have an opinion about whether that survey was conducted in a valid way?
And the thing is, she seems immensely well qualified. Her work is something that she clearly loves. It is just the end of the day. We know it's repetitive. And I'm just like, it is okay. I love, great. The work you do sounds very interesting, but also as to the survey here, was it done right? In your opinion? Great. So brevity is what we need.
Yes, I do.
What is your?
In my opinion, it was a valid survey.
Great. What do you base that opinion on?
So there are
this is the purpose of her testimony.
Professional code of ethics that I mentioned earlier.
This is the peer reviewing
suggested by
in real time.
Again, AAPOR, American Association of Public Opinion Research, and the American Society of Trial Consulting, ASTC. And specifically, ASTC has a section on venue change surveys. And there are many things that could go into a survey to determine its validity and reliability. I guess I should talk about that before I go into that. When you're talking about scientific reliability, by the way, it's very different than evidentiary reliability. So evidentiary reliability is looking at the trustworthiness of evidence, whereas scientific reliability is looking at the consistency and repetition of a survey done over time, across different populations.
Can you tell us where everybody was
and
sitting
validity is more looking at
girls basketball
trustworthiness
game
or accuracy. So if we talk about reliability as consistency and stability of results, and validity as accuracy, that's how I'm going to talk about those things. And with respect specifically to this survey, there are many types of validity and many types of reliability, but I'm not going to go into all of them here.
Thank you.
I think specifically for this survey, what's important is content validity, construct validity, measurement reliability, and response reliability, specifically with this survey, and looking at coverage error and what we would call external validity. There are other types, as I mentioned. There's criterion validity, there's inter-rater reliability, retest reliability, convergent validity. There's many types of validity, but I'm not going to talk about those here. I'm just going to talk about the things that made me come to my opinion or form my opinion based on the survey.
Judge is trying so hard.
According to the ASTC standards, we're doing a change of venue or community attitude survey to look at whether or not a change of venue should be conducted, or a change of venue might be considered. You want to look at 6 things. You have screener questions, you have case recognition questions, you have questions related to the source or the media where the information comes from, you have demographic information, and then case knowledge questions. I think I got them all. And that's what I was looking at with respect to the content. And those were all there in Dr. Edelman's survey. The other thing I looked at was the questions themselves. Do they have what we would call construct validity, which is basically, does the survey measure what it purports to measure? And then does it have content validity? Does it cover all those things? And it does. I mentioned that already. That's the content validity, those 6 items. And was it done in a way that you can consider it? The measurement was reliable. And I would say yes. I read the methodology was brief, but based on what I could gather from the report that Research Strategies did, they did all of the things that we would have done. I would have probably done a little bit more in terms of...
the state is attacking the methodology. That's why we're here.
Looking at, some of the disposition codes were just a little bit hard to determine, but that's not that important for this. What I would say is that they did everything we do in our lab. We are very strict. I would say strict when it comes to our methodology for our surveys because we follow APOR, which is the strictest standards that you could follow for calling on a telephone survey, or what we call the RDD survey, random digit dialing. And primarily that's because we have to do this.
I know I chose 1.25, but when we start getting into academic acronyms, there is an acronym for everything. It is a totally different language, but I don't know if we need to retain all this info, so it's fine.
CDC survey, and the CDC survey follows the APOR guidelines. And so for all of our projects, whether it's VRFS tests, whether it's CDC or not, we follow the same protocol. So no matter what project we do, whether it be for NDOT or DEER or any of these other organizations that I mentioned, we definitely follow the same protocol procedures. And that includes things like good questionnaire construction and design. That's the first thing. In order to combat what we would call non-response bias, the first thing you look at is questionnaire design. Are the questions written in a way that would get the responses that you need? Do they have content validity? Are the questions valid? And by that I mean we look at things like question order. We look at the whether they're leading, whether they're loaded, whether they're double-barreled, whether there's many things we look at.
Loaded like a potato? And what do we mean in the academic sense by double-barreled?
So I looked at that. And then we also look at how the survey was sampled. And according to Research Strategies, they did use a random digit sampling frame. And by that means they probably, I don't have all the details. I'm just going based on my opinion, my experience. What we do for our surveys is we order our sample from a sampling company and we get replicates of phone numbers. And what that means is we get them in blocks of like 30, for example, and you would call your replicates of 30 phone numbers until completion. And that's to make sure that you are not biasing your sample. So you don't want to call, here's an example. If you get 20,000 phone numbers, you don't want to call all 20,000 phone numbers just once. That's not how it works. Because you're only getting those people that answer the phone on the first ring. So that's biasing. Also, you're reducing your response rate by doing that. So what we do is we call them in blocks of numbers and we call them several times. From my understanding, they called them 4 times. Research Strategies is they called once, if they get a hold of them, they call 3 more times, they get callbacks. That's also proper protocol. We like to call our surveys at least 3 times during 3 different time periods, either the morning, afternoon, and evening. We also like to call them during the day and on the weekends. My survey lab that I run is open 7 days a week, and every single holiday except for Christmas, Thanksgiving, and believe it or not, Super Bowl Sunday. It's the other American holiday, apparently.
Yeah, if you're calling people to survey them on Super Bowl Sunday, the responses aren't going to be well received.
Anyway, people get mad when you call them on Super Bowl Sunday versus Father's Day, Mother's Day, and Easter, believe it or not. But anyway, so we call these numbers at different times. And from what I could tell, they did follow-ups, they did different call timing, they did callbacks.
Judge is here for it. Judge is like,
both cell phone and landline.
Judge is like, so great.
It is customary practice now when you're looking at coverage validity, you want to get more you want to make sure you're getting the population that you're interested in. And now so many people have cell phones. So in our lab and most labs across the country now, we do like 90% cell phones versus 10% landline. Now it's customary because of the reduction in the number of people that have landlines. Anyway, those are some of the things that I looked at, and whether the questions themselves, like I said, were valid in terms of what they were being asked.
It sounds like you
answer the questions.
You had a really thorough look before you had your opinion as to whether the survey was valid.
Yes.
Do you have
Anne says, that was very thorough. The lawyer is subtly signaling that we can tighten up the answers just a little bit, but I definitely am not answering unknown numbers.
Opinion about whether it was reliable.
Yes, in terms of measurement reliability, which includes things like if you are an interviewer and you are asking questions, it could be biasing if you're not trained properly. And the mode of survey that you're doing for change of venue surveys, the typical mode is RDD surveys, which is phone surveys versus paper or in person. And so the interviewers must be trained and supervised. My understanding is that research strategy has been around for 20 plus years. So I'm assuming they're like our lab where they were trained properly and they have supervision where there's supervisors also supervising the interviewers. So that's another way to combat non-response bias, which includes refusal conversion training, which is, I think Dr. Edelman alluded to it earlier, things like stop refusals. If someone calls up and says, I'm making dinner, I'm too busy, I'm giving my kids a bath, I'm running to the store, whatever it is. We train the interviewers on how to handle those situations.
Refusal conversion training. This I'm going to use with my teen. He doesn't refuse much when I ask him to do chores around the house, but I would like some refusal conversion training as to how to convert my my youngest mostly into wanting to answer the dishwasher. Everything has a name. Everything has a name. It's to not getting hung up on. Refusal conversion training. Good.
And so that we don't get only the first person that answers the phone or only those people that are saying that they're busy. So that's all part of the training to make sure that we get at.
Also, to snark a little further, for those of you that followed the Jen Shaw case with me, I feel like the call center in the Jen Shaw telemarketing fraud case had excelled at the refusal conversion training. It's why the fraud was so successful.
Non-response.
Right. I think that you have answered my questions really well, and based on, just to sum it up, based on your look at the work done by Dr. Edelman, the survey,
and more.
Your opinion is that it's a valid survey.
Yes, basically, it's what I would have done or what we would have done in our survey lab.
Thank you. I don't have any other questions right now, but hang on, prosecutor.
It was done the way we would have done it. That's what she said. It was done. This survey was done the way we would have done it. This is
we
like
have for this witness, Your Honor.
The peer review.
Thank you.
No.
That was easy.
So easy.
She's like, that was easy. No cross-examination.
She may, Your Honor.
Okay. Thank you for being here. It's very interesting. Help yourself. Yeah, that's what you need. Thank you. Thanks.
She's taking some water with her. Thanks, ma'am. Your work is fascinating. It's just been a long
witnesses, Your Honor.
No more witnesses. Okay. Any witnesses?
None from the state, Your Honor.
Okay. We prepared for argument?
Yes.
Do it.
Okay.
Let's argue.
Thank you, Your Honor.
We're ready for argument. All right, chat. We are going to
Your
argument.
Honor, the decision to change.
Megalina, if you want to let the app know that we've moved to argument, some in the app might be like, oh, I'll come back now. Let's go. We are on to argument. The defense goes first and the prosecution. This is going to mirror what they've outlined in their briefs and the witnesses we've heard today. And Judge is like, let's get this done in a day, y'all. Let's get this done.
Venue rests on what you've heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is a huge amount of coverage. The kind of coverage is prejudicial coverage, and it's had an impact on the Latah County potential juror. The court can see actually of that survey. Reading the hundreds of comments from Lake Todd County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Lake Todd County. The court can also presume prejudice by looking at this case as it is. It's an in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Lake Todd County, it's bigger, it's a state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written.
I don't know why my internet was being spicy. Apologies, everybody. But we are sorry about that. So the weather's getting spicy. The feed is getting spicy. We will, well, on my end, but we will rock on through. So let's keep rocking in the free world. Let's go.
Shows have happened in this case. It just doesn't stop.
I'm putting on my backup internet.
And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items.
The note, Miguelina, the note I got on StreamYard was if this continues to be a problem, try switching to Chrome, which is interesting. So just to make a note of that, let's keep going.
Context explanation of what they mean. So you have this coverage that permeates the community, bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming.
Yep.
That doesn't
We knew she was going to argue tech.
The live stream is captured and replayed almost in real time, if not real time. Everything that happens in this case is on social media, and all kinds of things that don't happen in this case run rampant in news stories and social media stories and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helps train. It's all negative. It's false. It's misleading.
I don't know if anybody knows that dude has a dog because he's not spoken to the media. You've not spoken to the media because there's a gag order. I think she's arguing this because there's a gag order, but the prosecution was able to put out not evidence. The prosecution was able to put out information. The police were able to do press conferences. And the second he was arrested, there was a gag order. So yeah, those things aren't out in the media, but they really can't be. But yes, in some spaces on the internet, we still do remind everybody of the presumption of innocence. But I get that they are leaning into their argument about the clicks and views and the rest of it. I get it. That's their job.
Rumor and never coming into court. There are things about his character that are just untrue that are out there. When you have this much information surrounding a case, it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by TrueScope this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County is. So that's a lot of coverage directed into Latah County, and that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing this information. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. You understand that, we understand that learning from Dr. El-Alayli this morning, where she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudgment of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away. You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a schedule order.
I don't disagree with her on this.
And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings.
But that interest spike was happening in Ada County too. So we saw those spikes also in Ada County. So I don't know if it's spiking everywhere, and if there's interest around court hearings and there's going to be more court hearings and then there will be interest around trial. That's not different in the other county per the surveys that were done, though.
And that's a lot of media coverage, and people in Latah County are going to see it and read it, and they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition, and there's prejudgment in Idaho. But there's hope.
But you can't move
when
out
you
of
look
Idaho.
at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good, because that moves right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in the state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller.
That's a good argument.
Imagine with me that we are here in June of 2025, and we're here, and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them.
Jurors.
Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. You can't be sure that there's a way to pick an impartial jury in this community. In Ada County,
We don't have it. We don't have Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. There are people who don't have those connections. The other difference that I think is really important to think about too is the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider, but in the community about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the court. People in Ada County do not have. And why Ada? Why not Canyon, or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to Bannock County, I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem. So that's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Laytown. Canyon County is the second largest.
So she's open to other counties, but
Your Honor,
wants
honestly,
it to be
if the court says let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through the media. They would be kept private and in secret and secure.
Hi, Georgie.
It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures, and the right to a fair trial cannot happen in Laytown County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue needs to be changed.
Buddy, stop.
Thank you, Ms. Taylor. Ms. Adie?
Thank you, Your Honor.
George.
Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it.
On the defense's side,
the state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Laytown County, Ada County had significantly more coverage than Laytown County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Laytown County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Laytown County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor, I'd like to talk about what the numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit F1, Dr. Dahir. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with 400 survey respondents in a population within the range of our population.
So
in
all of those
County,
are within the margin of error.
Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert,
all of them,
and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County, 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon, 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County, 29%, Ada County.
This is why they didn't do cross-examination. They're like, right, those are the numbers. We're just going to use those numbers.
25%, Canyon County, 23%, and Bannock County, 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300 plus page document of all of the survey responses and look at these surveys and see that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims?
Or
things like that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing, as we approach trial, to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would...
I think using the numbers is the state's best argument here, arguing, look, the issues with how many people are aware of the case are not unique to Latah County. This is the same everywhere, and all of those numbers are within the margin of error. So these numbers could flip-flop. So they just want to move it to Boise. We need to ask better questionnaires. We're fine with, if people work at the university, not having them on the jury. There's still lots of people in the community that don't. So they're like, we are willing to work with you, but the defense's numbers show that this case is known about. So yes, there are some challenges to a high-profile case, but those challenges don't warrant the drastic remedy of moving this case 300 miles away. So
address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to...
If they do jury selection that way, it will take forever.
To do that, I think individual voir dire would be very appropriate, and the court has that option available to it.
Right. So she's saying there's remedies. The defense said there are no remedies. It has to move. The pressure within this community. The jurors are going to see people they see at the grocery store. They're going to see their kids like school resource officer or whatever. They know people in the community, and they are going to feel the community's vitriol and pressure. So they can't come to any verdict but guilty. This is the defense argument. They can't come to any conviction but guilty because the pressure is so high to come back with a guilty based on those statements they saw in the surveys. But she's saying, look, Your Honor, we voir dire around it. We do individual voir dire. There are other remedies. The defense said there are no other remedies. So that's what the judge is going to have to decide.
Possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete.
That starts to impede on other rights.
When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do. We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, where Bryan Kohberger had a difficult time convincing you that he is not guilty of murder. 19% said no, 16% said no opinion. You add those up, and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger? No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Canyon County. And
it's a fair argument, because she's saying we're going to need to pull like 1,800 jurors. We have enough people in Latah County to do that. So why does it matter if it's in Latah or if it's in Ada? Because the survey numbers are the same. So if the survey numbers are the same in Latah and Ada, then it doesn't get moved, because it's things being the same, it stays where it is.
Frankly, Your Honor, as we move toward the issue
the
of
defense has to prove they're not the same.
If anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more.
Your Honor, do you want to go live in Boise for the summer? Do you want your court reporter to? The bailiffs? Everybody?
Convenient options closer to Latah County, either Kootenai County or Nez Perce County, would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred.
She was going to call it the murder house. I heard murder house. But if you had to walk to the university that way, it's not that people chose to walk by the house. They just might have. They might have chosen, but they just might have had to because of where they live. So we'll see.
Or you were a family member, student, or employee at the University of Idaho in Moscow. 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it. But if the court were persuaded that Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County. Lewiston is approximately 30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that.
Within 30 minutes is not unreasonable.
Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodation that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County courthouse, in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job of that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they can accomplish that with careful planning and preparation over the many months between now and trial. It is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, council referenced the cost of transportation to and from the airport and correctly noted that the Spokane airport is considerably further from the Latah County Courthouse than the Boise airport is from the Ada County Courthouse. That's absolutely correct. However, the Lewiston airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial.
And we have to move everybody.
There's also a logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth. I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, a larger side, on the larger side for counties within this state, that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty. Ms. Taylor?
Thank you, Judge. And then rebuttal from the defense.
As I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood that it impacts the impartiality of the jury, that it impacts Mr. Kohberger from getting a fair trial? Don't think about county's members. Don't think about Canyon County's members, and don't think about Bannock County's members. Think about Latah County's members. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County. You know the jurors have been exposed to prejudicial media. You know that there's been an impact on you. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you can't.
But if there's nowhere to go in the
court
state, then
has
there's
to
no
decide
point.
what do we do. But answer the first question first. Answer the first question
So
first.
what do we do?
And don't be tempted to say, well, maybe we could go to Kootenai County. Maybe we could go to Nez Perce County. We don't have any surveys on them. We don't have any information on them, except we know that Dr. Edelman pulled a couple hundred stories from the Lewiston Tribune and looking at the local media coverage because of the closeness of Moscow and Lewiston. And except that we know that people in Lewiston have the same nightly news as those in Moscow. And by the way, so does Kootenai County. KXLY that broadcasts all the stories on their nightly news, that happens at my house, it happens at Mr. Thompson's house, and it happens to somebody who's from Lewiston too. That's the same news. The difference is the newspapers And the difference is the community connection and what that means in this case. So don't be tempted to go to another county we haven't surveyed. We've surveyed a lot of comparative counties. Stay in the place where your decision rests on what's going on here in Latah County. For sure, when we do get to jury trial, you should do individual court. For sure, we should do a jury questionnaire and we should talk amongst all of us and try to figure out if we can excuse some jurors before they're ever brought in. They should never be on camera. We should try to keep them as anonymous as we can. Those are all things that we absolutely must do.
Yep, it's going to take forever. I agree with that
To be
too.
the very most protective, we have to answer the first question.
Glad we're all
and that
agreement.
question is, we have to get this case out of Latah County. That's an important decision, and it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts planned. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first, and then think about where it's most reasonable to have a trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here. There is no way Mr. Kohberger can get a fair and impartial jury.
Well,
he's going to take it under submission.
Give you a decision now. Number one, I would say this is probably professionally the most difficult decision I've ever had to make.
The most difficult decision I've ever had to make.
Both sides. Okay.
He's not going to rule today. I'm going to just gain the volume up because he is quiet. He's not going to rule today.
Have made really solid positions and supported that. I know there are a lot of considerations, practical, in terms of logistics and prejudicial.
I slowed him back down to real
media. So I have some work to do. I'm going to go through everything. Okay, even if I got most of everything, but that's going to take me a little bit of time. And go through the law again, too, including the rule itself and the interpretation of that. So I'll do my best. It's a challenge. So that's probably all I should say at this point. But I listened carefully all day, and I thought
it was a long day.
There were some really important things to think about, both sides, and that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
He's like, all right, you've all given me a lot to think about. JJ out. So that is the end of today's hearing. I don't know if I'm even going to be able to summarize it. It was a ton of information. Some of it was fairly repetitive at points, but we're going to do a short summary. I'm going to do some questions, and I, after 7.5 hours, am tired. Christina, I'm going to answer your question first, though. Christina said, will they be back tomorrow? No. The hearing is done. The judge has taken it under submission. He will issue a written ruling later. And he said it's going to take me some time. So 3 weeks or more. If it was going to be less than 3 weeks, I don't think he would have said it's going to take me some time. He has ruled fairly slow in this case. So I would think 3-4 weeks is probably reasonable. I imagine we'll also get a Friday ruling on that. So end of September is when I'm going to really start wondering if we have a ruling. I'll be surprised if it comes in before then. I have cat glitter from George, who, is here for the substitute human. He's like, you'll do. But I think he just wanted to say hi to chat. I feel bad for anyone who's not watching the screen and listening and is like, why do I hear a cat? Is that my cat? What? and takes an earbud out and is like, what's happening? Why is there a cat in the room? It was George. It's rare these days, but it was George. Okay, let's do a very brief summary. Miguelina, I might record a separate one for Quick Bits on Monday, but let's do a quick summary now. After a all-day hearing, Judge, as I suspected, took the issue of change of venue under submission. The defense argued vigorously and presented witnesses asserting that Bryan Kohberger cannot receive a fair trial in Latah County. There has been too much prejudicial media coverage and cat hair. And because of that prejudicial media coverage, the jury pool is too tainted with that to find a fair jury, and therefore it has to move out of the county. The prosecution used the numbers from the defense against them and said, look, the numbers across all the counties they surveyed are similar. And the solution in that case is not to move it to another county. The solution in that case is to pull from a bigger jury pool. So pull in 1,800 people. There are over 32,000 jury-aged residents in Latah County. So out of 32,000 people under the defense's survey, we can pull in 1,800 to get a jury of 18 for this extensive trial. It does not need to move. And then they hit very heavily on the convenience prong. How much onerous effort it would take to move the entirety of this trial to another county for 3 months. It would be an extensive undertaking. So will the defense survey show that another county in Idaho is better for this case and that there is no hope to find an unbiased jury in Latah County? I don't know what the judge will decide to do with that. I think the numbers are incredibly close, much closer than I thought they would be, but there has been extreme media coverage. The media coverage has been biased, but can you find jurors who are not exposed to it, who, as Ann Taylor said, will go against sentiment in the community to follow the evidence? Or is the community sentiment of guilt so pervasive that the jurors, even if they're not persuaded, will have to vote guilty for fear of running into their neighbors at the grocery store and having all of their neighbors know that they were jurors and be like, how could you? So they went quite a long way with their witnesses to argue that there is absolutely no way Kohberger can have a fair trial. And everyone mentioned other cases that have changed venue recently in Idaho, the Vallow case. So Judge is going to take some time. He made it very clear that he was going to take his time to rule on this. So 3 weeks, 4 weeks maybe to rule. We will see a written order in the ruling and go from there. But the defense very clearly said, take the first thing first, give us the change of venue, and then we'll figure out what to do next. The judge might say there is nowhere to go. The change of venue is not appropriate. The remedy is pulling more jurors and doing individual voir dire and the rest of it. I'm going to answer a few questions, and then after a 7-hour day, we're going to bounce. All right. So with all of that, we've got some questions. Carrie said, can you please say what the calendar of hearings coverage and trial coverage that's coming up for the rest of the year will be? What's on the docket? Thanks so much. I did not pull it up. We are looking at putting some of that into the app, but all of it is subject to change. So next really on my list for trial coverage would be Donna Edelson, unless it moves. It doesn't look like it's going to move, but that looks like our next trial. So that will be kind of next up on the docket. Other things are very, very subject to movement. Thank you, J. Michael. I hope you got some rest before your shift this evening. Cheryl Ray said, Emily, is even a whiff of higher bias enough to move it? No, a whiff is not going to be enough. It's going to have to show that there is no way that Kohberger can get a fair trial, but the standard is fairly low on that. So the standard is below like 50-50, and it's the defense burden to prove that the jury has been impacted by biased media coverage. George, really? Sir, okay. Sir, can we? All right. George is like, no, we're gonna do this. We're going to do this. Let's see. Just because said, I'm sorry. I believe Alec Baldwin was guilty of everything he was charged with, but I know that the state had a burden to prove he was legally. And yes, some people can say, did you prove it? Did you not prove it? What my gut feeling is not enough. But the defense in this case leaned in to some of those statements that were made on the phone survey. And some of those statements were things like, if he's acquitted, then we'll just burn the courthouse down. It was very hyperbolic and dramatic and violent. But that is a sampling of the most extreme reactions to show this is sentiment. Is the sentiment of one person the sentiment of the county? I don't know. We're going to see. Let's continue on. Wait, what? Red Solo Cup. Wait, what said, for me, it's the community pressure that is key. I keep thinking of the Canton community and how much it impacted Karen Reed. The community pressure is a fair argument, but they're also saying there are over 32,000 people in this community. So maybe you don't pull jurors that live, and they can do that on the jury rolls. Hey, we're not pulling any jurors that live within 5 miles of the crime scene. We're going to go out further than that. There are things they can do to work around that. Jeno said, would the judge go too? Yes. If the trial moves, the judge would go. Most of the court staff would go. The prosecutors would go. The defense attorneys would go. The witnesses would go. Law enforcement would go. Everybody would move. So there is that. Let's see. Oh, Georgie. Lori NCT said, I once adopted a 3-year-old cat and I had him 7 months. Moving him from the shelter activated a latent virus. Oh no. I'm sorry, Lori. That is no good. Emily said 32,000 is still so small in terms of modern day. I don't know. I think it depends on the state. There are some states in the US that have much lower populations and are much more spread out. So when she's saying in Idaho, this is in the middle. She's saying for this state, this is not a tiny county. This is a county that is in the middle. Really, it's 11 out of however many. So it's in the middle of population size. So it's all really relative to the state. I don't have any. My brain is beginning to stop at this point. Kiwi said streaming with cats is hazardous. It's always an adventure streaming with cats. Then again, the county I lived in was very large, but the town that we lived in before we moved was 16,000. It did feel like a small town. This is double that. So it's going to feel like a small town, but also if it is dispersed by landmass, depending on the size of the county, you can get people that aren't as intricately connected. But then again, in smaller towns, you're going to get somebody who's like, oh yeah, I'm the chief of the volunteer fire department and like the community resource manager and like the principal of the high school and. So it really just depends. But the judge is actually in a good position to determine that. You can't, if you put the cat hair on what I'm using to get the cat hair off, George, it's not going to work for either of us. So, well, he's like, it works for me. The cat hair is mine. So it's really, the judge is in a good position to determine it because he's there. But the defense, I think, made a fair argument saying, Your Honor, you're going to see these jurors around town. How do we do this? It's a large case. It's a serious crime. It's a death penalty case. It's a quadruple homicide. That it's a 3-month trial. It's going to be a lot, but they also said it's not a burden to the community and we have a right to have the trial here. So we will see what they decide to do. Let's see. Brandy Rose, I don't know yet. I know that there was breaking news on this yesterday. With the amount of streaming we've done this week, I have not taken a dive into all of that news. I've had a lot of you ask. I have not looked into it enough to give you an answer on that. So thank you for letting me know your interest. I know a lot of you have told me that you're interested. I don't know. So I will I will not make a decision on that until I have more information, and I will not process information until my brain's not so tired. So my brain is tired. Smurf Anna said, I know the defense carries the burden since it's their motion, but what is the burden they have to prove? Is there a level? I grabbed this much earlier because we went over it much earlier, and then I wrote it down and closed it, but it's below 50-50. It is reasonable belief. Well, reasonable. There is a, hold on. I'm going to pull the exact words because my brain, this is when we know we're done. Reasonable likelihood. Reasonable likelihood, which is lower than more likely than not. So it's a fairly low standard that the defense has to prove. And that's probably what the judge wants to go look at is that standard, because that standard is low. FLKC said, my husband was called for jury duty in the Parkland trial. He wasn't selected, but he had to go in every Thursday for months for voir dire. They found a jury. I remember that in Florida. Yes, they found the jury and the jury did not recommend that. Yes. Because that case, the jury was only doing sentencing. They were only pulling the jury in for sentencing. Let's see. Tracy says, this is ridiculous. In the year of our Lord 2024, I'm like, the thing you need to do, and then my internet freezes. It's probably because of the length of the stream. It's probably not my internet. Remember, it is also a process. So take notes, speak up. Things have to be titrated, and good luck. And yes, it is a nice thing because the brain sometimes needs a little bit of support, and there's nothing wrong with that with all of our neurospiciness. But I don't think that is, Megalina, that is not the internet, because I've speed tested. Internet is good. I think we're buffering due to the length of the stream, and the computer is not overclocked. So that said, though, I do not want it to be a terrible rewatch experience for the replay crew. Y'all have the app. Y'all have been here all day. It is a long day. I'm tired. You're tired. I've got recording to do tomorrow. I have recording to do tomorrow. We've got new quick bits for you. It is Labor Day weekend, but there will be quick bits out on the podcast and on the quick bits channel on Monday. I will keep you in the loop on the app. Law Nerds, you're the best. I'm sorry that we kept freezing at the end of this. I think the buffering is not on our end. And I will talk to you soon. Thank you for being here. Thank you for being a Law Nerd. I know you're tired. I'm tired. See you guys soon. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.